Can I make sure someone can hear me?
We can hear and see you just fine, Vicky. You're good.
Okay, great.
No worries. Welcome. Good morning.
Good morning. Oh, and I got everything this morning. It was there at the door at 6 o'clock.
All right.
Thank
Woohoo.
you.
No problem.
Good morning, everyone. Welcome to day one of the Board of Registered Nursing Board meeting. Good morning, everyone. Thank you for coming and welcome to day one of the Board of Registered Nursing Board meeting. It is February 26th, 2025, and we will begin by taking roll call to establish a quorum. My name is Dolores Trujillo. I was appointed by Governor Newsom to fulfill the direct care provider role, and I am the current president of the board. Vice President Neelu Patel.
Good morning, everyone, and welcome. My name is Neelu Patel, and I am the board vice president, and I was appointed by Governor Newsom for the advanced practice role.
Thank you. Board Member Jovita Dominguez.
Good morning, Jovita Dominguez, appointed by Governor Newsom in the Education and Licensing, chairing it.
Thank you. Board Member Patricia Nguyen.
Good morning, everyone. Tricia Nguyen, appointed by Governor Newsom in the public member role.
Thank you. Board Member David Lawler.
Good morning, David Lawler, also appointed by Governor Newsom in the public member role.
Thank you. Board Member Vicki Granowitz.
Vicki Granowitz, board member in the public role. I was appointed by then Senator Pro Tem Tony Atkins.
Thank you. Board Member Allison Cormack.
Good morning. My name is Allison Cormack. I serve as a member of the public, and I was appointed by the Speaker of the Assembly.
Thank you. And our Executive Officer, Loretta Melby.
Hello, I'm Loretta Melby, or Lori, and I'm the board's executive officer appointed by the board.
Thank you. And our Board Counsel, Reza Pejjuhesh.
Good morning, everyone. Reza Pejjuhesh, Board Legal Counsel.
Thank you. Our board has established quorum. We will move on to the next item in the agenda. This is item 2.0. This is general instructions for the format of a teleconference call. BRN moderator, please take it from here.
Good morning. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the board reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then proceed to the next member of the public who has a comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. When your turn comes, you will be prompted to unmute. If your question can be answered, the board will respond accordingly. When making your comment, please speak about anything you believe is important for the members to know. Remember, board members cannot address any item not on the agenda. Items not on the agenda at that moment, items that you would like to add to future meetings, or items that will be discussed later on the agenda will be discussed at their correct times during the meeting. I will provide a brief reminder of this approach at the start of each public comment item. I will also query our in-person public location to see if there are any public comments there. Finally, when board or BRN staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will mute your microphone automatically.
Thank you. Item 3.0, we will open up for public comment for items not on the agenda.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Matthew A. would like to make a comment. 1 second, please. Go ahead, Matthew.
Good morning. Can everyone hear me?
Yes, sir.
Good morning. Over the last year, the BRN has repeatedly and publicly been touting all the quote unquote changes it's making to its intervention and diversion program, including more transparency. Unfortunately, what's said publicly is completely different than what's happening behind closed doors. I'm here today to inform the diversion participants and the board members of the BRN's refusal to notify participants about the disclosure of their confidential information. In May 2024, I submitted a public records request regarding documents related to the intervention program. I want to again repeat that this is a public records request that anyone can make, be it a reporter, a barista, a gardener, a stalker, any Joe Schmo. In October, the BRN informed me that there was a delay in producing the documents because it was reviewing the documents to, quote, in order to avoid disclosure of confidential information pursuant to Business and Professions Code, end quote. Right before Christmas, the BRN produced to me hundreds of pages of completely unredacted information containing participant names, their conversations with Maximus and the BRN, and other sensitive and statutorily confidential information. As admitted by the BRN's October email to me, this information is quote unquote confidential information pursuant to the Business and Professions Code, end quote. The same day that I received the information, I immediately informed the BRN of this unredacted information and asked whether it would notify participants about the release of their confidential information. This was over 2 months ago. Rather than owning up to their mistake, the BRN tried to hide their mistake, just as it has done with the intervention program over the last year and a half. Instead of notifying participants, the BRN did what it does best in this situation, tried to threaten my license by quote unquote reminding me of my obligation as an attorney to keep the information confidential. Unfortunately for the BRN, it has no authority over my license. I have not and will not disclose the confidential information because unlike the BRN, I respect the intervention participants' confidential information and abide by the law. This also raises a question. If these documents were produced to me completely unredacted, how many other public records requests has the BRN sent out containing the confidential information that they're not telling participants about? The BRN's response to this question, trust us, we didn't. Well, I don't trust them, and neither should you, since they clearly refused to notify participants that their information was released. Lastly, if anybody wants to know what the BRN staff really thinks about diversion participants, I would recommend you request their Microsoft Teams chat logs during these meeting days. Since the BRN refuses to tell participants their confidential information was released, if anybody would like to know whether their name was publicly disclosed, you can contact my law office at 619-786-4992. Thank you.
Thank you for your comment. Paradise would like to make a comment.
Before we move on, moderator, this is Reza, board counsel. If I could take a moment and just respond to that. Those were some pretty strong statements just made. I'm in contact with that individual. He's made his public records request months ago. I find it incredibly unfortunate and disheartening the way he's tried to portray it as an intentional attempt to hide anything. Additionally, the accusation that the board has disclosed confidential information and tried to hide that also is incredibly disheartening to me. It's I'll say it now, it's a spin on what actually occurred. This individual, I won't identify him, made a PRA request during my leave of absence. My substitute counsel assisted him with that PRA request. There was an inadvertent failure to redact the records. Some of the records, I believe some of them were redacted, but some information did end up in the hands of this individual who made the request, who happens to be an attorney and who happens to have fiduciary duties to not disclose information that was provided to him inadvertently. So the efforts to just remind him of that obligation was not a threat, and I'm shocked that he took it as such. He never spoke back to us as if he felt threatened or intimidated. Here, he's portraying it as a threat against his license. It was really an effort to retain the confidentiality of the information that should not have gone out. As far as issuing a disclosure notice, I've been in the process since, I will say to his credit, he did return the records that were provided to him promptly as he was requested to do. We are appreciative of that and gracious. Meanwhile, since then, I've been attempting to, since I've returned from my leave, reviewing the records, providing them to him in batches with appropriate redactions being made. So we are doing our best to fulfill this public records request, which, by the way, covers thousands and thousands of pages and requires a review to ensure that no confidential or privileged information goes out. This is a routine process. He's getting the records that he asked for in batches. He hasn't. I find it incredibly sad. I'm shocked here the way that this comment has come about. He didn't reach out to me prior to say that he felt threatened or say that we were hiding information or to discuss the issue of disclosure notice. He asked me if we were going to be providing a disclosure notice prior to me having gone through the records, and I told him I would be looking at the records, identifying what was actually disclosed, as well as researching the duty to provide a notice. He never followed up, so I don't know where he even thinks we stand on that, or that's all I'm going to say on that. I'm not going to go much further, but a lot of what you just heard, at least from my perspective, there's a second side to it, which it's the board doing what it's supposed to do, responding to this enormous PRA request. And I understand there's a lot of tension with it being regarding the intervention program and, you know, some of the changes that him and his clients would like to see not occurring as quickly as they'd like to see. I understand the tension there, but it's frankly not what you just heard. So to that individual, I invite you to reach out to me. I told you that I'm back in the office and I have an open door, and I'm open to speak to you if you actually have concerns that you'd like to address rather than blasting them out in public comment. That's all. With that, unless there's any questions or comments from the board moderator, you can go to the next comment.
Thank you. Paradise would like to make a comment. 1 second, please.
Rule since 2020 is that anyone with a dismissed charge or expunged conviction and/or a misdemeanor conviction older than 7 years at the time of the submitted application for licensure will not have any action taken against them by the board. However, those of us who met this criteria before the current rule are still dealing with the quote-unquote indefinite online Breeze and Nursey's public record of our dismissed charges, expunged convictions years after being placed on nursing probation for it. In my case, these charges convictions are 20 years old when I was a literal teenager, long before I ever dreamed of becoming a nurse. As a result, for years I have been and continue to be denied higher education and job opportunities in a safe working environment, despite having graduated nursing school summa cum laude and having a spotless nursing record for almost 10 years, the entirety of my nursing career. I would like to put this on the next agenda to see if we can also apply the current standard to old cases and thus have these probation documents removed from our Nursey's public record. Thank you.
This is on today's agenda, and it is up for discussion today. So I ask that you stay on this morning and participate in that conversation. Thank you.
What item is that, Lori, just so we can narrow it down for her? We have a different. I'm just trying to get the agenda item number for her. Is it? Okay, 5.5.
Thank you.
Thank you for your comment. BJH would like to make a comment. 1 second, please.
This has been brought up before, and I wanted to see if and I have not seen it on an agenda, so I'm hoping that maybe it can make it on an agenda. I just wanted to know if the board could address the rule regarding the required distance to travel, that participants in the intervention program, and I don't know about probation program, need to travel for testing. I believe the rule is 50 miles. I think everyone in the program believes that is excessive and unreasonable. And I'd also like to point out that 50 miles does not equal 50 minutes. If you live in a rural area or even a metropolitan area, I live in a rural area, 50 miles is probably more like over an hour for me. I'd also like to point out that Vault's mapping system does not pull from your address. It pulls from my centralized zip code, which is likely town center. I live 15 miles outside of town center, so my closest testing site per Vault is 36 miles away, but it's 51 miles for me. And because I am so rural, it takes me an hour to get to my closest testing site. But technically that's following the rule of under 50 miles per Vault's mapping system. And, I don't have a testing site where I work either in the town I work at. So days that I have to work, I'm 2 hours late for work to be able to test. And that comes out of my lunch hour as well. I have to stay after work late in order to make up the time. I'm traveling in March to a different state, and on the weekend, the closest testing site is across another state lines. It is 42 miles away, and I'm not going to have a car. It's going to be $180 Uber if I have to test on that weekend. So I just am hoping the board can take a look at that rule, see if maybe there can be an adjustment, maybe 30 miles, and also include a time limit, 30 miles or 30 minutes, something like that, because what we have now is not reasonable for the participants. Thank you.
Thank you for your comment. Sarani Harkwan would like to make a comment. 1 second, please.
Sarani Harkwan, nurse practitioner, and also with the California Association for Nurse Practitioners. One thing that hasn't been on the agenda and I'd like to see added is the incorrect language that remains on the board website regarding nurse practitioner attestation, specifically post enactment of Senate Bill 1451. So I had several discussions with the leadership team of CANP, who had been in discussions with the BRN, asking us to notify nurse practitioners with legacy certifications wanting to apply for the 103 certification to wait. So January 1st, the BRN told us that the website would not be prepared, but we are now well past that deadline and approaching March, and the language in the portal of the BRN for attestation remains incorrect. So I continue to get emails. I happen to do the Ask a Practice question for the state of California for California Association for Nurse Practitioners. And I continue to get multiple emails every week from nurse practitioners and employers struggling to understand why the language hasn't changed on the BRN site. I'm happy to be available to discuss this when the board puts it on the agenda. And thank you for your time.
Sarani, if you can reach out to me with that specific information, I'll follow up. We did a release in February that was supposed to correct that. And if you are noticing on the public side that that is not corrected, if you can send me screenshots or send me an email, I will flip that over to the Office of Information Services so that we can get that corrected. But that was a release in February. We do releases with DCA every 5 weeks. We did not meet the January release, which is why we asked to delay to the February before we would send out that release. And so that release did go live. If you are hearing it and still seeing this after our February release, I would love to get some screenshots so I could flip that over to DCA and we can get that corrected, knowing that it will take another 5 weeks for that release to be done, but we will get that done. But that is the process of the way that we do IT fixes here in combination with all of the boards and bureaus. It is on an every 5-week schedule.
Thank you for your comment. Lori NP would like to make a comment. 1 second, please. Lori NP, if you're on a computer, a small window opens up, probably behind windows that you have open, that says unmute me. There you go. Lori, we can't hear you if you're speaking. You're unmuted though. Oh, she changed her mind. Okay, thank you. Thank you, Lori. Board President Trujillo, there are no other public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
No, we don't. We don't appear to have any requests for comments here.
Thank you. Would you like me to close this window?
Yes, thank you. Okay, moving on in the agenda, this is item 4.0. This is the review and possible action approval of prior meeting minutes. This is for meeting minutes from November 20th to 21st, 2024. Any questions or comments from the board members? No? Yes?
I'm willing to make a motion.
Okay.
I'd like to move that we approve the minutes from the November 20th and 21st, 2024 meeting.
I'll second. This is Cormac.
Thank you. BRN moderator, please open this up for public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
No, it doesn't appear we have any requests for comments here.
Thank you. Would
Thank
you like
you.
me to close this window?
Yes, please. Okay, we have a motion and a second on the floor. We'll take it to a vote. Dolores Trujillo votes yes. Vice President Nilo Patel.
Patel, yes.
Board Member Jovita Dominguez.
Jovita Dominguez, yes.
Board Member Patricia Nguyen.
Win, yes.
Board Member David Lawler.
Lawler, yes.
Board Member Vicky Granowitz.
Granowitz, yes.
Board Member Allison Cormac.
Cormac, yes.
All right, thank you. We're moving on to item 5.0. This is a report of the Administrative Committee. Lori?
Sorry, I've got a delay in my materials here. Sorry about that. Okay, so agenda item, 5.1 is the executive officer report. As you can see on the agenda item summary, beginning on page 4 of the materials, that the majority of the report is found on other sections. We have the strategic plan update in 5.2, budget update and personnel in 5.3, regulations update 6.1, et cetera. So what I will be covering as part of my specific report out here, is that what I have been doing in meeting between the last board meeting and today's board meeting. So I have held meetings with California Hospital Association, IACA, to discuss apprenticeship programs, Premier to work on implementing and updating our intervention program, DCA task force on med spas and IV hydration. We are also looking at expanding that to other topics. Meeting with NCSBN, meeting with SEIU, meeting with WICHE, which is Healthcare Workforce in the West, meeting with the Bureau of Private Post-Secondary Education, as well as the Board of Vocational Nurse and Psychiatric Technicians. I have met with CANA, which is the California Association for Nurse Anesthetists, Senate B&P, presidents of colleges and universities, LAO, which is the Legislative Analysis Office, Secretary Moss. We've met with Horn, which is a company that came in last year and worked with our licensing team. I have met with the North consortiums around grant support. I've met with the Clinical Placement Network and Academic Practice Consortia. I presented at HOAC Grand Rounds, which is the Health Officers Association of California. I've attended the DCA's Directors Quarterly. I did meet with CSUs and UCs on a workforce. I've met and presented with the COADN, which is the Associate Degree Nursing Programs. And I met with LWDA, which is Cal HHS. It's the monthly cross-committee agency workforce for training and such throughout the state. And then I will be traveling next week, I believe, or the week after, with our board president to the National Council of State Boards of Nursing mid-year meeting immediately following my presentation at the COADN meeting being held in Monterey. Any questions? Okay. Open.
BRN moderator, please open this up for public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
It doesn't appear that we have any requests for comment here.
Thank you. Would you like me to close this window?
Yes, please.
That is an information-only item, so we'll go on to agenda item 5.2, and that is updates on the progress towards the goals identified for the strategic plan that was implemented in 2022 that will be actually wrapping up in 2025. So we'll be starting our next strategic plan process in the near future. When you start on page 7 of the agenda item, you can go to the areas that are highlighted in yellow. Those highlighted areas in yellow begin on page 11 that go towards kind of letting you guys know the new things that were added to this document so that you can see what the process was and what we did toward meeting each one of those. The first one to discuss is that we initiated the development of a reg package for CRNAs and CNSs to streamline and codify the application process. Currently, the APRN application that is in regulations is the nurse practitioner and the nurse practitioner furnishing and temporary license. So we are now working with the CNS Advisory Committee as well as the CRNA Advisory Committee to work on getting those applications in regulations. We do have a CRNA reg package that will be with DCA regulation team to start that review process soon. If you go to page 11, the bottom of that, that is where we kind of discuss Horn again. I brought that company up in my EO report. We did complete the internal review process to evaluate out-of-state licensing by examination, and that has been completed. They are now off-site, and we will be receiving a report soon from them. We go to page 13. It brings up some ongoing activities. And right there, we are collaborating with DCA to contract with a LiveScan vendor for fingerprint services for out-of-state applications. The reason that that is incredibly important is we have two processes for fingerprints. The first one is if you are located in the state of California, the Department of Justice allows you to go to a LiveScan vendor. We can get those results as fast as 3 days. Typically, it's around 2 to 3 weeks, depending on DOJ's workload, and that does get DOJ and FPI results. So we always recommend that even if you're coming in from out of state to take an interview or to look for apartments or anything like that prior to coming in and actually getting your license here, we ask you to stop by a LiveScan vendor and complete it in state. If you do not complete this process in state, DOJ does not accept LiveScan from any out-of-state contracted LiveScan company. So you have to manually roll your fingerprints at that point with a hard card process. So that means you pay an additional fee to DOJ. We collect that and pass that on. And you reach out to us, you ask for a hard card, we mail it to you from USPS. That may take a couple weeks for you to get. You go to a physical location, you roll your fingerprints, you mail that back into us. It comes through our DCA mailroom, then goes to the BRN mailroom, and then we process it, look to see if it's complete, and then send it over to the Department of Justice before they even can start the process to look at it. So we don't like that process. It is not conducive to being a quick process. It does delay that. So we are looking with DCA on getting a vendor that will manage that out-of-state hard card process. And that out-of-state hard card process would then leave BRN completely. And we are told that they take the hard card forms and they scan it into a LiveScan system in California, which then allows it to have that electronic processing, which we definitely support. So we are working with that. We hope to move through that in the next calendar year if we can secure a contract and that does work out as promised. So hope on the horizon for that. If you go down to page 15, again, it does discuss that Horn did complete the review of the BRN overall licensing process. And one of those recommendations that came through Horn was a concierge service to assist applicants to complete the application process. That process is in place now. And when an applicant submits an application that is not complete, we review that application, we deem that is not complete, and we now do telephone and email reach outs to the applicant to try to let them know what they are missing and get a plan on receiving those items. Complete applications do not get that concierge service because when they are completed, they are processed and an application or a license is issued. So we are now calling in because we do receive a lot of applications that are not complete applications, and therefore when they're not complete, we have to issue deficiencies and they go into a separate bucket and they can take a while to be processed again. Yes.
I think this is really great in terms of addressing delays in licensing. Could you tell me how long it might take for us to notice that someone has filed an incomplete application? I mean, I'm sure so much of it is automated, but like what would be a flag and how long might that take?
Within about 2 weeks is when we do our initial review process of an application received. What is typically missing are fingerprints. And that's just a process we have to wait to catch up with, especially if it's with the hard card, because those are the out-of-state endorsement apps in, and transcripts. And so our board did vote a year ago, I believe, to go to an electronic transcript system. We do have contracts with Parchment and Clearinghouse, which are the two number one transcript systems in California. They do send those to us. We do review those. But a lot of times, because of the way that our law is written, we have to ask for transcripts of their general education pre-nursing courses. And that's your micro, your anatomy, your psychology, sociology, et cetera. And a lot of applicants do not understand that that is an additional transcript that needs to be submitted if they took that at like a community college or a prior degree that they had and they only are submitting their nursing transcripts. So we are required to submit those. So a lot of times the applicants are received without those transcripts. And so we reach out and say, hey, we're missing your micro transcript. Can you please get that and submit that? Then that is back in the licensees or applicants, hands, and that could take weeks. And so that you'll notice a delay in processing based on how long it takes that applicant to get that information and resubmit it. And then that goes through another kind of process internally again, where we have to receive it. We have to then sign it out. It then has to be re-reviewed, et cetera. And so it is a lengthy process when we do not receive an application that's complete. So we'll move down to page 18. It does say partnering with DCA's legal division and the Office of Attorney General on subpoena enforcement efforts. What we are finding out is when we're in investigations, we have subpoena authority that is granted to me through the Department of Consumer Affairs Director Kirkmeyer. We issue those subpoenas and not everybody responds to them. And so we are waiting for documents, waiting for investigative materials, and it goes into a process where it kind of lengthens the investigation process. And so we do review those. We are looking at how to track those better, and we're working with the Attorney General as well as DCA Legal to kind of work with the more common players that do not necessarily respond to our subpoenas in a timely manner. And so we are working on expediting that process through. Going quickly, sorry. Page 26 covers an update to the board action letters. It is an updated process implemented with data available on the board's website. So during our education licensing committee, we cover a lot of education-based issues, and we issue board actions on those issues. Previously, that was an email or a letter that was sent out through USPS to each one of the program directors, and that is where it kind of ended. Now, every board action is on our website for the past almost a year now. And it has the Education Licensing Committee meeting where it was discussed what the agenda item was. You could link to the exact conversation that occurred. It has the board action letter that came from that, the board meeting where the vote took place, and you can go back and look at it for all schools. And you can sort that. And so it's an amazing kind of data bank now that anybody can see, especially if you have schools that are doing fantastic. They'll have that in there, that they have continuing approval. If you have schools that are running into any issues where they're struggling with meeting our rules and regulations, that's also in there too, and is now public for anybody to see and listen to the discussions. Page 29 says that we developed and executed the information plans for bills that were signed into law. That did include the updated nurse practitioner bill that was discussed in public comment. That plan was to have that fixed and released in the February release. We will follow up on that. But the rest have gone through. I haven't heard any complaints, so I'm assuming that those are complete. Page 32, we're talking about some draft proposed text, and that will be covered here as well later on, where SB 1451 is the bill that Sarani was referencing in public comment. We do have to do some regulatory updates for that. That regulatory language has been written. It has been reviewed by DCA Regulatory Council, and we are bringing it to the board for approval today to move through that process. Page 33, sorry, kind of just really goes through some more things that we've done where we did participate in DCA's career fair for the general public. We did an all staff meeting in December, and we did issue our winter 2025 BRN report. And page 36, there was a presentation that you guys did receive in our last board meeting in November that is covered and captured on here. And as well as the social media materials on page 38, where we partner partnered with PCA to issue several materials regarding the LA County wildfires and offer assistance that way. Any questions on our strategic plan update? Yes, Allison.
Thank you so much, EO Melby. I'm in the 2 years, almost 2 years I've been on this board. This report has improved so much, and I appreciate your whole staff working on it. I think it's gone from a recitation of all the things that we've been assigned over the past X number of years to like, here's what's changed and here's what we're meeting. So I just want to take a moment to start with that. That's really obvious and important. I guess one place that we haven't talked about very much is continuing education. And usually when the board talks about it, it's in the role of, legislative, I'll say requests as opposed to requirements. And I see that for a number of years, we've been thinking, well, maybe we should just take a look at the quality of the continuing education classes. Is that what the audit's about? Any thoughts on that? I realize it's not as much of a crisis as other things, but it's just one of the few areas where you haven't already made excellent progress.
Yes, and so I'll give some background on that continuing education. So in 2018, I believe, we got a budget change proposal that established a continuing education and research unit. The design of that unit was ineffective, and we were not able to implement that when that was done. So we have had to do an organizational chart change and get different supervision in that unit. We were not able to hire a supervising nursing education consultant. We can barely get a nursing education consultant in that. And those are the people that review all the content for continuing education, because continuing education is required to be content that is above what is required for general nursing licensure. And so you have to have a nurse that does that. We have a retired annuitant right now that is working in that position as an NEC, which is doing all of our new continuing education application reviews. For about a year, I was doing that, double dipping, because we didn't have somebody in there. We did get a retired annuitant that was there for about 6 months. She retired officially. And I took back over that position for about 6 months as we then went and hired another RA. And so what we don't have is permanent staff in that unit. That is a very difficult to fill position. So we, in the reorg, we looked at hiring a staff service manager 2 or a 1 into that role so that it would be easier to hire state employee. That would allow for still just one nursing education consultant to do that review of the course content and not the procedural content. We were at the point where we were getting that through the Office of Human Resources and getting that process approved when we got hit with a budget cut and we lost 19 positions. Of those 19 positions, many of them came from that unit. And so we have began, as you can see on the strategic plan, some mapping. There is some processes being built to support that, but we are not there yet. And so that is an area that, although it is very important, it is so important that in 2019 and in 2020, we issued reports to the legislator saying how we were going to address that. And so that is not off my radar. We are still definitely working towards that, but we have to get staff in to do that. And right now I do not have staff to do that. We did, with the legislative update from last year that included a nurse practitioner specific CEU audit. With that, we did get approved for a legislative BCP, that is a budget change proposal, where we were granted a position as well. And there will be a hearing for that either the 1st of April or the 1st of May that we will be attending, hoping that we do get that position, and that will help us again just continue to work towards that process of implementing that review for our providers. We are still doing the audits on our RNs. That has not stopped. We do complete a percentage of that as a kind of a spot check throughout the year, but we have not implemented the provider audit of every 5 years.
Thanks for your comprehensive answer.
Any other questions or comments from board members on the strategic plan? David?
Just as a compliment, the ongoing activities is an overwhelming list of pages, and I just compliment you for the progress you're making throughout each category. So thank you for that report.
Thank you, David.
Neela Patel?
Lori, can you give us a little bit of an idea of what is happening with the survey regarding this strategic plan and when we anticipate getting information from that survey?
I had a note passed to me on BMOs, which are our Breeze releases. Can you repeat the question?
Sure. It's regarding the survey that went out to the BRN members or RNs basically around the state and just when we will get information from the survey.
So that is with the new strategic plan. And so we do have that scheduled where we will be meeting and we'll hear all about that. I don't have a specific date, but I actually know there was some conversation about that even this morning. It says it closed on January 31st, 2025. I just received it in my email this morning, and we will have a meeting to discuss that moving forward. Yes. And for those that may not have heard that, that was our Assistant Executive Officer explaining the process of the strategic plan and that we have a meeting coming up in April.
Any other questions or comments from board members? BRN moderator, can you take us to public comment, please?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in person in your location?
There doesn't appear to be any requests for comment here.
Thank you. Would you like me to close this window?
Yes, thank you.
Board moderator, can you elevate Suzanne and Luke for the next presentations for 5.3.1? And then at this time, if you can do a mic and video check with them as well. And our board president has asked for a break, so I'll turn it over to her.
So at this time, we'll take a 10-minute break and return back at 10:05.
Suzanne, Luke, would you guys like to test?
Yes. Hi, can you hear me?
I can see you and I can hear you. Oh, there you are, Luke. I see you too. Thank you.
Good morning, everyone. We are back from our break. We will take roll call to establish that we still have a quorum. Hello, everyone. We're back from our break. We will take a roll call to establish that we are still within quorum. Vice President Neelu Patel,
Patel here.
Board Member Jovita Dominguez,
Dominguez here.
Board Member Patricia Nguyen,
Win here.
Board Member David Lawler,
Lawler here.
Board Member Vicky Granowitz,
Granowitz here.
Board Member Allison Cormack,
Cormac here.
and I'm Dolores Trujillo. Thank you. Continuing on in the agenda, we're at item 5.3. This is information only. This is a presentation by DCA Budget Office on the following 5.3.1 Registered Nursing Fund Condition.
Okay, and Suzanne and Luke have both been elevated as panelists. Thank you.
Hello, can you hear me? Awesome. Well, good morning. My name is Luke Fitzgerald. I'm a budget analyst with the DCA Budget Office, and I'm joined by budget manager Suzanne Balkus. I'd like to thank the board and executive staff for allowing me a few minutes to present on agenda item 5.3, the board's memo, expenditure and revenue projections, and fund condition statement. First, I'm going to start with the budget memo, which is going to be page number 41 of your materials. This will give you a general overview of the board's budget, as well as percentage of budget used and counted towards expenditures. In 2023-24 year-end summary, the board was appropriated about $66.5 million and spent an estimated $61.5 million, or about 92.51%, which resulted in savings of about $5 million. In current year 2024-25, the board was appropriated about $65.9 million and spent approximately $64.4 million, of which $25.8 million was expended on personal service costs, $27.5 million on operating expenses and equipment, which includes contracts, purchases, and travel, and $11.1 million on enforcement, which is for Attorney General's Office and Office of Administration hearings. The board is estimated to have 1.5 million or 2.23% in reversions. The next page we will go over is the board expenditures, which is going to be page number 42 of your materials. These projections are based on actual data through fiscal month 6. This report includes 2023-24 actual expenditures in green, as well as 2024-25 budgeted and projected expenditures in blue and orange, which also includes a budget allocation breakdown. Over this 2-year period, costs are relatively higher. As we move to the end of the document, you'll see this is a breakdown of the memo. The board had a beginning base budget of approximately $65.9 million and is projected to spend approximately $64.4 million, creating a reversion to the board's fund of approximately $1.5 million, or a reversion percentage of 2.26%. The next document is going to be the board's revenue projections, which is page number 43 of your materials. This report includes receipts collected through December and projected revenue to year end. I'll actually go further into these projections as we transition to the next slide. The last slide, page number 44 of your materials, is the board's fund condition statement. And as a reminder, we read this document from top to bottom and left to right. The left column is the board's prior year 2023-24 actuals. It shows the board began 2023-24 with a beginning balance of just over $77 million. Collected roughly $77 million in revenues, with $23 million from initial license fees and about $51 million from license renewals, and $3 million from the issuance of citations, fines, delinquent fees, and other revenue. Below that, you'll see the loan to the general fund of $65 million. The board expended $62.5 million, which includes $4 million in direct draws to the fund for statewide prorate and pension payments. The board ended 2023-24 with $27 million in reserve balance, or about 5.8 months in reserve. For the current year, the board projects revenues of $78 million, with almost $22 million projected from initial license fees, roughly $52 million from renewal fees, and $4 million from the issuance of citations, fines, delinquent fees, interest on loan repayment, and other revenue. And then below that, you'll see the loan repayment from the general fund of $30 million. The board's 2024-25 expenditures based on the governor's budget with fiscal month 6 projections is $55.8 million between authorized expenditures and direct draws to the fund, leaving the board with a fund balance of $78.7 million or 14 months in reserve. The budget office will continue to monitor the board revenue and expenditures and report back to the board with monthly expenditure projections as we continue to close fiscal months in the current fiscal year. And then just a few things to note on the board's fund condition. The fund condition is a snapshot in time. One of the main factors driving expenditure increases in future years is a result of personal service adjustments. These include general salary increases as well as employee compensation and retirement rate adjustments. The budget office includes a conservative ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. You will also notice that revenue is projected higher in the out years. And then lastly, I would like to note to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which would create cost pressure on the fund. And I would now like to give some additional information regarding the 2 budget letters that the budget office received that will have an impact on the board's appropriation. The first is the Vacancy Savings and Position Eliminations Budget Letter 2420. Department of Finance issued a budget letter 2420 vacancy savings and position elimination to reduce the state workforce by 10,000 positions and $1.5 billion, $762 million from the general fund and $738 for the special fund. The budget letter 2420 reduction will be effective starting 24-25 and ongoing, while the position eliminations identified will become effective 2025 and 26 ongoing. The second is going to be the government efficiency reductions, budget letter 2424. Department of Finance issued budget letter 2424, government efficiency reductions. This budget letter includes instructions to implement control section 4.05 reduction required in the 2024 Budget Act for the development of the 2025-26 governor's budget. As of today, DCA is operating under the understanding that the reductions will be approved as submitted and will be included in the May revise. The budget office will continue to monitor the board's fund condition and keep the line of communication open with executive staff for any future needs or expectations. Again, thank you for allowing me the opportunity to present at today's meeting, and I'll now be happy to answer any questions.
Just for clarification, that was 5.3.1 and 5.3.2 that Luke covered. And so if you have questions on any of those items, it is open for question, and we will do public comment on both of those items too.
Board Member Patricia Wynn.
Thank you very much. So I'm not sure if this is to Mr. Fitzgerald or maybe it's to our EO, Loretta Melby, but just talking about position eliminations. So that's a pretty big number to have to eliminate. And we've been talking already this morning about elimination of positions that were kind of critical to the work that we're doing. I'm just wondering if those positions that we're talking about in this item is going to result in more dramatic position eliminations.
No. And so the position that I talked about in the prior strategic plan update on the question for continuing education, that was part of this budget letter where we got together with DCA. We submitted so they ran a report of all of our vacant positions. And then that was, again, a snapshot. And so of that report with those vacant positions, we set amongst BRN leadership and said which ones remain vacant because we can't eliminate positions that have people currently in them. And so of those vacant positions, those were the ones that were put forward. We were given the opportunity to say, I can't afford to lose this one. This is a position that needs to be kept. And so back and forth, we were able to keep some of the positions that we felt were absolutely imperative to continuing on our mission.
Thank you.
Mm-hmm.
Any other questions? Board Member Allison Cormack.
Thank you so much. And thanks to the budget staff for, this is really comprehensive work and we're in a nice steady routine here. The only thing that I don't understand is on page 44, in the current year under total resources, the 4th line of expenditures. It looks like we got $10 million in funding provided by the state from the general fund. And that doesn't look like it recurs. So If you said what that's for, I think I missed it. Just be helpful to understand. And it looks like that's a one-time thing.
So that is from the HCI, and this was supposed to be separated between 333 and 666. So between two budget years, and it was supposed to start in 23-24. However, the board did not use it, so it was moved to the following, which is current year, and that is the lump sum of it.
Okay, and HCI provided this because for what?
I can get that more of information, except if Lori would have an idea about it.
Thank you. So we've gotten two sets of funding from HCI. One was for the nursing workforce, and that's where Horn came in. And
Okay.
we were able to do that. Another monies that were given to BRN from HCI was for the supplementation of the public health nurse renewal and initial certifications. And so those are still a process that we had to collect money on, even though the licensee did not have to pay. And so that got settled up by a general fund coming in to clear those licensings. What we did in the meantime is pursue legislation that just passed where we no longer have renewal fees for
Right.
the public health nurse.
Right.
And so that will eliminate that process, and we won't have to worry about that in the future for those public health nurses to get that supplementation.
Great. So one-time things in both instances.
Yes.
Thank you so much.
Thank you, Lori.
I just want to acknowledge the consideration that was given to registered nurses in the fire areas down in Southern California to be able to delay their fees. And I just think that's really beneficial for people that were suffering down there. So appreciate that.
Thank you, Nilu. Any other questions or comments from board members? Seeing that there's no questions or comments from board members, BRN moderator, will you please open this up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment."
And it's just a reminder to the public, this is for public comment on agenda item 5.3.1 as well as 5.3.2.
Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in person in your location?
No, there doesn't appear to be any requests for comments here.
Thank you. Would you like me to close this window?
Yes, please.
Thank you.
Thank you.
In preparation for 5.4, we do ask that Tim Bunter and Yvonne Leonard Taps, please come to the middle public table, please.
Moving on to the agenda, we're going to item 5.4. This is information only. This is presentation on travel requirements for licensees on probation or in the intervention program.
Good morning. My name is Tim Bunge. Working, testing, maybe a little bit. No,
Better.
better.
Is the lights on?
Lights
Yeah?
on.
Okay. It's just some background real quick before Tim opens up. This was a public comment that was provided at a previous board meeting, and it was asked for it to be added. And so we are now discussing this in response to a public comment received. Thank you.
Good morning. My name is Tim Bunger, and I am the Deputy Chief over Discipline and Probation at the board. Specifically, I wanted to address that probation and the intervention program do not have specific language that require the board to either approve or deny vacation or travel. What does come up is that we need to coordinate testing facilities for them when they do travel, especially for probation, as that's kind of the area I'm more knowledgeable of between the two. Is we will work with Vault, our testing partner, to identify where a nurse should go to submit to testing based on where they reside, or in cases of travel, testing sites near where they're at. Vault has testing facilities throughout the country. International travel has been an ongoing discussion that we are looking for what options we do have and what we can do. We also do work with the probationers, with the intervention participants to provide alternate testing locations. But I do want to say that we are also mindful that travel can be used as a means to avoid testing and avoid compliance. But we do our best to work with each individual on a case-by-case basis to allow them to live their lives while also remaining compliant with their program requirements, whether that's intervention or probation. Any questions for me?
Board Member Patricia Nguyen.
Yeah, thanks very much, Mr. Buncher. Sorry. Could you, about 6 months ago, we were told about a different kind of testing procedure that could be a swab that could be mailed in. So is that is that something that can happen now, or is that something that's a kind of a future?
It's something we're researching. I had every intention of having our meeting with Vault to have that answer for you. Unfortunately, I've been sick on and off since the beginning of the year, so I had to reschedule it. And the next available was next week. So hopefully in a future board meeting, we can share that. One of the questions that we had specifically to probation leading up to the board meeting was, is saliva or oral fluid testing even in our contract? I did review the contract. It is in there for probation. We just have to figure out what that would look like as far as modalities, how we could get the test collected, and then also the security of the test to make sure that the sample submitted is from the probationer and doesn't get tampered with on its route to the testing facility.
Thank you very much.
So just for some clarification on additional information for Vault and testing. So the information was given to us through Maximus last year when we had Maximus come and present and Vault was here present. And there are 373 collection sites throughout California, and those are in 49 of the 58 counties. And so when we do have participants, whether probation or intervention, saying we have to travel long distances, that is accurate for some. However, like when you think of LA, traveling 5 miles might still be a 1-hour trip. And so really looking at, we're working with our new vendor, Premier. They are now they took over the vendor from Maximus starting January 1, and they did continue their contract with Vault, and they are working with Vault to expand more of the testing sites and seeing what options are with that. Intervention does do saliva testing, as part of the various testing modalities that they have. They do blood, saliva, fingernails, hair. There's a bunch of different ways that they do the testing. And so that is rotated in there. For security purposes, they do DNA testings of the participant if they want to do a saliva testing, so that the saliva received is verified by DNA that it is the participants. So it does require additional levels of testing to ensure that is taken care of. I also met with the executive officer for Montana and their Board of Registered Nursing. And because of the rural aspect of Montana and the way that they have to have their testing done, their primary testing modality is saliva. They are not super happy that that is the primary one, but they do put that in with testing that does a retroactive look, like a PET test or a fingernail or a hair testing, used to validate that. We would be implementing something very similar to that form so that we can ensure that that testing is accurate and would allow for travel. So at this moment, intervention does have saliva. They are able to travel. we do not deny or approve travel. What we do is meet with them in advance to ensure that they have the ability to stay compliant with their program when they are gone. That is something that we did start looking into probation, where Tim did review the contract to ensure that we have that option. And now we just need to put processes in place to make that happen.
And although it's not specific to testing, I did want to mention one of the historical things that used to play into travel too was being able to attend their support group or their 12-step meetings. With COVID and everything kind of going remote, they've now been able to complete that remotely versus needing to be in person at that nurse support group. So that has helped travel a little bit as well. The other part we're looking into too is international travel and what that looks like. I know we've had a public comment in the last couple of meetings regarding traveling to Argentina. That case and any case involving international travel does present some unique questions of, while they're spending time out of state, out of country, does that potentially toll their probation while they're out? So that would mean that they wouldn't have to comply with the terms and conditions. And then it would just start right back up once they come back, and it would be treated as like a pause on their probation terms. So if they're gone a month, they come back, we bring them back into being active on the program and then add a month at the end. But that's a question we're currently looking into to see how it plays in.
And then to make that very, very clear, that is a difference between probation and intervention. Probation has an ability to be told if they do go out of state or if they do potentially go out of country. Intervention does not have that process. And so what we do hear a lot in public comment that may be confusing is beginning last year, we had a lot of intervention participants that were coming into public comment. Towards the end of last calendar year, it was probationers coming into public comment. And so there are two very distinct processes within our board. One is probation that has its own set of rules and regulations, and one is intervention. And so to try to not get those confused and intertwined is difficult, because you might have a participant say, well, I heard at the board meeting this. Well, you heard that about intervention, not about probation. Or you heard at the board meeting this. Yes, you heard that about probation. That is not intervention. And so those two processes are kept completely separate within our board and have different guidelines for each one.
Just for the record, there's in the uniform standards as it relates to intervention program provisions about tolling for drug testing for somebody who leaves. It's a may postpone testing. It's not explicit the way that our disciplinary guidelines are, for folks in probation. Any other questions on this agenda item?
Thank you. So there will be more to come, just because we do have Premier as the new vendor that is managing the vault testing with our intervention program. They've been up and running now for about 2 months. It is still a very steep learning curve. So we do ask for continued patience and understanding as we continue to work with forwarding them. As most people are aware, Maximus was a vendor for Department of Consumer Affairs for about 40 years. So it is a new process, new people, new everything. And so we are working very diligently to get that up and going. Yes.
Any other questions or comments from board members? No? BRN moderator, can you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, I would like to make a comment. Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
There does not appear to be any request for comment here.
Thank you. Would you like me to close this window?
Yes, thank you.
Go ahead and move into agenda item 5.5, which is an enforcement adjudication overview. Before starting the presentation, I do want to highlight that this is a high-level overview and is not intended to be a complete and comprehensive outline of all possible directions that a case could go. And I'm happy to answer any questions throughout the presentation or at the end. I want to start with...
Sorry, Tim. This is Reza. I just want to add, I think towards the beginning of the meeting, there was a public comment during the section for public comment for items not on the agenda where somebody asked for something to be added regarding, I believe it was regarding the board's online retention policy regarding discipline documents, and that person was referred to this agenda item. This agenda item is pretty general regarding adjudication under the APA, including proposed decisions, STIPs, et cetera. So I think it's fair to include that say that would include those documents that are mentioned, PDs, stipulations, including the posting of it. But because it's not specifically worded as specific to the issue of online record retention, I'm suggesting that that item specifically be added to the next agenda as well. So you can discuss that today, but also to accommodate that individual who may have wanted a more focused discussion on that, to specifically identify that topic on our next agenda.
And Reza, I did have notes on that specifically to cover our retention policy and can cover that today. And it was going to be at the end of kind of this whole overview.
Great. Yeah, I think that's fine to cover it today. And if there's any questions or anything, that's fine as well. If you have direction for board staff for any information you want or anything like that for the next discussion at the next meeting, you can kind of think about that as we're listening to Tim. Sorry for the interruption there.
Please. So I want to start by highlighting Business and Professions Code 2708.1. And this is the code section that highlights that the board's ultimate mission and goal is public protection. And especially when it comes to enforcement and disciplinary actions, protection of the public is paramount and what guides the entire enforcement process through all the stages that I'm going to go through here shortly. The enforcement process starts once the board receives a complaint, and we can receive a complaint from multiple sources. The most common are our court and arrest notifications. So with nurses being fingerprinted, if they get arrested and or convicted, we get an automatic ping or a query notification from the Department of Justice, letting us know of that arrest so that we can start obtaining the arrest record, court records, anything like that. It could come from members of the public, facilities, pure medical staff, civil case settlements, other state licensing agencies. So if, like another state board of nursing disciplines someone, we have the authority to take action on that here in California. And ultimately, anyone can file a complaint at any time for any reason. Based on the type of complaint that's received, we'll either refer that to the BRN Investigations Unit, Division Investigation, or a desk investigation will be completed by our Complaint Intake Unit. Cases that involve a scope of practice violation, those will get referred after the investigation is complete to an expert practice consultant in that area of practice to review and determine if the respondent did deviate from the standard of care in that case. One of the main code sections that you'll see in every single disciplinary case is it's kind of our umbrella statute that kind of encompasses the broad spectrum of all enforcement actions, and that's Business and Professions Code 2761. And it's broken up into a few main categories. The first is unprofessional conduct, and this is where acts of gross negligence or incompetence may be grounds for disciplinary action. And there could be a finding of general unprofessional conduct But that may be for a lower level of discipline, like a citation, may not warrant going to the AG, or result in gross negligence or incompetence. For gross negligence, this is either a extreme repeated failure to provide nursing care as required, or the failure to provide care or exercise ordinary precaution in a single situation which the nurse knew or should have known could have jeopardized the client's health or life. I do want to highlight here that no actual harm is necessary, just that there's a possibility for harm. The next is incompetence, and this is where the nurse either lacks the possession of or the failure to exercise the degree of learning, skill, care, and experience ordinarily possessed, and is also more detailed in California Code of Regulations sections 1443 and 1443.5. Once a violation is substantiated, it's gone through investigation. If needed, it went through an expert and the case is substantiated. The case will get referred to our discipline unit to then send it to the Attorney General's office for an formal administrative action to be filed. Once the Office of Attorney General or the AG receives the case, a Deputy Attorney General or DAG will be assigned to then prepare the pleading documents. And that could be an accusation, a statement of issues, which is the charging doc for applicant cases, an order compelling a mental and or physical exam for 820s, and or a petition to revoke for a nurse that's on probation and violated those terms and conditions. Once we file an accusation, the nurses have 15 days to file a notice of defense contesting the allegations. We do allow more than that 15 days. Historically, it was for mailing to come in. Now that most things are electronic, we still allow that time to make sure we're not proactive or too expeditiously moving towards a default for non-response if it's just a delay in getting that notice of defense in. Applicant cases, they have 60 days from the date of denial to file their appeal. We don't require them to submit a notice of defense after the statement of issues or SOI is filed because we treat their appeal request as that notice of defense. So once we get that notice of defense, that's what kicks on the settlement negotiations or scheduling the case for hearing. For statement of issues, as soon as we file the SOI, it's served on all parties, then we just move into settlement without that NOD piece. All our pleadings, whether it's an accusation, statement of issues, 820 order, or petition to revoke, they state the causes for disciplinary action. It is a public document, which I'll go into a little bit later, and it is published on the board website and nurses. The exception I want to highlight here is statement of issues don't get posted until there's a final action on that case that resulted in discipline. So if a nurse decides that they contest the SOI, we end up withdrawing it, nothing would get posted on their license record. Also 820s, those documents, anything contained in there are confidential as well and not posted publicly. Specifically on the 820 exams, this is where we have reason to believe that the nurse is unable to practice safely due to a mental or physical illness. And our EO, Ms. Melby, has the authority to order these exams as appropriate. Once an order has been sent, the discipline case analyst will work on getting an examiner, typically a psychologist, psychiatrist, or medical doctor, depending on the case facts, to determine if the nurse is safe to practice or not. If they are deemed safe to practice, the case is closed, and under statutes, that case actually remains completely confidential. There's nothing posted publicly about it. We can't use it. It's very much kept closed. In the event that they are found unsafe to practice, we will send that case back to the Attorney General's office to prepare an accusation based on being unsafe. Or if they fail to comply with the exam, we will proceed with disciplinary action there. There has been case law and statute that supports that just us ordering it, they are required to comply. If they want to argue the basis for it, that occurs at the accusation phase after an 820 order, not during the initial exam. The other part too is if a nurse fails to comply for whatever reason, say they didn't get the packet in the mail, but they get the accusation for failure to comply, we will allow them to submit to the exam after an accusation has been filed. Our goal isn't to force these nurses to get revoked for noncompliance if it was just a mistake of why they didn't attend to that exam in the first place. And we have that every so often for various reasons. So there's two routes once a case is filed that it can go. It can either go to settlement or hearing. Settlement is by and large the largest number of ways our cases resolve. I used to have the number, but what it used to be was about 90% of our cases settled, 10% went to hearing. So more settlements than we have cases go to hearing. In order to settle, one of the things we look at is certain requirements that we want to review document-wise. So proof of rehabilitation, letters of recommendation from peers, support family members, employment performance reviews. If they've had, a DUI on the weekend, what was their work like around the time of that DUI? We also look at mental health exams, anything that they have that can show kind of how they've either responded to the event that led to their accusation, or practice cases, have they taken courses relevant to that practice area. In the event that the respondent or us cannot reach a settlement, we'll proceed to hearing with the Office of Administrative Hearings. An administrative law judge will hear that case, and then they'll provide their written proposed decision within 30 days. The board, and that's board staff, and I know the board members, when they vote on our decisions, we look at the totality of facts. Each case is very different from the other. I've been here at the board doing enforcement for about 10 years, and although we see a ton of DUIs, I've never seen one DUI that was identical to another. So we're really looking at each individual element of that case to see what is the most appropriate settlement, going back to that public protection being paramount, but also is appropriate for that case and not being overly punitive. We do have a handful of final orders, the lowest level of which is a public approval, which is essentially saying this was wrong, but it doesn't require ongoing monitoring like probation would. These cases usually will involve cost recovery for the investigation and or prosecution costs. And they may include courses as well. So if it's a lower level practice violation, we may require them to take coursework in that relevant practice area to remediate whatever deficiency may have been present. The far more common is probation, where we'll typically monitor a nurse for 3 years with various terms. Just about every probationer has their employment monitored, but in cases where there's substance abuse involved, there's a mental and physical evaluation, ongoing drug monitoring, nurse support group, and other requirements. A nurse could choose to surrender their license. There could be a revocation. That could be either from a default, either by not responding to the accusation, or for no show at hearing, or it could be that the conduct was so egregious that the judge, the administrative law judge at hearing, ordered revocation based on that case. It could be a final decision of denial in applicant cases where either they just decide not to contest the denial notice, or they appeal it. We go all the way to hearing and the judge upholds that denial. There's also withdrawal. So if there's for any circumstance where our case changes, we learn more information down the line, we may withdraw our accusation or pleading document, and we would have nothing posted on our web. Basically, we didn't have enough information or evidence to continue, so we don't leave that as a mark on a nurse's record because we don't have it. And then all signed orders are sent to the board for final vote, the exception being defaults and surrenders, as our EO has designated authority to sign those, or her designee. So those don't go to the board and we just process internally. Going back on kind of what guides all of our enforcement actions is the recommended guidelines for disciplinary orders and conditions of probation, more commonly known at all these board meetings as the disciplinary guidelines. And these list the violations and what the recommended actions or punishment is for that violation, identifies what we can treat or should treat as mitigation towards rehabilitation, and then specifically outlines the conditions of probation and their rationale. And that is a public document. It's within statute, or excuse me, regulation, and is posted on our website. If you search disciplinary guidelines, it will pull up. Based on some comments at the last EIIC committee, I did want to touch on the board vote process and kind of how that flows. As I mentioned earlier, this does exclude surrender and default decisions, as that those are signed by the EO. And there's really kind of two branches of board vote cases. The first being our fast track, our early termination for probation stipulations. These are quicker turnaround cases that from when they're sent out to the board members to vote, there's a 1 week turnaround for that vote to come back. And on average, about 5 cases are sent out per week. All the other decision types that we have, so those would be the stipulations or proposed decisions. Historically, we referred to this as the mail vote process because this would be physically mailing it out, waiting for them to come back. Obviously, we've made that efficient and it's now all electronic. But those have a 30-day turnaround from when they're sent out to when the votes are expected back. And we send on average 10 to 20 cases every 2 weeks. And in the event that 2 or more board members either vote to hold a decision or reject it, the case gets held and is discussed at the next closed session at the next board meeting like we have later today. And then typically there is no delay with getting the cases out for the board to vote. It is just waiting for the votes to come back in and then process them to legal desk for adoption, or if it was rejected through that process. Based on the public comment, I did want to address the disciplinary history and kind of how that plays into our role. Disciplinary actions are a permanent part of a licensee's history and record with us. There's 2 kind of branches to that as well, federal and state. For federal, we're required under the Social Security Act to report all disciplinary actions to the Nurse Practitioner Databank. All records reported to them are permanent. They cannot be removed in any fashion unless the underlying action is removed itself, which is a very rare occurrence for us. For another part with all of these is all disciplines are considered public records, and we would be required to provide them under a applicable PRA request, and we do get quite a few of those. We do post all of our disciplinary actions to our website, but based on our document retention policy, the documents get pulled down at certain intervals based on the decision type, which I'll go over shortly. But the chronology of discipline remains indefinitely. So even though you have a case that was closed 20 years ago, you've complied with everything, you're no longer on any type of monitoring, you don't owe us cost recovery, anything like that, the documents themselves will be removed, but the history that you were placed on probation, had a public approval, that will remain, as well as, again, if the records are requested, we must provide them. On the National Practitioner Databank side, those records are posted indefinitely. We are required by federal law to have those posted and don't have the ability to pull the documents down like we do on our website. So for public approvals, it is 3 years from the date of compliance. So that's all courses completed, cost paid in full, that the documents will get removed. For probation, that's 10 years from the date of probation completion. For cases of revocation or surrender, it's posted indefinitely. And then though not formal discipline, citations for unlicensed individuals is posted indefinitely. So these could be nurse impersonators or people that are acting as nurses when they are not licensed as such. That will remain on our website indefinitely. And that ends my presentation. Do you have any questions or concerns or anything on the process?
Board Member David Lawler.
Thank you for that, Tim. When you were talking about unsafe to practice as a decision that's made on some of the nurses, I remember the public comments on that. Granted, those were individuals not inside like you are, but with their own personal cases. Is there a rubric or a red line of some sort that makes everything that is unsafe to practice as serious as everything else? And I ask that, and maybe that's not the best way to ask it, but there seems to be a range where, based on anecdotal public comment, some of the decisions to be considered unsafe to practice might have been, let's say, in a gray area.
It's possible. One of the things with the 820 cases is we're heavily reliant on the evaluator, whether that's the psychologist or psychiatrist, to determine what level of unsafe there is. Oftentimes, and I believe in our questions, and if I misspoke on that, I apologize, but in the questions that we ask our examiners to complete, it identifies, what level, if this probationer or if this individual could be monitored, could the reasons being unsafe be resolved or addressed? In most cases, yes, okay, if they're on probation for 3 years, you monitor their drug use, you monitor their prescription meds that they're possibly taking, and ongoing therapy, then yes, they're safe to practice. So when that gets to an accusation stage, our settlement would probably be probation with monitoring. There are other cases where, unfortunately, the mental or physical ailment is so severe that there's nothing that could repair that or mitigate that. That those are cases we would go for revocation. We'd ask for surrender, and it really just depends. But we do rely heavily on those examiners to tell us, could this be something with monitoring it's been resolved? Is it a one-time thing that doesn't need to be ongoing? Or is it so severe this person needs to be immediately removed from practice?
Thank you.
And then to add real quick to those examinations are done by qualified medical nurses that have specific criteria. And those review processes are not just like a 30-minute office visit or a 15-minute office visit or where they just review documents. They can take upwards to 8 hours with interviews, reviewing data, materials, et cetera. And that is a process that is used by the Healing Art Boards within DCA as well. So it's not just singled out to BRN.
And oftentimes we'll see examiners too that they want to see, they'll talk to the support network for that individual to see if, what they're telling them was true. They'll talk to their employer to see if, hey, have you noticed anything here? They are very thorough in looking at the totality of that individual and their potential health situation to make their recommendations.
And then real quick, to add on to that, our board president, when we're looking at developing agenda items, that has been a request that she has asked to add to our upcoming board agenda, where when these people are deemed unsafe, the risk that has happened in the past towards our board members as well as board staff, where some people become threatening, where we do receive some death threats and some other unsavory kind of emails and stuff that comes with that. And so we will be kind of putting that, we've tabled it for this initial board meeting because we wanted to kind of go over this process, but then we wanted to kind of bring up the inherent risk that comes to the public servant that is carrying out these orders, where we do remove a license from a person that has been deemed unsafe to practice, and what happens after that, and safety requirements, and getting security at future board meetings, and et cetera.
Thank you, Lori. Board Member Patricia Nguyen.
Thank you very much. What a great presentation. Very, very thorough. I appreciate it. So we spend, hours every week reviewing cases. But I don't think I've ever seen a citation case. What would that be like? What would is there a typical citation case? Okay.
Nope. It helps if I hit the button, I guess. Sorry about that. So I'll start over. I'll take a stab at citation cases because it's been a while since I've been over them. But they are informal actions, so they don't come before the board for vote, with the exception being if one was appealed to the level that it went to an administrative hearing and a proposed decision is issued. In that case, you may see it, but those are very, very rare. And I think have only seen maybe 2 in my entire time here. Typically, it's very low level cases, DUIs where it's maybe a 0.01, but there was maybe some other minor aggravation with it. It could be another good example is like CEU. If they didn't complete their CE requirements that they're required to for their renewal, we could issue a citation for that.
Another common one is address of record.
Yep.
So we are required within 30 days, any RN that changes their address, that their address of record must be reported to us. And so those are the type of kind of administrative things that we will do, a cite and or a fine. We haven't really been doing fines much in the last year, more just citations. And as Tim said, to be very clear with that, that is not considered disciplinary action.
Right, so that doesn't get
is
reflected on, and then is there a limit on the number of citations you can accumulate before it would turn into a disciplinary, or is that just that just doesn't happen.
We haven't seen that
Okay.
happen. Yeah.
Good. I just have a second question, and that is really just to address the public comment. And I do appreciate your presentation on it. I mean, great. It's nice to know that there are two different systems going and there are federal requirements and state requirements. But, you know, we've heard now twice in public comment of someone who had a very, very old, 20-year-old, you know, conviction. I think she said she was a teenager. She applies for a nursing license. She, you know, that gets reported. Here she's been a nurse now 10 years. That just strikes me as just being so fundamentally unfair. And I understand there's a federal system and we can't address that, but are we doing the right thing in terms of the state where we're saying after a certain amount of time, those offenses just go away?
So I want to clarify, they don't go away.
Okay.
Even though the record may get how much is publicly available at any one time may change based on our retention policy, it doesn't negate that there was a discipline that could be shared with anyone at any time. It is a really hard balance because on one side you're looking at making sure the public and the consumers are aware of the practitioners that they're seeing and treating them when they could be at their most vulnerable. With exactly the public commenter we had earlier where, you know, it's 20 years ago. What is it, you know, how does that impact my practice today? I know I'm not the same person I was 10, 15 years ago. That it's really is a hard balance to strike. But the hard part is, at least with discipline, it is a permanent record. And even though we could pull the docs from our website, we can't remove that discipline happened. To touch on kind of the change in its specific business professions code 480, and it was for applicants, of how far back we could go for court or conviction cases or arrest only. Cases are adjudicated where the law stands at the time that the case was resolved. So in, you know, a hypothetical case that the resolved 20 years ago, but they were a licensee at the time, or even an applicant, we can't apply what's now current to what their case was. And I know Reza and I have had multiple conversations and emails with nurses asking that very same question of, will this law change? So can my case get dismissed or withdrawn? Well, no, because your case was fully adjudicated with the law that was in place at the time.
Well, I would just, you know, encourage us to, you know, keep after this. If there's a way to come up with a fair solution, I would definitely hope that we would be doing that. Thank you.
As it stands right now, it would require a legislative change. And that legislative change would have to then make the current requirement to be applied retroactively. And that is not the fact today. That still only, and to really make this very clear, that still only affects the Breeze license lookup and the publishing of documents associated with your California RN license. That does not affect the NERCES data bank. That is a National Practitioner Data Bank reporting system. We use NCSBN to do that for us through NERCES, and that is a federal system that stays indefinitely. So although we could have California law come in and say, we'll apply it across all California applicants and licensees, the same law, and that goes retrospectively. And we do a massive cleanup of all of our licensing systems, knowing that we have over 500,000. And we clean that up. It doesn't fix the NERCES or the National Practitioner Data Bank, as that is federally required. So that stuff will still be there. The other thing that Tim was very good at pointing out was that applicant, which is a new person coming into California, that it looks at criminal cases and background issues, that does not address prior discipline on other licenses, including other out-of-state RN licenses. That stuff is considered through the licensing process as well, and that doesn't have a time frame attached to it. So if something occurred and a discipline happened and they were in Missouri, then that comes over with their license when they come into here too, and that's separate from that process.
Thank you, Lori. Board Member Nilu Patel.
Tim, fantastic presentation and overview. Again, I appreciate it. It's a great refresher. As board members come on in the first few weeks, Tim provides an orientation and of all this information. And it's been a steep learning curve for me to wrap my nursing brain around all the legalese and things like that. So I know you touched on this regarding unsafe to practice. If you can just provide me with further clarification regarding what's unsafe, and are we categorizing unsafe to mean those that have exhibited mental health issues, substance abuse disorders, to those that have practice issues? And are we providing expectations of them based on those things?
I'll try my best. Because there's the unsafe to practice category, there's a whole host of what types of cases can go into that route. What you probably wouldn't think of right off the bat is we get an arrest for a domestic violence issue. But when we look at that arrest report, we notice that they were incredibly intoxicated. Either the victim in the case or other witnesses said that they were making, nonsensical statements, showing some signs of potential psychosis, that we would have the examiner looking at that to go, was this a one-off, or is this a pattern of behavior? And that's where like the interviews of peers or, family members can sometimes come in of like, oh yeah, my ex-wife or partner is always drunk every weekend all the time, versus no, this was a one-time thing. It's out of character for them. It's a one and done type situation. We do also have other cases where you do have a more significant mental health concern, where, the nurse could be suffering from schizophrenia, where they're hearing voices on shift and thinking someone's trying to steal drugs from the med cart when they're just trying to stop the nurse from practicing unsafely. There's just a lot that can fall into that category. But there are definitely degrees of, how unsafe is unsafe. And that could be, requiring, no, you need to lose your license. You are too much of a public safety risk. To, as long as your prescriptions are being monitored, you're taking them as ordered, you're drug testing to make sure you're not taking anything you're not supposed to, you will be safe and we'll monitor you for 3 years. And I would say most 820s that are unsafe to practice, we usually settle. It's a very rare occurrence that we go all the way to a revocation. It does happen. Or sometimes, they just have some type of psychological break or concern that happens that is severe enough to warrant taking their license away and allowing them to petition for reinstatement later. And just a note on that process too is if someone is revoked for being unsafe to practice, when they go through the petition and reinstatement process, they have to prove that they've overcome whatever ailment was there prior to the decision to surrender being revoked occurred. So we do a check that way, so we're not just potentially letting them come back after, a year or two of being surrendered or revoked.
And then to add more to that what Tim is referring to is also our probation and intervention programs, right? So in the intervention program, if your practice is affected by mental health or a substance use, then they go into that program voluntarily. It is confidential, but in that program, they have a worksite monitor. And so once they have on the intervention side, have negative tests and they are involved in their recovery process, then the IEC committee reviews that and says, you can go back to work as an RN, but maybe not in direct patient care. So you can do case management, telephone triage, something to that effect. Then they practice that way for 6 months or in a part-time kind of role, and then they go back in front of IEC and they say, I really want to do patient care. I want to have access to narcotics. I want to do that. Then that committee will review how compliant they've been in that program and really look at what is happening with their mental health issue or substance use issue and determine if they can be released with less oversight essentially to that one, so that you can now have patient care and still be monitored. We still have a worksite monitor. They continue their testing, they continue checking in, they continue to do all that kind of stuff up to releasing them to a full licensure while they're in the intervention program, and just continue to monitor to see how they do so that they can reach that 3 to 5 years and be completed. On the opposite side of that is the probation spectrum. And with probation, you get a lot of patient care issues that come with that. You hang blood on a wrong patient, you miss a failure to thrive diagnoses, and the infant passes away. There are many different things kind of practice related that come through that one that are not necessarily substance use or mental health disorders at that point. And so when you get somebody that comes into probation, that goes through a legal process, and that is public, that is noticed, that is on their record. And there are specific guidelines that have to be followed with that, up to and including they have to work for 20 hours a week for 6 months as part of that process. They do have a worksite monitor, and that worksite monitor is very different than the worksite monitor that happens with intervention. Intervention, that worksite monitor is really checking in a couple times a week, looking at sobriety, looking at how is your mental health. And that kind of goes into that committee and goes in with all the testing and the checks in to kind of make sure that that's managed. On the probation side, you might have a worksite monitor that's assigned to be with that nurse the entire time that they are on shift. If they start at 7 o'clock in the morning and they end at 7:30 at night, they have a worksite monitor with them that entire time. They don't go to breaks on their own. They don't go to lunch on their own. They are two people that are linked through that entire process, because we are really looking at that public safety. It could also go to what's called moderate supervision. And that means half the time that they are in front of patients, they are with a worksite monitor. So they are checking with them, they're touching bases, they're reviewing charts, they're pulling Pyxis reports and Omnicell reports and following up on documentation and really just doing some very thorough reviews. They also turn in worksite monitor reviews on a schedule. Some of them are monthly, some of those are every 3 months. It just depends on where they're at in that process, so that our team can get an accurate reflection of what's happening out there. There is also a minimum supervision for them, and usually they get to that progressively throughout the 3 to 5 years that they are on probation. And that is just a twice-a-day check-in. And so they might check in at the beginning of shift, end of shift, just to see how things are going on. There's also limitations to that practice if there's like home health-based, right? Because there's not a lot of supervision with that. And when we're doing worksite monitoring placements, the nurse that is assigned to that within our unit calls the employer and says, do you know what's going on with this nurse? Have you read the probationary terms? Do you know why they're there? Do you know the classes that they're receiving and why they're doing that? Are you able to provide that type of supervision? And then they also ask for like the general layout of the unit. They may limit to them saying you're not able to float, or you can only work day shift, you can't work night shift. All of that kind of stuff is taken into consideration. It's very complex. And so even if we get somebody that originally was deemed not safe to practice, we have the ability to work with them, work with their employers to get them back into practice as long as they are monitored and staying compliant. Some of them may just need a RN refresher course. Maybe they hadn't practiced in a while and they came in and they're no longer competent, and that was missed. And so then we do RN refresher courses, we do course assignments. There's a lot of things that come in probation-wise that are different than the intervention side.
Thank you so much, Tim and Lori. That really helps to answer my question.
Board Member Allison Cormack.
Thank you so much, Chair Trujillo, and thanks for going through this. I feel like this little clip should be like, when someone joins the board, okay, start with this, because, and it's hard in the beginning to absorb it. I just wanted to take a moment to acknowledge that the vast majority of nurses are never disciplined, right?
Yes.
Okay, so, I mean, because we spend so much time on these issues and just every now and then I like us to resurface and say the vast majority of nurses are never disciplined, so.
And I'll add to that. It's been a minute since I pulled the stats, but working in enforcement, you do get a little jaded, especially on discipline, because you're seeing the worst of the nursing profession, unfortunately, and most of the time. We discipline 1% of the entire licensee population.
Yeah.
It's
So
an extremely small number.
So I just think that's important to say. And then just so I'm really clear on this, because we do this every week and some people ask like, what is your job? I'm like, we do, license discipline. And so if someone is disciplined, it goes through the process, we vote and they're on probation, that whole packet is up for 10 years? Like the whole thing that we see, or what's that?
Not the entire packet you see. All that gets posted publicly is the underlying pleading, so typically accusation, statement of issues, and the final decision in order. So the stipulation or the proposed decision, which typically will have a lot more information. But that memo that you normally get from the DAG that outlines
That
the
first 2
recommendation-
pages is not there.
Correct.
But everything else is there. You're on this kind of probation and blah, blah, blah. It's 13 or 19, and here's what you were accused of. Okay. We know that the percentage of nurses who have DUIs is consistent with the overall population as well. It's not any different for nurses or any other category of people. Okay. So I think if someone were to go through and look at, okay, we got 10 years of probation, 3 years of public approval, about what percentage of all of that discipline do you think is DUIs?
I couldn't answer.
Round
off the top of my
numbers.
head.
Okay, what I can say in my, is like, it's pretty high, right? It's a big component of, what we see. You obviously see, the citations and things like that. So it just always I just feel like this should be like a class in like, or a teaching session or something where someone who's on probation comes in and tells nursing students, hey, like, I didn't really understand this. You are putting your license at risk if you drive after you've been drinking. So I know I say this a few times, my public service announcement. I doubt that anyone here needs to hear it. But it is, we do spend so much time on this. And it's not that nurses are any different, but I do think some of them are surprised at the effect on their profession, their professional work. As a result of this, it's very different, very different consequence than your, average person who gets a DUI. All DUIs should have said that. Let me just state that, they're unsafe, right? So anyway, I just wanted us to take a moment to do that while we spend all the time on edge cases and things that are serious, to reassure the public that the vast majority of nurses are practicing safely.
In our nursing schools, they actually, in their fourth semester or final semester program, a lot of times they will have a chance to come in and watch a discipline day. Here, we used to have discipline days that were there, and now I know that we're working towards getting a discipline day reinstated here so that they can see that. And they have to schedule as a group and get all that kind of things going now because it is public. And so, with that, a lot of the nursing students kind of got to see what happens. Another thing that I know that program directors, they share with me all the time, they say, I know you're going to celebrate graduation. Don't drive when you're celebrating graduation because the DUI you get today will affect your license in 2 weeks when you want to apply. The other thing just to kind of add on to that with the DUI is it's not just alcohol. It's alcohol and drugs, and it's not just illicit drugs, but a lot of times it's prescription drugs. It's your antidepressants, it's your pain medication, it's different things like that that will cause them to be under the influence and be part of a traffic stop. And there's what I receive a lot as comments is, why does what I did here pertain to what I do in nursing? I wasn't working. I was driving under the influence. Why does my license have to be disciplined? And so that's when you start to look at how those choices or lack of clear choices come in and start affecting your nursing practice. And so that's when the nursing board comes in, because again, our entire purpose is protection of the consumer or protection of the public.
And I'll add to your PSA a little bit too is one of the things that we have is California Code of Regulations, section 1444, which is a substantial relationship criteria that does dictate that a DUI or criminal act could result in discipline with us. And it is something that when we do our outreach with the nursing schools, with hospitals, whoever we're talking to, that, you know, we share that nursing is one of those unique professions where what you do off the job, seemingly unrelated to your career as a nurse, could impact your daily life. It could have very severe consequences on, you know, you went and had one too many at the bar, drove home. Well, now you're losing not only all the requirements from the criminal side of it, but now you've just lost your license or have requirements placed on it from there too.
And that's consistent with the statement you made earlier that there doesn't actually have to be harm. There has to be the potential for harm.
Yeah.
Right.
Board Member Vicki Granowitz.
Thank you. Tim, great presentation, and my fellow board members, you've done a great job, I think, with trying to illuminate a lot of the complexity of what we do. When you're talking about what you need to train the students about at the end during discipline day, they also need to understand that this isn't a legal proceeding where if you get in trouble, you can get a court-appointed attorney. In our situations, people, if they can't afford to hire an attorney, they don't get an attorney. And it does make a significant difference, in my opinion, for a lot of the people that we see who really get into particularly the hearing officer situations where there are depositions and then there are, they are legal proceedings. And they really don't know what they're doing, and they're going up against attorneys who are knowledgeable. And so they're at a big disadvantage. And I just wanted, it's difficult to read those and to see how, just to see how heartbreaking it is that they don't have resources to be able to adequately defend themselves. And so that's just something I also have noticed in reading these, that where you have an attorney, a lot of times those people do better, looking at all things being as consistent as possible as the person without an attorney. Thank you.
Thank you, Vicki. Board Member David
To
Lawler.
piggyback off that, and I know you've addressed it before with us in terms of how, even though they're not your client, you'll ask the right questions. But my question is, doesn't their union provide legal services? And I only ask because as a teacher, if I get in trouble, CTA Legal will take care of me. No?
I can't answer that. I don't know for sure. And don't want to obviously misspeak on that at all.
So with nurses, it's dependent on where you work, whether you're unionized or not. And it is dependent on whether or not what occurred happened at work. And so if what occurred did not happen at work, you're not going to have union representation throughout any of it. And if you're working in a non-unionized hospital or a clinic or something, you're not going to have union representation. So that is a common thing that I do hear from our board members when we're going through this process and we're having them reach out, is they do tend to state that they see a clear line of licensees that have an attorney representing them and licensees that don't have an attorney representing them. And clear to what Vicki said is because this isn't a kind of legal proceeding process. It's not like if you can't afford one, we'll appoint you one. And so they don't have that benefit of everybody that goes through the process having legal representation. And I think that was the biggest point that Vicki wanted to put up there.
And for just, you know, the public and board members, because I know we've talked about this in closed session when we're reviewing cases, but just want to, you know, share is it is naive to think, if you don't have an attorney, that there's not going to be some difference between someone representing themselves or having a, attorney that does this day in and day out. In the cases where the nurse is pro per or representing themselves, the attorney generals that work those cases do a little additional work to help those nurses to get to a settlement. We don't just basically treat that they would expect to have the same knowledge as an attorney that's representing them. In the cases that they go to hearing, the ALJs do a similar thing. There is a little bit, and I don't mean to minimize this, but hand-holding that occurs. So I just want to give a shout out to the DAGs that do work with respondents that aren't represented to try and get them to a similar settlement if they were represented. Again, obviously, there's going to be a difference in how those cases get handled, but we do our best to make sure that that doesn't play into the ultimate outcome of that case.
Just to add, sorry, this is Reza. Last thing on that. As far as I'm aware, criminal court is really the only forum where you're appointed an attorney if you can't afford one. This is not a BRN thing. There's no board in this department that provides attorneys to respondents. Likewise, if you're in civil court, if you can't afford an attorney, it's not provided. It's strictly criminal court, as far as I'm aware, that it's kind of unique based on what's at stake there. Understanding, of course, there's a lot at stake in our cases as well, but it's just kind of an unfortunate reality of the system.
Any other questions or comments from board members? Thank you, Tim. That was very informative. BRN moderator, will you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Paradise would like to make a comment. 1 second, please.
First, thank you for those that have shown empathy with my situation and the thorough explanation of the current legislation. I have a couple points and suggestions for the future so someone else doesn't have to go through what I did. First is to let applicants know that if they agree to the probation, that their record will never be erased federally, rather than telling them it will be cleared in 10 years and leaving nurses out of the discussion, so that they can make an informed decision and pick a new career path. Lastly, intervention participants have their record kept private the entire time when they have committed recent illegal acts against patients while working as a nurse. One example was when I was in We Care, the support group, and an intervention nurse discussed recently stealing patient narcs and diverting or selling them on the street, and continued to work at a prominent hospital with the record kept private. Yet probation participants for now decades-old expunged teenage crimes are put on blast all over the internet, which is what seems a little backwards in terms of patient safety and public protection, if that truly is the priority. I know that as a patient myself, I would feel a lot more comfortable and safer with the 14 years sober former probationer nurse rather than the drug dealer intervention nurse. Just saying. Thank you.
Thank you for your comment. Cynthia Yovanov would like to make a comment. 1 second, please.
This is Cynthia. I'm a nurse practitioner here in California. Also serve for CANP. My only question was great detailed explanation in regards to how RNs go through this process from a legislative standpoint. But how will there be a detailed explanation for the licensed practitioners? I believe it was earlier this year or maybe last year, there was a similar presentation, but the hurdles that an RN has to go through for, say, a DUI, is that the same process for any of the licensed practitioners? I just feel like we don't have anything that detailed for us as this presentation was done.
Thank you, Cynthia, and don't jump off yet in case you have more questions. So the reason that we were RN focused is that is your license within the BRN. And so if you are an advanced practice RN, you also are primarily an RN. And so when your RN license is disciplined, so are your APRN license, no matter how many you hold. So if you have a nurse midwife and a nurse practitioner and a clinical nurse specialist, then when your RN license is disciplined, it's disciplined across all of your APRN licenses as well. So it is the same process for all. It is not whether you're an independent practitioner or a practitioner that works under standardized procedures or whether you're just an RN. That disciplinary process that goes through probation is similar across the board. The one thing that we did have to address, and it is currently a regulatory package that's moving through, is the monitoring of the independent APRN when they are in the probation process, because previously our advanced practice RNs did not have an independent scope of practice. And so they fell underneath the same monitoring structure of minimum, moderate, and maximum that we kind of explained earlier. And so now with this, we had to create a new pathway for your independent advanced practitioner for the monitoring that occurs when they are in the probation system. But if you do something that gets you disciplined as a nurse practitioner, that discipline is posted to your RN license, and then it is carried over to your nurse practitioner license. And so both of those get disciplined as one.
Well, thank you for that explanation. I mean, it was very detailed. As the nurse practitioners and midwives, the only thing I find that is a bit of a disparity is that the nurse practitioners, as we function in that role, and the midwives and the CRNAs, is that we are obligated to have malpractice insurance, right? So based on that malpractice, we would have the opportunity to be represented by a lawyer. But for those that are not in an APRN role, they don't have that advantage to have malpractice. And as you had stated earlier, if they're union and non-union, it gets more convoluted and they have possible representation. So I kind of felt like, it is a disparity for the RNs that are non-APRNs may not be aware of that option, that having that malpractice if something like this were to happen against their license. So I appreciate that detailed information. So thank you.
Thank you, Cynthia. And then just a point of clarification, just so that the public knows, it's not BRN requiring malpractice insurance for APRNs. We do have one statement for nurse anesthetists that there is a requirement that they do carry their own insurance and that they are liable for their practice. But that is not carried over in our other areas of the NPA. And it is also noted that your RN that does not have an APRN is able to get malpractice insurance. They can do that on their own. It is something that they pursue. But that is, we do get some questions that come into the board that say, should I, or do you know a good insurance company? And we can't. That's outside of our jurisdiction. So it is good to get that information out, but that's not coming out from the BRN.
Great. I appreciate that. Well, thank you very much.
Thank you for your comment. Judy Cornell would like to make a comment. 1 second, please.
Hello, I'm obviously a registered nurse. I'm also a chief nurse executive. Perhaps you can answer the question around the professional obligation of executive nursing leaders in reporting or maybe not unprofessional conduct of a registered nurse, someone who is perhaps under discipline within an organization, but not yet with the BRN, and or someone who is not convicted of a particular crime, but has been arrested and and there are serious allegations and the liability associated with that if they remain in patient care.
So we can't specifically address what happens at the healthcare agency through the employer perspective. But what we can let the public know is that because of our fingerprinting process that we do utilize for licensure here, that we do get criminal records sent to us that are reviewed. And if it is something that is egregious, it is notified to the Attorney General. And they have a person that presents at the hearing to ask for immediate revocation of the license through a process called a PC-23. And please, Tim, any point you need to jump in and correct me, please do so. There is an additional process that we utilize if that doesn't get granted, and that is an interim suspension order. And so those we ask that to be considered, and a judge will either grant or deny. If both the PC-23 or the interim suspension order is denied, it has to go through a complete investigative process and go through a legal process, which does take years to go through. And during that point, until an accusation is filed, the public is not aware of that. And so that becomes kind of problematic for the employer. We do have employers that reach out to us and say, I provided you with all the documentation. I gave you the complaint. Why do they still have their license? And that is because it is a legal process. It's not something that the BRN has complete control over. Additional thing to consider in the state of California is employers for nurses, for RN nurses, are not mandated reporters. And so if you are an employer at Hospital A and your nurse does something egregious, they do not have to report that to the licensing board. We want them to. We really would ask you to do that, but it is not a legal requirement. Therefore, there are many, many times that incidents occurs and they're handled in-house. They are go through a risk management or a failure mode analysis or a root cause analysis, peer review, M&Ms, morbidity, mortality. And so they're handled internally and they never reach the level of the licensing board. So we're not aware of that. Another thing that comes out as a common issue is with travelers or temporary staff is you don't have to go through the HR process at your facility. You can just cancel a contract, and that's a very quick thing. And then the traveler that participated in that event goes on to the next travel assignment, and nobody knows about that. And so there are definitely some holes in California law that could be addressed legislatively if there was an author that decided to do that. That is different from BVNPT. BVNPT is our Board of Vocational and Psychiatric Technicians. They do have a law on their books that require employers to report any disciplinary action directly to their board. That was something that I believe was brought forward legislatively for BRN, and it did not successfully go through many years ago when that was brought in. So there is definitely a difference on how that is handled, but from an employer aspect, we do ask you to report, but there is no legal requirement for you to report to your licensing board.
This is Reza. Just one quick add to that. I want to distinguish, I think what the question was and what Lori was speaking to was kind of just general obligation to report, say, unprofessional conduct or other misconduct by an RN. And then there's what I'll refer to here as the quote unquote mandatory reporting laws that individuals who work in schools are subject to and healthcare professionals are subject to and all that. I don't believe that discussion was specific to quote unquote mandated reporting, which is specific about reporting specific things and covers specific individuals, and RNs are subject to that. But that's kind of that specific area of law under mandated reporting of things like child abuse and neglect and things like that. So I don't want there to be any confusion about that statement being, going too far.
Thank you.
One part I want to add too is there is one area which is required that nurses do get reported, and it's specific to nurse practitioners, specifically Business and Professions Code 805, where a nurse practitioner was found to have violated the facility policy or standard of care through a peer review body or the other options that Lori mentioned. The facility is required under law to report that to the board under an 805 report. And we do have information on our website for more of that. Additionally, those 805 reports are public. So if someone were to request an 805 report on a nurse practitioner, which I know we have a lot of facilities that ask for those, we are required to provide them. But I would point you to our website regarding 805. And again, it's specific to nurse practitioners only.
And that was a new one that was added after the passing of AB 890. And so when AB 890 passed, they added that responsibility for 805 reporting. And there is a process to do that on our web.
This is Reza, and I was just going to add that there are, in addition to what Tim just mentioned, that's specific to nurse practitioners, in the Business Professions Code 800 range, the sections that follow, there's a few provisions there that deal with required reporting under certain circumstances by certain entities. So, for example, a settlement of certain allegations might trigger a mandatory reporting. Insurance payouts under certain circumstances could require. So take a look at those as well. Business Professions Code Section 800 and the following sections, which includes 805 that Tim just mentioned. They're not necessarily, that entire range is not strictly limited to NPs.
Thank you.
And so that's the 801 reporting, correct, for insurance settlements greater than 10,000, I believe.
Right. 800 talks about judgments and settlements. 801, that I'd say 801 through at least through 805. It may continue on beyond that, but that entire article is titled Professional Reporting, and it covers kind of miscellaneous scenarios, including insurance payouts, legal civil settlements, things like that.
And then just for clarification, a report out does not necessarily mean an action by our license, like by our board. So we can get an 801 report on an insurance payout where the insurance has just decided to kind of close that. But when we investigate it, our nurse was not at fault. And so we would not take any disciplinary action at that point.
Thank you.
Thank you for your comment. Julie would like to make a comment. 1 second, please.
Can you hear me?
Yes, go ahead.
Oh, thank you. I appreciate this discussion, particularly being a nurse practitioner. I would like to advocate for more education up front. I think deciding whether to be a practicing RN or a practicing nurse practitioner, I probably would have chosen differently, knowing that I made a mistake one night many years ago outside of work. And I think knowing that as I was part of medical staff, I did not report to any nurses. The intervention program was not something that would have worked for me. I did extensive investigation on it on the website, and there was not the information that's being given now. This is not the intervention program that I learned about. This is a completely different situation. And I just wanted to say that I think reporting situations to the national provider database that stays on there for the rest of my life, given that I was encouraged to surrender my license because I was ill when I was encouraged to go to probation and then encouraged to surrender my license. And then and then the board, I was, I was told that the board reviews all of the evidence and reviewed everything and that people were looking at everything. And now I hear that only the executive officer is signing off. I just don't feel like you guys know everything. As an advanced practice nurse, you do not understand what you're getting into. The same situation could happen to an RN. And now this is on the National Provider Database. I was not even convicted of anything. I was not convicted of a DUI. I know this is too much information, but this is my entire life. My entire life. For one mistake. I'm just saying you don't grow up wanting to be a nurse for your entire life. And then one mistake, your entire life is over. I think the BRN, yes, we are the worst of the worst nurses. I heard you say it. But I think there are some issues that we all need to look into. And I'm sorry. Thank you.
Thank you for your comment. Catherine
What-
Hughes. Sorry, go ahead.
Thank you. One thing I want to add is for stipulations, the board does review any stipulation with the exception of surrenders or defaults before they are made effective. In the circumstances that were just mentioned, it sounds like the surrender occurred after probation was effective. So that probation decision would have gone through the board for vote and review. The surrender would not have, but it sounds like that might have been under condition 12 typically, where the nurse has the ability to surrender under that condition.
Thank you, sir. Catherine Hughes would like to make a comment. 1 second, please.
I'm a registered nurse and the executive director of the Nurse Alliance of SEIU California. And I just wanted to make one comment regarding SEIU in particular. We represent about 750,000 members across the state of California. About 35,000 nurses, so a small number of nurses. Our union usually represents our nurse members regarding contract violation or employer misconducts. We don't have, our representatives don't have any expertise regarding the Board of Registered Nursing or nurse licensing. So, so we don't represent them unfortunately, when nurses are facing disciplinary action. If I happen to receive a call, because I've been doing this for more than a minute, even though I can't recommend an attorney to them, I do provide contact information for an attorney who did a presentation for us regarding BRN discipline. So we are able to just say, hey, we happen to know someone who does that work if you're interested in contacting them. But that is one of the reasons why SEIU in particular isn't able to provide that expertise for them. We don't have enough nurses for that to unfortunately be a priority when you're representing, almost 800,000 people. Thanks.
Thank you for your comment. Board President Trujillo, there are no other public requests for comments on the WebEx. Do we have any public requests for comments there in your location?
Yes, we have one request for comment.
Okay, go ahead. Oh, sorry, as soon as this walked
He's
out.
coming up to the podium.
Yeah, I can see. Thank you.
To address the board. My name is William Shea. I'm the Senior Vice Provost at Charles R. Jr. University of Medicine and Science in South Los Angeles. This has provoked a lot of questions. I'll limit it to just a few on comments. One is if we could speak to the higher education responsibility, if there are laws or regulations that dictate what we should do when we don't own and operate clinical facility. And if we know that on a license, there is a form of disciplinary action that has been removed since, it's unclear to us what we have to apprise, if anything, our students and our clinical affiliates about that particular past disciplinary action. Secondly, and this is murky for us as well, we have had a lively dialogue with the California Medical Board on a remediation not being a disciplinary action, especially in regard to our medical residents and fellows. And having said that, we struggle with our proactive responsibility in terms of impairment, something that hasn't yet reached the stage of a disciplinary action, either internally or with your board or otherwise. And the specialized accreditors all over the place on what our responsibility is to proactively call out impairment. And we've talked about under the influence, but with the fires in LA recently, it's also under duress. And we've had students and faculty that lost homes or family members that did. And we said, look, you're not in an emotional space to be able to go into that clinical and learn and or touch patients in that case of someone who's at that stage in their clinical. So it's just a common question about learning more with your guidance on one, what is the responsibility of higher education when they don't own and operate to apprise students, others that we're affiliated with about a past disciplinary action. And secondly, guidance on what we do proactively in regard to calling out impairment, which can be risky. And frankly, as a senior administrator, I'd rather err on over-interpreting possible impairment than under, but I also run legal risk when I call someone out that truly is not impaired for whatever reason. So thank you for the opportunity to.
So I have a layered response for you. So I'll start at the beginning.
Appreciate it.
So if it's a pre-licensure program, that is a student that is not a nurse, right?
Yes.
They're going to school to be a nurse. We do not have any reporting requirement to our board at that point because they are not our licensee and we are unable to take action on any student that is doing something within your setting. When you're looking at enrolling that student, there is a law out there that actually prohibits schools from looking at criminal background and deciding whether or not they're going to enroll them. That is an area of contention with our directors of nursing because what happens in a nursing program is you have a requirement to do 500 hours of direct patient care, which means you have to touch a patient, you have to be in a healthcare facility. That healthcare facility can determine that they don't want that student in there. And then you have a student that may have completed 90% of their coursework and really close to graduating and then can't. They are stopped. And so we do ask our academic partners to try to find clinical placements that would take them in lieu of a placement that denies them based on a criminal background. We do know that part of the clinical preparation, there are many organizations out there. One of them is called Complio or American Data Bank, and they do a 7-year criminal history, and they will tell you whether or not it's clear or not. If they are clear, they typically are allowed in almost any of the clinical sites out there that utilize that. If they are deemed not clear, that process is that person's information is given to HR at the healthcare facility to look at whether or not they are willing to make an exception and allow that person to come into their clinical facility. Again, completely outside of BRN and done within the healthcare system 100%, because our state law says you cannot deny enrollment of a student based on a criminal conviction, right? So that is handled separately outside of BRN. And that is done through the clinical contracts that each one of your facilities, each one of your academic institutions have that determine whether or not they will take that student. There have been academic institutions that create like data banks that they utilize that say, if we get a student that has this, we know that this clinical placement will take them because of the monitoring, the support and oversight that they have. It is not a risk. Now, when we go to look at now they've completed school, whether or not we license them, if you pull our statistics, we get anywhere between 40 to 60,000 applications a year, and we only deny applications to maybe 1 or 2 on an annual basis. So most of our nurses that apply become nurses in our state. They can become nurses with a full and unrestricted license. They can become a nurse that we carry over some disciplinary action that was on from another state or et cetera. And we can give them a probationary license and put them through our probation system for that. So that is your unlicensed student. Then when you look at your licensed student, so this is your APRN student, this is your nurse practitioner student, nurse midwife student, et cetera, you are required to look at their RN license and vet it prior to enrolling in your program, because your program is for a post-licensure program, which means you have a license and you have to vet that. When you do that and you find that there's discipline on there, that goes back to your state laws again, which says you cannot deny entrance into your program based on criminal convictions, et cetera. So what you would have to do is see what you can do to accommodate that. And we work with our schools to accommodate that. If we have an RN that is going to school for an APRN role, we treat that as an employment. And so it does go through our nursing education consultants. They review them and they give employment approval or clinical approval for each one of the courses that require a direct patient care. And when that is done, we also make sure that that continued monitoring occurs. So if they are in a clinical placement, is that clinical faculty that is there going to accept the responsibility of monitoring that patient for that? And so just like we do job modifications when they're in probation, if they switch jobs, the same thing happens on our side as if they switch clinicals, right? So it is a very strenuous process to go through, but we do that as they progress through their academic institution, progressing towards their advanced practice RN role, is we will approve each one of their clinical sites as a job and ensure that they have monitoring in there so that that public protection stays the same. That is the probation aspect. I cannot talk about the intervention aspect, as that is handled outside of BRN, and job placements are handled through the vendor, and they monitor that. So I don't know that one as solid as I know the probation one, because I actually used to work in the probation aspect one to do those placements. So with that, they are able to go to school. We don't block them, and they can obtain licensure because they are in the probation system with us, and they hopefully will complete the probation process and gain licensure. We have had people in probation become a nurse practitioner and want to get their license as a nurse practitioner. What they don't understand is that their nurse practitioner license is then disciplined because their RN license and discipline. Part of that public comment we had earlier where we said we discipline the license, and it's all licenses that are tacked to that. So hopefully that kind of helps, like the enrollment aspect. We also have the director's handbook. Each one of our pre-licensure programs have a director's handbook that they get. That director's handbook doesn't update much. It's pretty similar from year to year. And in fact, this one is actually going online this year. And that director's handbook has an NLN statement on impaired students. We put that out there as truly just a recommendation to follow on how you would manage impaired students. But again, that they're not a licensee for us. And so we have no ability to take action on them. And so we also cannot tell you affirmatively what to do with your student that is impaired and how to manage that.
Thank you. That's very helpful. I appreciate it.
Thank you.
Thank you for your comment. Do we have any other public requests for comments there in your location?
Yeah, no, there doesn't appear to be any other requests for comments here.
Thank you. Would you like me to close this window?
Yes, please.
Okay, so we will not be moving on to the next agenda item at this point because it is lunch. And so we will be taking a break for lunch. Do you have a time? 45? So it has been asked that we break for lunch for 45 minutes. So we will be back and then that'll be, let's make it 50 minutes even. So we'll come back at 12:45. Thank you, guys.
Welcome back, everybody. We will begin the second portion of our board meeting today. We will take roll call to establish quorum. My name is Dolores Trujillo. Vice President Neela Patel.
Tell here.
Board Member Jovita Dominguez.
Jovita Dominguez present.
Board Member Patricia Nguyen.
When present.
Board Member David Lawler.
Lawler present.
Board Member Vicki Granowitz.
Granowitz present.
Board Member Allison Cormack.
Cormack present.
Thank you. We have established quorum for this afternoon's meeting. Moving on in the agenda, we are at 5.6. This is discussion and possible act. Oops, I'm sorry. This is information only, presentation on the outcome of the board's enforcement pilot project with the Division of Investigation, the Consumer Protection Enforcement Initiative, CPEI, and the Complaint Prioritization and Referral Guidelines.
Good afternoon. My name is Nicole Bowles. I am the Deputy Chief of Investigations here for the Board of Registered Nursing. I've made a mental note to myself to never follow one of Tim's presentations because that is a very hard act to follow. So I'm glad that we had a lunch break in between. Can you guys hear me okay? I'm sorry. I just want to make sure the microphone is okay. Before I jump into the presentation, I just want to note that this is a very high-level overview. Investigations by nature are confidential, so I will do my best to answer any questions that the board may have after the presentation. I want to also elaborate on several different elements of this presentation. So the Consumer Protection Enforcement Initiative is an initiative by the Department of Consumer Affairs for all of the Healing Arts boards. This wasn't just exclusive to the Board of Registered Nursing. Within that initiative, the Complaint Prioritization and Referral Guidelines, the CPRGs, were created as a tool for us to use in the enforcement process. And the enforcement pilot project with the Division of Investigation was an opportunity that the BRN had participated in because of our volume of complaints that we receive and the large licensing population that we have. So with that, I will get into the presentation. The Department of Consumer Affairs released the Consumer Protection Enforcement Initiative to overhaul the enforcement of the Healing Arts boards. The initiative targeted 3 critical areas to reform the enforcement process and reduce the average timeline from 36 months to between 12 and 18 months. These areas included administrative improvements, increased enforcement resources, and pursuit of legislation to better protect consumers. I think it's important to note here that although the Board of Registered Nursing were structured a little differently, investigations is separate from enforcement, but that is not the case for all of the Healing Arts boards underneath the Department of Consumer Affairs umbrella. So when we speak about the enforcement process, our investigative timelines are included in that enforcement process. So that timeline of 12 to 18 months, that also includes investigations, although we are separated in the Board of Registered Nursing from enforcement. Through the initiative, the Division of Investigation enhanced BRN's control over investigations through the 2019 guidelines, allowing our non-sworn investigators to develop subject matter expertise. And to further support BRN, in 2019, we participated in the Complaint Resolution Pilot Program. The participation in the pilot was approved by the board at the time, and the pilot allowed the Division of Investigations to focus its resources on the complaints involving criminal offenses while maximizing the resources at BRN through the enhanced case triage process. During the course of the pilot, the terms were revised as appropriate for both the Division of Investigations and the Board of Registered Nursing. On February 7th, 2023, a portion of the pilot was temporarily paused due to BRN investigations experiencing high caseloads, nearing or at the limit of 30 cases per investigator. On March 1st, 2024, the pilot was discontinued with the release of the new guidelines for the Healing Arts boards. The new guidelines included lessons learned and best practices identified during the course of the pilot. and the pilot was deemed successful and helped design the 2024 guidelines implemented for all of the healing arts boards. BRN continues to partner and collaborate with the Division of Investigation to meet the board's consumer protection mission. Are there any questions from the board?
Any questions from board members?
So you guys, oh, go for it.
Can I just add, the CPRGs are what determines where an investigation goes, if it stays with the Board of Registered Nursing, which are non-sworn investigators, or to Department of Investigations, Division of Investigations within DCA. And those are mainly sworn personnel.
And then so to add into this, as to maybe some people are saying, well, why are we having this discussion? Why is this being presented today? The last two board meetings, we have brought forth some data from investigations showing you guys that we have an increased caseload coming to us, that our investigators are at their 30 limit, that our special investigators are taking cases, both the two on the left here. So Yvonne and Nicole are triaging cases as well and looking at what they can do to help close cases and move them along. And so in those reports, we've referred to this CPEI and these guidelines and these changes that happened last February. And so we felt that it'd be prudent to kind of give a little more explanation on that for you guys to understand. We will be continuing to report out on this on a separate investigations report, typically day 2 of our agenda. And you guys will see that it is on there, day 2 of this agenda as well. And we will be tracking these numbers because we are seeing a change of cases and a change of just kind of working through this. And so with that, this has become a very high priority for us to take a look at and monitor and ensure that we stay in compliance. I'm sure you guys are very much aware of the audit that came through in 2016 from the California State Auditors, saying that the Board of Registered Nursing was not moving things through in a timely manner, and there was a bunch of things within our enforcement area that were looked at. One of the recommendations was decreasing the caseload or setting a caseload, for our investigators. And at that point, it was set at 20. When with new administration and us coming in and taking a look at everything, we were not able to find any specific criteria that 20 was based on. And so with that, we did meet with DCA. We did kind of query other healing art boards, and we came to a 30 as a case limit. Again, that could change in the future. We could go back out, we can look, we could say, do we have to go back down to 20? Do we need to go up to 40? We don't know what that is yet, but we're not going to make a just move that is not evidence-based and is not supported. What we have to look at is what we can do to get additional help into this area. We will be exploring a budget change proposal to see if we can get some staffing in there. We've also looked to see what we can to kind of redirect help as well within our current organization structure. And we are really looking at other processes and meeting with DCA to say, are there other efficiencies that other boards and bureaus might have that we're not aware of or that we're not utilizing? And so it is a kind of all hands on deck collaborative approach, because each month we are getting 100 or more cases in new to us each and every month. And we do have a limited amount of resources that can work with that. So continuing to bring it forward to the board's attention, continue to make sure that this is known publicly, this what we're up against and what we're dealing with. And we're just continuing to kind of explore all avenues of what we can do to manage the numbers that are coming into us and move them through in a timely manner.
Board Member Patricia Nguyen.
So when we were audited, I'm not sure who this is to, but when we were audited, did the state auditor come up with a number?
They did not. Okay. No, it was reported to us that potentially a staff member of the BRN at that point said we do 20. Okay. And so that is what was put forth in that report, knowing that our assistant executive officer, me, Nicole, we were not part of that team or even part of BRN at that point. And so we don't have any kind of historical knowledge of how that officially came about, but we have been told that it was brought up with a staff member and that was a discussion and turned over to the auditor that we do 20.
Any other questions or comments from board members?
No.
Thank you, Nicole. BRN moderator, can you please open us up for public comment?
We'll be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in person in your location?
No, it doesn't appear we have any other requests for comment here.
Thank you. Would you like me to close this window?
Yes, please. Thank you. Okay. Okay, at this time, we will go to agenda item 5.7. This also is information only. Presentation on the structure, authority, roles and responsibilities, etc., of the appointed 9-member Board of Registered Nursing and the civil service staff within the Department of Consumer Affairs, RN positions on the board within civil service staff and consultants.
Thank you. So I'll get a little background on this. This looks very similar to an agenda item that happened about a year ago at this point. This came up in public comment, and so we're just bringing it back out there, putting it back forward in public comment. There's been a lot of public comment lately that says, "I can't believe the RN's at the board this. I can't believe the RN's at the board this. If you're an RN, how come at the BRN the RNs don't such and such?" And so what I think really important to know for the public is that the Board of Registered Nursing is not a employer of registered nursing. So that is a kind of big area of confusion, I think, for a lot of people. I know it was for me as well. When I was a practicing RN and I was offered the job to come in here and work as a nursing education consultant, when I showed up in Sacramento, I didn't know that there was like 10 RNs total at the BRN. Last year, when we gave this presentation, we had 244 employees, with only about 14 of those being RNs. So we have slightly less employees now, but our RNs are me. I am an RN. I'm required to be an RN per current law. That can change in sunset. So in January, in fall, we'll start our sunset process, but it'll be a bill introduction that happens probably February of next year. If in that bill introduction, they decide that the RN as the executive officer is not needed, they can remove the RN licensure as a requirement for the executive officer. That is something that other healing art boards have. You don't have to be a physician to be the executive officer of the med board. You don't have to be an LVN to be an executive officer of the BVNPT. We currently have to be an RN to be an executive officer of the BRN. I appreciate that. I think that's the right move, but I could be slightly biased with that. But I am balanced. I am not a machine of one, truly. I have Yvonne Leonard Taps, as she is my, literally my right and my left-hand man. She is my assistant executive officer, and she's got an MBA. She doesn't have an RN. And so there's many times we're in conversation and she says, "I need you to not be an RN." talk to me like this. Remove your nursing knowledge. You're not understanding what's happening. Let's do this. And she really writes me, and we're able to work through that. Matthew Yates, sitting over there, he is over board services, board consumer services, board operations, not an RN. Macaulay Fusarins, Marissa Clark, Tim, Nicole, everybody that's been here, not an RN. So these are all BRN staff, none of them RNs. I am the RN. Then you look at our nursing education consultants. And we have a section under our board that are nursing education consultants, and they're assigned to our schools. And they do all of the reviews of our nursing programs, whether it's pre-licensure, nurse practitioner. They answer scope of practice questions. They truly are a jack of all trades, nursing related. And that unit is all RNs. They have to be an RN to be a nursing education consultant. There are two other kind of nursing education consultants right now outside of that unit that work within our board, and that is the retired annuitant I mentioned earlier that works under continuing education and does all the new provider approvals. And then I mentioned that we do in probation a worksite monitor approval process and an assignment of coursework. And that is done by a nursing education consultant that works with the enforcement department on probationer job placements and course assignments. Every other person is not an RN at our board. And we have a myriad of roles. We have licensing, and there are people that come in and specialize in licensing. We have enforcement, they specialize in enforcement. We have investigators that specialize in investigation. You don't want an RN trying to do all of those roles. It won't work. We have, people that answer our phones with public information unit and answer correspondence. And Marissa, who is amazing working with the legislators, I don't know how to do that. She knows how to do that. And I would not expect an RN to know how to do that. That is not what our training is. And so when we get these public comments that say the nurses at the board this, understand that that's under 20 people of a board that is greater than 200. Then when we look at it from our board, 9-member board perspective, right? There are 5 RNs and 4 public members. Each one of the 5 RNs have a specific role as they're appointed into. We've got our board president, which is a direct care. That means in order for her to be here at the board, she has to be actively employed at the bedside taking care of patients. We have Nilu, 2 over from Dolores, and she represents the advanced practice RN. So she has to be actively employed as an advanced practice RN. She is a certified registered nurse anesthetist that meets the expectation of an advanced practice RN, and she is appointed to serve here. And then the other RN currently on our board is Jovita Dominguez, and she's on my far left, so your guys is probably far right. And she is the education representative. So what we get a lot is that it's an RN heavy board. Of course, they're going to err on choosing the RN over public protection. Right now, we are not an RN heavy board. We are a public member heavy board because we do have vacancies in our RN role. And that is how we've been acting and moving, waiting for appointments to come through. So currently we have a vacancy in a direct patient care role, and I'm missing on what our other vacancy, manager, because Dr. Mary Fagan retired, and so she no longer qualified to stay on in that nurse administration role. So we are 2 nurses down, which makes us a 3 nursing board with a 4 public member. And so we do get, as we move into sunset, we do typically receive a letter that goes to the legislators as well as us from various legal firms, law firms that say that we are doing a promotion of the profession versus public protection. And one of the trainings I recently sat in, and our board vice president was in that training with me, was the president's onboarding that DCA does. And so that is an annual training, and they were very clear at what the purpose of our boards are. And in that statement, they said, if it's protecting the consumer, it lives with the board. If it's protecting the licensee, it does not live within the board. It lives within the organization. And sometimes that's a very difficult line to walk and a very difficult kind of redirect when you come in as a licensee. We're like, no, I want to protect all licensees. That's not the job of the Board of Registered Nursing. It's to protect the consumers of the care that is provided by the licensees. And so that becomes difficult. And then in that meeting, it said, if you're faced with an issue that is public protection of the consumer and also protection of the licensee, where should that probably live? And they said, probably that should live with an outside organization as well, so that that line is never crossed. And so that is difficult to manage as we bring through legislative proposals and legislative and bill analysis and stuff, and all the stuff that we move forward is, when you are an RN in any role serving on this board, we always have to kind of redirect and think of consumer protection 100% all the time and how that works within our licensee population. And so that is why we brought this back forward in front, because in public comment, a lot of people were saying, well, the nurses at the board, there's like 20. Tops, and I could pull my org chart and count, but I don't want to right now. But we are almost fully staffed with our nursing education consultants right now, which is a rarity, and it's fantastic. And so our nursing programs will benefit from that as we have more nursing education consultants that are training up and getting out there. And, we're always willing to do more and learn more and have more positions if they ever have opportunity to do that. We do have a nursing education role in enforcement that is vacant, but that was one of the positions that we're saying, we probably don't need at this point, because the current role is serving that. And then we did also talk about the supervising nursing education role that was in the continuing education unit that we are removing, and making that a state service role that doesn't require an RN license. So even though we had 2 positions that required RN, we've actually chosen to redirect those positions or eliminate to no longer require that. So it is not a leading factor in our hiring decisions or in our business management kind of decisions that it must be RN based 100%. So I wanted to really get that out there and get that clear. And do you want to add?
Yes.
Yes.
I just want to give some stats about our organization. Currently, we are authorized for 228.1 positions. That does include the 19 positions that we will be losing, I believe, in July of 2025. So that was going to take us down to 209.1 positions. At this current time, we have 189.9 positions filled. And so with our vacancy rate, removing the 19 positions that we cannot fill, right now it stands about approximately 9%. As Lori was mentioning, we do have 3 SNECs. One may no longer, we are considering reallocating that. We have 14 NECs with 3 vacancies. Again, 2 of those are being looked at. I think that's it. We do have our expert practice consultants that are in contract with the board. Many of them are licensed, or all of them are a licensed professional. And we also have some of our staff that hold an RN license, but that RN license is not required for the position that they hold. But we do have some that do have an active RN license. And I do just want to state that to make it clear that the Board of Registered Nursing is under the Department of Consumer Affairs, which is part of the Business and Consumer Services and Housing Agency, which then reports to the governor's office. So that's the hierarchy for the Board of Registered Nursing. And I think that was all I wanted to add, Lori.
And that's why she balances me so well. She comes in with all the stats and I love it. Thank you.
I'll just add, this is Reza. I think that the explanation Lori provided was very helpful in helping those who are not super familiar with the organization of the BRN, how it's kind of made up. Yvonne briefly mentioned something that I wanted to just expand on a bit, and that's the expert practice consultants that are used in discipline cases. So as Lori explained, of our 200 some employees, the vast majority are not RNs. So this understandably might raise the question of, with discipline cases, how is the board evaluating those cases at the investigative stage and when a complaint comes in and throughout that process? As Yvonne mentioned, the board has on contract expert practice consultants, generally who are RNs or maybe APRNs, and they provide the service where they review a set of facts, they review the investigative report and the materials that are provided to them for that specific investigation. And because they are a licensee, they're able to speak as an expert witness and opine on whether the set of facts demonstrates a violation and speak to the standard of care and whether that was met based on the facts and all that. So I just wanted to put that out there, that even though the board doesn't have on staff a ton of nurses who are actively, involved in each individual discipline case, that role is still filled by a nurse who provides that expertise.
So I can elaborate more on that. So in order to be an RN expert practice consultant, you have to be a California resident with an active RN license. That consultant also has to have 10 years or more experience as an RN, with a minimum of 5 years of clinical practice experience in the area of expertise or current employment in that setting, and no prior or current discipline against any healthcare related license or certification. And those are not necessarily employees of the BRN organizational structure. They are contracted out, and they do get paid $75 an hour for RN expert, and for advanced practice expert, they're at $125 an hour. They take and manage their time, they calculate that, they turn that into us, and they put that forward with their billing to us, and we do pay for that. And they are used for many different areas. And what you guys see in our board materials when we get to the enforcement section is there's always a recruitment for that. It says we're recruiting expert practice consultants and we need them in this, and this area desperately. So there is also a recruitment excuse me, on our website that you can just search in expert practice consultant. It'll take you right to it. It tells you specifics, what we're looking for, and what you're paid for and what your qualifications are. And those people are the ones that are utilized in our investigation and review of each of our cases that come forward.
And part of our expert practice consultant pool is those that the licensed practitioners who do our 820 examinations, and they are listed under that. So they may be at a physician, a psychiatrist, psychologist level. So we do have those also. And then I forgot to mention, in addition to the 209.1 positions that we have minus the 19, we also have 11 blanket positions that we currently have. One of those being the RA that Lori spoke of earlier, who is an NEC. And I also wanted to mention that Reza is an employee of the Department of Consumer Affairs, assigned to the Board of Registered Nursing, but part of the Department of Consumer Affairs employment.
Board Member David Lawler.
Thank you so much for that. I know how frustrating it is for people with questions, making requests of us, and discovering what we cannot control or is not within our purview. A number of those are at least implied requests for us to advocate for this, that, or the other. Other than simply saying we are not in the business of advocacy, is there a better way to say this isn't a part of the resistance? Does that make sense?
Can I just give a single statement that may help in that? Is
Yeah.
that this 9-member policy setting body is of the board. So that is, I guess you want to say your primary role is the policy setting body for the Board of Registered Nursing.
That makes sense. Thank you.
All right. Any other questions or comments from board members? No? Seeing as there are none, thank you, Yvonne. We will go to public comment. BRN moderator, please open us up for public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
No, there doesn't appear to be any requests for comments here.
Thank you. Would you like me to close this window?
Yes, please. Thank you. As this was information only, we're going to move on in the agenda to 6.0. Sorry. Just invented that. 6.0. BRN future priorities and proposals for review and possible action. Lori?
Marissa, come on up.
Sorry, Marissa.
Okay, 6.1 is discussion and possible action regarding proposed regulatory text to incorporate the statutory changes from SB 1451 and other related updates. That's the bill that became a law that a public commenter referenced earlier. And so we are working diligently to get everything implemented and updated based on that. So I'll turn it over now to Marissa to give you guys the details.
Thank you. Good afternoon, everyone. Marissa Clark, Chief of Legislative Affairs. As Lori mentioned, the impetus for this proposed text for regulations is passage of Senate Bill 1451 from last year. It was a bit of a policy omnibus bill, and it contains a whole wide array of changes for a bunch of different boards and bureaus under the Department of Consumer Affairs umbrella, so we are just a part of it. However, the part that focuses on the board is focused around changing certain provisions of AB 890, which, as I'm sure you remember, is a law that passed back in 2020, establishing those two new categories of nurse practitioners. So because the statute changed, our regs now need to come into compliance with that. So the majority of the language we're going to go over is statutory conforming. There are some other minor related changes that have to do with nurse practitioners or clarification of existing guidance that is also included, but I would say most of it has to do with conforming. And if there's a question on kind of which is which, more than happy to delve into each of them. So I will kind of just go by subject area. So for the first one, it is changes to the 103 NP, which are the nurse practitioners that work under Business and Professions Code section 2837.103. So those are your nurse practitioners that can work without standardized procedures within a group setting. So the proposed text would remove the requirement for an applicant's transition to practice hours, national certification, and 103 NP certification to all be in the same category. And when I say category, I'm referencing our current regs under section 1481 that talk about those population-focused categories. It used to be a requirement that they all had to line up. The law changed that, so now our regulations is removing that requirement. The second requirement is to remove, again, the requirement that a healthcare provider specialize in the same category as a 103 NP applicant that they are attesting to the completion of a transition to practice hours for. So similarly, our regs currently state that if you're a tester, has to have the same specialization category as the NP they're attesting for. That was changed into law, so we are removing that. Next, it just is a clarification that a 103 NP's national certification must remain active in order for them to continue working as a 103 NP. That was kind of implicit in the law, but it's just clarifying that you have to have that. It has to remain active, and that is the duty of the licensee. And then last was something that we added that we hope just helps for kind of clarification, and that is specifying that the term 103 NP refers to a nurse practitioner practicing pursuant to that business and professions code. It's kind of a tricky, wonky nickname in and of itself, and it's even wonkier citation. So we've struggled with how do we come up with a naming convention that is kind of understandable to the general public. And there's not always, understandably, that connection made between the section and then that phrase. So we wanted to try and add a provision just connecting those two. So if you hear the phrase 103 NP, it's referring to an NP under this section. We are open to other suggestions if there are. It's kind of a tricky one to remain accurate to the code, but also remain something that is understandable to both the licensees and the consumers. Next, I'll go over the changes to 104 NPs, which are going to be your NPs that can practice without standardized procedures and outside of a group setting. First, similarly to 103, it clarifies that a 104 NP's national certification must remain active for them to continue working as a 104. And a little bit differently, they must be in the same category as the 104 certification area they are seeking. That is something that is spelled out in the law and still is in there. So 103s don't have to align, but for 104s, their national certification and their area of 104 certification do need to match up. Next is we are removing the requirement for a 104 applicant to resubmit their national certification information, as well as a requirement for a 104 applicant to resubmit their transition to practice information. This is information that is submitted in order to become a 103. And I think originally when the regs were written, in order to become a 104, you have to be a 103 first. So it was just the same eligibility criteria was brought down. But reading it now coming up on 104s, it can seem kind of duplicative, like we're having them submitted again, and we don't need to go through that for us or for the licensee. So in place of that, we just added a requirement saying they just submit proof of certification as a 103, rather than resubmitting national certification or resubmitting any transition to practice information, just to try and streamline. Next is clarification of the documentation a 104 NP applicant will need to complete in order to apply the direct patient care hours they obtained as part of a doctorate of nursing practice program towards the requirement for them to work as a 103 NP for 4,600 hours. So in the law, it says that the board has the ability to provide kind of, I know waiver is not the right word, but some adjustments for individuals who have gotten their DNPs towards that 4,600 hour requirement that you have to work as a 103 before you become a 104. And we had clarified it somewhat in the regulations in terms of what types of hours would qualify, but we hadn't clarified how those hours will be validated and submitted to the board. So it's just adding a little bit of clarification there that we'll have a document that can be used and signed off by the program director and then submitted to the board for us to use for that validation. And then lastly, similar to the 103 NP kind of colloquial term, it would clarify that the term 104 NP refers to a nurse practitioner practicing pursuant to Business and Professions Code, section 2837.104. Next are changes to the notice to consumer provisions of AB 890 and our regulations. First, it clarifies that the consumer notification provisions are only mandatory for 103 and 104s. Other NPs are welcome to use them, but they are only required for those two categories. It would also remove the requirement for a patient to be notified verbally that an NP is not a physician and surgeon, and it would remove the requirement that specific terminology and phrases be used when an NP informs a Spanish-speaking patient that an NP is not a physician and surgeon. So what the law says now is kind of a broader requirement is that the NP is required to provide the consumer notification regarding them not being a physician in a language that is understandable to the patient. So that provides the provider the flexibility to do it orally, verbally, in writing, and in whatever language or terminology they think would be best suited for patient understanding. And then last on the notice to consumer changes, remove the requirement for 103 and 104 NPs to advise their patients they have the right to see a physician and surgeon and the circumstances under which they must be referred to see a physician and surgeon. That was explicitly stated in the law to remove that provision, so we are removing it. And then the other two are kind of broader NP changes. One removes a reference to the nurse practitioner certification equivalency option, which also is known as method 3. And that was eliminated by board action back in, I believe, May of 2023, as part of a broader kind of effort to align with APRN national licensing standards to remove that third equivalency option. And we just hadn't got around to updating that regulation section yet. But since it was included in this package and related to the content, we included it in there. And then lastly is that we have a clarifying provision that nurse practitioners who are not certified as a 103 NP or 104 NP must still work under standardized procedures. We still sometimes get questions or reports of misunderstanding about either that all NPs are able to work without standardized procedures or all NPs have to work without standardized procedures. So we wanted to just add a provision in there clarifying there's two very different kind of lanes you can go in. So I know that was a lot. I'm more than happy to answer any questions.
Go ahead, Neela.
I just have a comment. Thank you for that clarification. That was really informative. It's a sticky subject to say that, something that's understandable to the Spanish-speaking population regarding the nurse practitioner having to explain that they're a nurse practitioner, not a physician. There isn't a Spanish equivalent for nurse practitioner. So as Jovita would back me up in saying that, thank you. So I think, just wanted to make that aware and put that on public record that there's an equivalent, but, to do the best as possible to explain that they're not a physician, I guess, would be the best thing.
And that was one of the things that came up in public comment when we were initially writing the regulatory language. And a lot of that was to be said that there is not even a nurse practitioner as a role. Not even that the term doesn't exist, but that role does not exist. And so that's where a lot of that confusion came from. And so we had a lot of public comment that the board took into consideration, and that is when we kind of added some specific things into the regulation based on that public comment that it went through the Nurse Practitioner Advisory Committee. However, after that was done and implemented and our regs were done, that was not something that was generally accepted out there. And so that is why now with the law that we are rolling back a lot of the things that we had put in with very good intention, listening to public comment, getting Nurse Practitioner Advisory Committee feedback and moving forward. But we're in a good space right now, and just moving through that process, removing some of the additional requirements and making clarifications.
That was something that was in the 1451 that was stricken as well. There was specific terminology, I think from a very good intent of having just consistent usage. But to your point, it was later communicated. Good intent, however, that terminology doesn't necessarily do a one-to-one translation for specialized nurse versus nurse practitioner.
Any other questions or comments from board members? No? Thank you, Marissa.
Thank you.
That was a very comprehensive explanation. BRN moderator, can you please open us up for public comment?
We will be opening for public comment now. Please refer
Chair
to the
Trujillo,
screen share.
excuse me. So, Chair Trujillo, I apologize. Board Member Cormack, I was just thinking perhaps we have a motion before we go to public comment, because this is action, right?
Yes, we do. And can you move back to that slide, please, board moderator?
Since my microphone is on, I'm happy to move adoption of this regulatory change.
Yeah, so here you go. And here is the motion. Just for you.
I cannot read it from this angle.
Then I'll read it.
So I can go around the corner with my, okay.
I will make the motion.
All right, and then,
Motion to adopt the proposed regulatory text to incorporate statutory changes to SB 1451. This is Ashby, Chapter 481, Statutes of 2024, and other related updates. Direct staff to continue with the rulemaking file and proceed with review by the Director of Department of Consumer Affairs and the Secretary of the Business, Consumer Services and Housing Agency. Upon their approvals, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulatory text as noticed. Do I have a second?
This is Allison Cormack. I would be happy to second that.
Thank you. BRN moderator, can you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Cynthia Yovanov would like to make a comment. 1 second, please.
Thank you for all that information. This is Cynthia. I actually had a quick question because you guys went through kind of fast and I didn't see anything visually during the discussion. So a quick clarification on the 104. It was mentioned, now I tried to write really fast, so bear with me. It was in regards to when the NP attest, and I'm going to assume that this is still a self-attestation, that it had to be, the license had to be active, but it must be in the same category. And so I wanted to get that clarified. I really didn't understand how that came about or how that process would work for a 103 who is, you know, like a legacy certification and in regard to that statement. So maybe you can clarify that just to help me understand because it was a little fast when you were presenting. Thank you.
Thank you, Cynthia. And I apologize. I know that was rather fast. The proposed text and a summary of everything I just went over is in the board meeting materials under agenda item 6 printed. So that's for reference, but also happy to revisit any of the points. So to the question around clarifying that national certification does still have to be maintained, I think is for both, for either 103 or 104. But then the reason that we had clarified that it has to be certification and national certification align is because there wasn't a change made, and this is in current laws 2837.104, and it's C1. And that one says that the nurse practitioner, consistent with applicable standards of care, shall not practice beyond the scope of their clinical and professional education and training, including specific areas of concentration, and shall only practice within the limits of their knowledge and experience and national certification. So yeah, your point is well taken around the legacy on maybe needing to kind of troubleshoot that, but that was the reason, because that provision is still explicitly in there for a 104, that their practice area has to align with their national certification category.
Okay, thank you for that clarification. I appreciate that.
And just to make sure that it is clear, is the 103, which is, so in California, we have a nurse practitioner that graduates school or comes in initially licensed. They work underneath standardized procedures here in California. And you're not even required to have a national certification in California for licensure, for initial licensure. If you come in from out of state because you're not educated by a California board approved nurse practitioner program, you are required a national certification. That can be current or that could be a legacy certification. They come in, they work under standardized procedures until they complete the transition to practice. That transition to practice allows them to go into a 103, which is what is commonly known. But what we've constantly referred to it as is a nurse practitioner that can work without standardized procedures in specific group settings with at least one or more physicians or surgeons. That's what the law states. It's very long, which is why everybody calls it a 103 NP. So in that setting, you cannot work independently. You are within a group setting. Those group settings are defined in law and very specific. We get a lot of reach outs that say, I work in a med spa as a nurse practitioner. I work independently. And we're like, no, you don't. You work under standardized procedures. And because that nursing LLC doesn't qualify underneath that group setting that is specified in law of where that can occur. So that's clarification there. That nurse practitioner under standardized procedures and that nurse practitioner that works without standardized procedures in those group settings in the law that is updated now and our regulations that follow that no longer require the national certification to line up. Right. So previously, if you were educated as a pediatric nurse practitioner, you completed your transition to practice hours as a nurse practitioner, and you had, as a pediatric nurse practitioner, and you had a national certification saying you were a pediatric nurse practitioner. That is what we had put into place based on Nurse Practitioner Advisory Committee and public comment recommendations and the interpretation of the law as we understood it at that point. Then this updated legislative part removed that. What it didn't remove was the section that Marissa just called out, which says for the 104 NP, which is a nurse practitioner that has no healthcare facility limitation of where they work, right? So they do not have to have standardized procedures, but they are also not limited to that supervision of a group setting. And they are not limited to being required to work with at least one or more physicians or surgeons. Those requirements removed, this statement still remained that it has to, you have to only practice within the alignment of the and within your national certification. Now, those legacy national certifications still exist. They are still maintained. So it should not affect the legacy person, the provider that continues to work within that legacy national certification. What it affects in the current legal sense, and there may be another law that's introduced and there may be a bill that's introduced to address this in the future, but what it doesn't allow for is a pediatric nurse practitioner that is educated as a pediatric nurse practitioner that is working as, that has a national certification as a pediatric nurse practitioner to work in a adult cardiac CHF independent clinic as a 104. They can still work there as a NP under standardized procedures. They can still work there as a 103 NP if that is qualified under that group setting. What they can't do is move to the 104 and work in that role because that is not the role that their education and national certification lines up to.
I did actually have a question because that brought a thought to my mind on, just because we are before we vote on the language, that right now we do cross-reference the maintenance of the national certification and it aligning in the area with section 1451, which has the existing population focus. Do we need to add language there that clarifies other active for legacy?
We will.
Okay.
Yes.
Okay.
So we'll bring that in as an addendum.
So yes,
To the
so we
next one.
will clarify that so that it doesn't inhibitly or
Preclude
inadvertently,
those.
sorry, the
Yep.
pregnancy brain.
So do we need that language before we?
No, we can vote on what's here and then we'll bring it back in front of the board with specific language to address 1481. Yep. So we do have a motion in section. We have public comment. Cynthia, are you still on? Did that answer all of your questions?
Yes and no. So the concern is, and I appreciate, all the discussion. The concern is, I get the example of the pediatric. I mean, you go into pediatric, nobody wants to deal with adults. But my concern is the majority of nurse practitioners are family NPs, and majority of the FNPs are applying for their 103. They're ready to be a 104. But what I'm hearing coming from the board is that now there's another barrier that says a family NP who's a 103 is going to have challenges being a 104 if they are in a setting of cardiology, when the bill doesn't address really the settings, it's really the population. So that FNP will still address the population, but just in a cardiology setting. And so that's where my concern is that we are overreading or go ahead.
The example that I used was specific to pediatrics, not specific to the FNP. I was
Okay.
trying to find a completely opposite role that a pediatric nurse practitioner could potentially go into, which is why I was saying adult cardiology clinic. As an FNP, if you have the national certification as an FNP, you are able to work under the full scope of practice of that FNP as a 104, as long as you maintain your national certification. There is no limits to where you work. All of that group setting limits was only for the 103 section and doesn't carry over to the 104 section. So it is truly just within the limits of your education and your national certification and your experience.
Okay, perfect. I appreciate that clarification. And, you know, the pediatric was a perfect example because, again, no peds wants to work in an adult setting. So I appreciate that. And thank you, everybody, for your feedback.
Well, just to clarify, we do have pediatric nurse practitioners that work in adult settings, and they enjoy their job and they love it. So I just want to make sure that we're not calling that out for everybody and making a blanket statement, because we definitely have those that exist in California. So thank you.
Okay, appreciate it. Thank you very much.
Yeah, no problem.
All right, Board Member Neil Patel.
And just for further clarification, Lori, I was just wondering, so if a FNP wants to then, or obtains a ACNP, do they have to go through the whole entire process again, right? 103 and 104?
No. Previously, yes, we had to do a separate 103 for each one of those specialties because it was limited to the transition of practice that had to be done in that specialty area in order to advance. So Cynthia, who is known by many, and we've used these examples, she carries 2 national certifications. And so she applied for one and was granted, and would have had to do a separate transition of practice to get granted for her second one. That is no longer what needs to occur. So you move on as a 103 in any of your areas because it is not concentration specific. The 104 is similar to that, except we will put on as that 104 that this is the national certification that you hold. And so that is the area that you can work on as a 104. That is the population focus you can serve as a 104, not the area. So the setting that you work in is irrelevant at that point. Mm-hmm.
Before we go to a vote, any other questions or comments from board members? No? Okay. We have a motion and a second on the floor. Dolores Trujillo votes yes. Vice President Neela Patel?
Patel, yes.
Board Member Jovita Dominguez?
Dominguez, yes.
Board Member Patricia Nguyen?
Nguyen, yes.
Board Member David Lawler?
Lawler, yes.
Board Member Vicki Granowitz?
Granowitz, yes.
Board Member Allison Cormack?
Cormack, yes.
Thank you. Thank you again, Marissa. All right, moving on in the agenda, we're at item 7.0. This is the report of the Nursing Practice Committee. Neela Patel chairs the Nurse Practice Committee.
Okay, so agenda item 7.0 is information only, and it's regarding the report for the Nurse Practice Committee, and that report will be given by our EO, Executive Officer Loretta Mulvey. Thank you, Lori.
Thank you. So I will move through 7.1, 7.2, and 7.3. So, and then we'll stop and pause for public comment and stuff. So 7.1 is information only. That will cover 7.1 through 7.1.1 through 7.1.5. The Nurse Practitioner Advisory Committee has not met in between board meetings. Neither has the Nurse Midwife Advisory Committee. And the Nursing Education Workforce Advisory Committee has not met. So there is no updates on those. So I will provide updates on the Clinical Nurse Specialist Advisory Committee, as well as the Certified Registered Nurse Anesthetist Advisory Committee. So the first one to discuss is the Clinical Nurse Specialist Advisory Committee. They met on January 16th. We did do a report out of the subcommittees. There are 2 subcommittees that they have on there, the public engagement website and regulatory updates. They also presented regulatory text that the subcommittee worked with the Chief of Legislation, Marissa, and I to write and get out. And that language is in a good place, and we are moving forward with that. We also did a presentation on explanation of scope of practice and specifically utilizing the title of clinical nurse specialist. There are many healthcare organizations out there that hire people into a clinical nurse specialist role and call them a clinical nurse specialist, and they're not actually licensed as clinical nurse specialists. And so there's a lot of kind of information setting out there that there are specific requirements to be a clinical nurse specialist, and that you actually have to be recognized by our board and licensed pursuant to our statutory requirements in order to become a clinical nurse specialist. That came around in many hospital settings with pursuing magnet status. And as they pursue magnet status, one of the requirements is to have education provided to their current staff. And they do that through the use of education specialists that are nurses. And so the titling and stuff is kind of getting a little blurred in that setting. And they're calling them clinical nurses that educate, and so they're specialists. And so a clinical nurse specialist has a specific role. In other states, they have the ability to diagnose and prescribe medications. California, we don't work them to that scope of practice here or acknowledge them to that scope of practice. It would require a legislative change for that to occur. And so the primary focus of a clinical nurse specialist currently in California is education-based. And so that's why it is important to really make that clarification. So there was a presentation on that. And then speaking of the other scope of practices that occur outside of California, there was a presentation from the California Association of Clinical Nurse Specialists on future priorities, and that is to expand the scope of practice. And so they brought that information to us that one day they may want to get there to practice at the full extent of their licensure, their education, their experience, and their national certification. The next the next advisory committee that met was on the same day, January 16th, and that was our Certified Registered Nurse Anesthetist Advisory Committee. That was a very quick committee, so very happy that we were able to still hold that remotely. And hopefully there is some language introduced later on in this legislative session to allow Bagley Keene to continue to do that. If not, we'll all be back in person come January 1 for all of our committee meetings. And we put it forward to the CRNA Advisory Committee to kind of look at and see for the first time. And we received a lot of public comment around that, some in favor, some not in favor. And so we started working with that team and really drilling down on regulation, pulling in the Attorney General's statements, in the opt-out statements and stuff that come forward, and really looking at what we have legally scope of practice. And so there is some regulatory language out there that is being reviewed and mulled around. And the plan is to present that to our board come the May board meeting. At the same time, there was just a bill that was introduced by Assemblymember Flora that defines more clearly a CRNA scope of practice. And so that missed the agenda deadline for us here. So we will not be taking any positions on that when we get to the legislative section tomorrow. But just know that there will be two things moving simultaneously that our board will have to consider, and that's introduce legislation on CRNA scope of practice, as well as our regulation on CRNA scope of practice. The regulation language that will be moving forward will be on what our current statutory language has. So we cannot take into consideration of what maybe that bill has unless it gets passed before our regulation package does, and then we'll be happy to alter and move at that point. So those have been the really big lifts coming out of those subcommittees. We do expect to have some CNS regulatory language coming forward in this next calendar year, as well as the CRNA language coming forward in May. So fingers crossed everything moves well. And that's my report out for all of our advisory committees. Any questions?
Board Member Patricia Nguyen.
Thanks very much, Laura. It's always kind of nice to hear, what's going on. Why did the other three not meet? I mean, I don't have any kind of judgment about it. I'm just kind of wondering.
They meet twice a year, and they're scheduled to meet after this board meeting, so I will be reporting on the other ones probably at our next board meeting.
Thank you.
Any other questions or comments from board members?
I
I think we can go ahead and take it out to public comment.
Oh.
Board moderator, can we take it out to public comment, please?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, I would like to make a comment. Please remember you will have 2 minutes to make your comments. I will not give a reminder as the time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired and will move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Board Member Patel, there are no public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
Thank you, board moderator. We do not have any public requests for comments in headquarters. Thank you.
Thank you. Would you like me to close this window?
Yes, please. Thank you, Lori, for the information, and I think we can move on to the next agenda item.
Okay, so 7.2 is the next agenda item, and that is to look at the appointment of a nurse midwifery advisory committee member. We did have a vacancy, and according to the charter is we can get those applications in. I can review them and then bring them forward to the board administrative committee. And then once that selection is done, bring it forward to you guys for voting on it. And so the suggestion that came from the board administrative committee is to select Kim Dow to fill the nurse midwifery advisory committee vacancy. This person previously served on the NEWAC committee and has experience and actually resigned that position to come over here and focus more specifically on nurse midwifery practice. And so if you guys are willing, I would love for you guys to make a motion to accept the appointment of the nurse midwifery advisory committee member.
Thank you, Lori.
Sure, I'll make a motion to accept Kim Dow as the nurse midwifery advisory committee member.
I'll second.
Thank you, David.
Any opposition? Okay, we'll take the motion passes, no opposition. It's easy roll call.
We have
Or
to
do
go back to
roll
public
call?
comment, and
Okay.
then after public comment, we'll have to come back and do a roll call vote.
Okay, thank you. Let's open it up to public comment. Board moderator, please.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, I would like to make a comment. Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Board Vice President Patel, there are no public requests for comments on our WebEx. Do we have any public requests for comments there in your in-person location?
We do not. Thank you.
Thank you. Would you like me to close this window?
Yes, please. Thanks. We'll go ahead and take it to a board vote. We'll do it formally. President Trujillo,
Trujillo votes yes.
board member Trisha Wynn, excuse me.
Win, yes.
Board member Lawler,
Lawler, yes.
board member Cormack,
Cormac, yes.
board member Dominguez,
Dominguez, yes.
board member Granowitz,
Granowitz, yes.
and board member Patel, yes. The motion carries. Okay, now taking it on to agenda item 7.3.
Okay, so we'll open up agenda item 7.3. This is the same process, but this is for the appointment of a nursing education and workforce advisory committee member. And so in accordance with the Business Professions Code 2785.5, the board shall appoint qualified committee members. And so again, we did look for an advanced practice RN representative for the vacancy on the NEWAC committee. We received many applications for this role. It was narrowed down through kind of administrative process at first. One, just to ensure that they turned in a complete application and met all the requirements. Then at that point, it was submitted over to me to review. There were 3 very qualified applicants. I brought 3 very qualified applicants forward to the administrative committee. And on the administrative committee, we did single it down to 1 person that we would like to advance forward for consideration of the board. And so I would ask for consideration that the board administrative committee, after they selected Alice Benjamin to fill the advanced practice RN role, to fill the vacancy on NEWAC. And so if you guys accept, I would ask for a motion to accept the appointment of the Nurse Education and Advisory Committee member of Alice Benjamin.
Thank you, Lori. And I just want to say that I really want to thank the public for just seeking the opportunity to fill this position in NEWAC. We had, I think, 63 or something like that. And just to narrow it down to this one individual was very difficult, but impressive nonetheless. So we'll go ahead and take it out to public comment. But, oh, we have to take a motion first, right?
Yes.
So I'll go ahead and make a motion to appoint Alice Benjamin to the NEWAC committee.
This is Allison Cormack. I will second.
Okay, we'll go to public comment.
Thank you.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give reminders your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board Vice President Patel, there are no public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
We do not. Thank you.
Thank you. Would you like me to close this window?
Yes, please. Thanks. And we'll take it to a vote. President Trujillo,
Trujillo votes yes.
Board Member Nguyen,
Win, yes.
Board Member Lawler,
Lawler, yes.
Board Member Cormack,
Cormack, yes.
Board Member Dominguez,
Dominguez, yes.
Board Member Granowitz.
Granowitz, yes.
And Patel, yes. Thank you. Motion carries.
Okay, so before we open up into the next agenda item, which is 8.0, Report of the Education License Committee, we do need to elevate Dr. Mary Ann McCarthy in the attendees to make her a panelist, as well as, I know, Jovita, you typically chair this one. You're in the wrong seat of the House to do that. You're not able to see any of the motions up on the screen. Are you able to pull them up on your computer in front of you? Okay. I will have them up for our board president here to help with the motions as well as needed. But the way that our screen is set up in the room here in Sacramento is not super conducive to utilizing it for motions. So we will have this pulled up on our laptops here in the front of the room as well. And then going into 8.0, it was agendized differently this time. So I do want to call that out to make sure that everybody is aware of this process. Previously, what we've done is any of the ELC committee meeting agendas, after all of those items were taken, we would rewrite each one of them to put it in from committee language to board language, which then required our board staff to do a lot of work on the materials as well. She had to go back in and access every single one of the materials to change all of those to meet the new agenda item for the board meeting and then update all of that. It was definitely a very time consuming and really not super beneficial process to go through between the committee and the board. And that's not something that we have to do on any of our other committees, because a board, the board committees don't have to make specific recommendations to the board, where the ELC does. We had tried to streamline that process earlier, where it does come forward and we say agenda item 8.1.1 to 8.6 or whatever are items that were considered in the committee, and you guys typically make a vote that says, I accept the recommendations. So this new way that it is written in the agenda does reflect that. And what you guys have in your packet are the specific materials that were in the Education Licensing Committee, unaltered and moved forward in case you did want to review. What was additionally created last board meeting that is carried over to this board meeting is a printout, or not a printout, but a form that has the agenda items of the ELC, what the ask was and what the board motion, the committee motion was, and what the committee members vote was on that motion. So that should be a clear reference for you at that point. Understand that this is continuing to morph. I do appreciate Reza giving me the pass on this one to allow me to trial this as a process improvement. I know that we have some scheduled meetings immediately to follow this to see how it goes and see if we have to update this because we do still want to be very clear and very open with the public as to what is being covered so that the agenda is specific. And so this is a trial. I hope that it works. Dr. Marianne McCarthy definitely hopes that it works because it is her workload that I am addressing specifically here. And I know that Reza will work with us and give us some any fine tuning or anything that has to come to this to make sure that it's clear. Yes.
Well, I just wanted to make a quick comment. As a committee member on this committee, this makes a lot of sense to me. And it was very, very easy to go through. So I would be particularly interested in feedback from those who are not on the committee, because this is my second time through with this. So anyway, just something as we start.
Perfect. Thank you. Okay, and he's not on the committee, and he said it's very user-friendly. So my fingers are crossed. I would love to do this process improvement. Okay, and so at that point, thank you for the lengthy introduction and understanding why you guys saw the materials differently. Coming from committee to board, we hope to continue this. There will be some tweaks just to make sure that we stay in compliance and we get additional feedback from legal counsel on that. So we will open it up to 8.1. Jovita, do you have your stuff pulled up now in front of you? Awesome, go for it.
Good afternoon. My name is Jovita Dominguez, Chair of the Education and Licensing, and Dr. McCormick is going to lead us. Thank you.
Hi, good afternoon. This is Mary Ann McCarthy. I am a supervising nursing education consultant and the liaison to the Education and Licensing Committee. Before we start with 8.1, which is the consent agenda items, I do want to clarify an enrollment pattern for Unitech, which is in the materials on the ELC agenda, that motions chart we were just talking about, the little thing that shows each of the schools that were heard and were consent agenda items. It's on page 6, and if you go to Unitech, you'll see there 8.6.5. And there was one typo in the slide that had all the materials were good, but when we put up the slide that we used for the motion, there was one typo in the slide. So I just want to make sure that we're all clear in moving forward. And there's a little asterisk in this box, 8.6.5 in the right-hand column. It says the frequency has been updated to reflect the ask. The motion will be clarified at this meeting. So that's what we're talking about, that section right there. It says the slide at the ELC meeting was incorrect. It said the total number of students is correct. It's 160 students annually, but instead of 40 students 3 times a year, which is what it said, it should have been 40 students 4 times a year, which would equal the 160. So I just want to ensure, especially, for Trish and Jovita and Dolores, that this makes sense to you, that we just had a typo on the slide and, the slide we use for motions, and that you and the board are okay with that update.
Yeah, I'm fine with it.
Yeah. Oh, Dominguez is fine with it.
Okay. Okay, you're okay, Trish?
Yes, I am. Thank you very much.
Okay. So then we're going to move on to agenda item 8.1. And so just as a note, the items in agenda 8.1 on this new format that we have will be treated as consent agenda items unless a board member or somebody in the public says they wish to pull something out for further discussion. And the list of the schools and the associated motions, that's the one we just looked at. That has all the things that went through and the votes for the ELC. Okay, so 8.1 is discussion and possible action regarding the ELC recommendations to the board on items presented at the January 22nd, 2025 meeting of the ELC. A copy of the 1/22/25 ELC meeting agenda is available, and in the materials there's a link to it. Actions under consideration include the approved curriculum revisions, the acknowledgement of program progress reports, the exception of clinical facilities and clinical sites for programs, the continuing approval of pre-licensure nursing programs, the continuing approval of advanced nurse practitioner programs, and the deferred action on continuing approval status of an approved nursing program. And also the acceptance of the substantive changes that are on the list, and anything that wasn't on the list will be presented today. So there'll be 2 items presented today as far as programs. So if you're okay with all that, if you have any questions, let me know. Otherwise, we will put a motion for consent agenda items contained in 8.1.
Anybody, any board members have questions? Okay, so then I will accept the recommendations of the Education and Licensing Committee for all items contained in 8.1. Do I have a second?
Wait seconds.
Thank you. And I apologize, Dr. McCarthy, for not naming the correct last name. Do we take it to public comment?
Yes, please.
BRN moderator, please take us to public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board Member Dominguez, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in your location?
None, thank you.
Thank you. Would you like me to close this window?
Yes, please. I'll take it to a vote. Dominguez votes yes. President Trujillo?
Trujillo votes yes.
And Vice President Nilo Patel?
Patel, yes.
Allison McCormick, member?
Cormac, yes.
Member David Lawler?
Lawler, yes.
Member Vicky Granowitz?
Granowitz, yes.
And member Nguyen?
Nguyen, yes.
Thank you. Motion carries.
Thank you very much. We're going to move on to agenda item 8.2. This is the discussion and possible action regarding acceptance of a substantive change to an approved program. This is Samuel Merritt. It's their entry-level master's and their baccalaureate degree nursing program. It's an enrollment increase of their Sacramento campus. Information on this program can be found starting on page 121 of the packet. Board moderator, if you could please elevate the presenters on the list for Samuel Merritt. Okay, so at the January 2025 Education Licensing Committee, Samuel Merritt requested an enrollment increase for their BSN and ELM programs at two sites. One was an Oakland site and one was a Sacramento site. The Oakland enrollment increase was recommended for approval by the board, and that was on your consent agenda item above. However, the Sacramento campus was asked to, the ELC committee asked for that to be brought forward today for the full board to review. If you look in the materials, you'll see their current enrollment pattern for the ELM at the Sacramento campus, which is 48 students twice a year with an enrollment increase of, I'm sorry, for an annual enrollment of 96 students. That's what they currently do. And they currently, for their baccalaureate program, they do 48 students twice a year for 96. So right now they're doing 48 twice a year for both programs at the Sacramento campus, 96 per year. What they're asking for is to increase the entry-level masters by 24 students once a year in the fall. They want to have 72 students in the fall and 48 students in the spring. So the annual enrollment will go from 96 students to 120 students for the entry-level masters. And then for the baccalaureate program in Sacramento, they want to increase by 48 students, adding a summer enrollment. So there'll be 48 students 3 times a year. So the annual enrollment will go from 96 baccalaureate students to 144 baccalaureate students. So the total increase for the Sacramento campus will be 72 students. This area is in Region 1, Sacramento. And so on page 124, you'll see our data report of what has happened with the school and then also in that region. And as always, each program writes an executive summary that they submit with the material to us with the materials, and that starts on page 125. The representatives from Samuel Merritt are here to, and I see a message from the moderator, so let me see, we might need to get them up, but if we do, we will do that. Oh, well, he says, I never sent him a list, so let me help you. I think, well, let me help you. Stephen Rush, who's the program director, should be S. Rush at Samuel Merritt. Jimmy Reyes, Carmen Ward Sullivan, Brian Clockson, Clocksin. He is the provost, so there should be 4. Not Abdel. He's Unitech. We don't need Abdel. I see Brian. I don't see Stephen. Do you see Stephen Rush?
Stephen is in the attendees, so they'll just need to find him and pull him forward.
Okay, we'll do that. And then Carmen Ward. Well, it's Ward Sullivan, so it says C. Sullivan if it's by email.
She's in the attendees as well as Carmen Ward Sullivan.
Okay, we'll just give Mark a second to find everybody. But I do see Stephen. Hi, Stephen.
You have
Hello there.
Okay, and I see Brian. Good. Okay. All right. We are, board members, we are ready. If you have any questions or concerns.
I did just receive an email that says that our board member emails are not online. That is accurate. We do not have our board member emails online. That could be something that we address. And they said that they were trying to reach out to the board members and they're not able to attend the meeting. But they did want to share some concerns with the Samuel Merritt expansion. So what I will do is I will take this email that I just received. I will ask for it to be posted as materials in alignment with what is required here, and I will read this out loud to you guys. It says, I am unable to attend the board meeting this week because of my work schedule. However, I see that Samuel Merritt expansion is on the agenda, and I wanted to share the concerns that I shared directly with Carmen in October of 2024. The proposed expansion is not small, and the Sacramento region is significantly impacted with the school growth. I would like to share these concerns directly with the board member. However, I'm unable to locate board member emails through the BRN website. Are you able to assist in forwarding this email or pointing me to board contact information for board members? And this is from the Betty Irene Moore School of Nursing at UC Davis, their director, Shannon Ruggenberg. And so what I will do at this point is take this email and I will put it on board materials. So I'll send it over so that it's accessible for everybody.
Thank you, Lori. Board Member Allison Cormack.
Are we ready for questions and comments? Great. Okay. Yes?
Yes, please.
All right. Ms. Melby, then does that mean that where we have on page 122, 2 programs were not in support of the enrollment increase? Is the Betty Moore program now the 3rd?
It looks like that is what it is. We had carried over the information we'd received for the Education Licensing Committee.
Okay.
And now this is a email that I literally just received minutes ago.
Okay, so maybe one of the 19 who had not responded, or perhaps one of the 3 that had scheduled a follow-up meeting. Okay. So as always, I spent some time looking at the data, and I have to say the NCLEX pass rates have been in decline for the BSN program I see over time, and the ELM ones are certainly below the state average. Attrition is good. So that NCLEX pass rates are always a big one for me in terms of whether or not to expand a program. And then I spent some quality time on our BRN School Survey Interactive Dashboard, and the region is Greater Sacramento. Is that right? Okay, because we use different terminology online than sometimes in here, so I want to make sure I got that right. And if I look at the BSN one, the most recent data we have for, and again, I'm looking at clinical spaces lost and students impacted. Traditionally, not traditionally, but many places we see this declining post-COVID, right? Getting better and better. And there was a post-COVID decline for BSN clinical spaces lost and students impacted in Greater Sacramento, 21-22. But then it more than doubled in 2022-23. So that's a concern. The ELM one was steady, both for placements and number of students impacted. But the BSN one certainly, again, we do not have perfect data, but this is the data that we have, and it's the most recent, suggests that clinical impaction is increasing in this region. So it's concerning for me to see declining NCLEX pass rates over the past 5 years, plus an increase in clinical spaces lost in this area. So those are the things I'm thinking about, because these are the part of the 4 things that we can consider.
Any other members?
Board Member David Lawler.
The only other thing I would add to that, because I agree with you, is from past experience at each board meeting, this comparatively is a large ask. It seems like a big increase in such an impacted area.
Vicky?
Can we hear from the applicant?
Sure. Do you have specific questions?
No, but I'm sure they have specific things they want us to know.
Okay.
Assuming that's an invitation for.
Yes, please,
Okay.
Stephen. Thank you.
Thank you, Board Member Granowitz. Yes, I do have a few things that I'd like to share with the full board here. As Dr. McCarthy shared, we were before the ELC last month with 2 different requests for 2 different sites, Oakland and Sacramento, and is very appreciative of your support of our Oakland increase. But as far as the Sacramento goes, when we did meet with the ELC last month, we had met and exceeded really all the requirements needed to have an enrollment increase. Of the 4 that you mentioned, we've met all of those. There have been some decreases, as you mentioned, in our NCLEX, but we've also in the last year or so been bringing those back up well above the 75%, which the board requires for any consideration of an enrollment increase, well above that. And I do really appreciate the feedback the ELC gave us last month. They offered multiple examples of anecdotal evidence that gave them pause really to granting this increase that some of you have mentioned as well. And I understand it, but as I understand it, there were no issues or concerns with our actual requests, our materials that we submitted, and our ability to meet the requirements for that enrollment increase. And, you know, again, as I understood it, the primary reason for them wanting, the ELC wanting to defer it to the full board was lack of clinical, the scarcity of clinical rotation sites in the Sacramento area specifically. The research and documentation that we conducted along with the multiple forms, the EL P18s and all of our clinical agreements clearly support that we have the clinical resources needed for these enrollment increases. As you know, San Luis Merit's been a very respected and valued healthcare partner in the Bay Area now for over 115 years. We've established, and with that, we've established a really strong reputation with hospitals, clinics, and community practice sites. We're also continuously establishing new clinical partners, and in fact had one such partner speak at the ELC meeting that they're able to provide enough clinical spaces and experiences to support all of the med-surg, psych, and mental health and geriatric rotations from their site, solely from their site. And they were there to support that. Therefore, we do request that our enrollment increase for Sacramento be granted based on the fact that we did meet all the requirements for that. Now, if you, upon further discussion and consideration, feel you can't support that, I do ask that I be able to address you once again with a secondary request. And I'll pause there, but I'll also ask if any of my colleagues who are on the call wanted to add anything to that.
So real quick before we move on to the colleagues, I have some area of clarification that I do need to address and clarify for our board members as well as our public to understand here. So on Business Professions Code 2786.2 that specifically address what we as the board can consider for enrollment increase, it was brought up that it is well above the pass rate of 75% for NCLEX. That is not a correct interpretation. So I want to make sure that that is very, very clear. We have a regulation that talks about first-time test taking NCLEX pass rates that we put schools in either compliance or non-compliance with. Non-compliance means you drop below 75%, and that means you're not in compliance with all the law, right? So at the less than 75% for first-time test takers, we actually require an action plan from the school. And they work very closely with their NEC, and we work towards bringing them back into compliance and at least understanding that they have an action plan in place addressing what they have identified as the issues. If they go into second year and NCLEX pass rate less than 75, we do a visit. We go out there and we take a look at everything that's going on, and that is a much more extensive review, and we bring them back in front of the board. When we look at the law that is being referenced right here, it says when considering a request to increase enrollment, the board may consider only the following factors related to the ability to adequately train additional students. And that does say that you guys can take into consideration the licensing examination pass rates, graduation rates, and retention rates. It does not set it at greater than 75, and because they're above the threshold, that's fine. If you guys see a declining NCLEX pass rate, that is an area of concern. We had a presentation done at a prior board meeting this year, and it probably got lost because it was when we were having a bunch of intervention participant public comment and issue there, where a education specialist from the National Council of State Boards of Nursing came in and gave a presentation on the approval of schools and why this is very important. And one of them that they said is the NCLEX pass rate. And that NCLEX pass rate is a latent response. So by the time that you see an NCLEX pass rate start to drop, that means the issues that are possibly occurring at that school have now trickled down enough to affect the student to have that. That is all evidence-based. I can pull up all of those reports that does come from the National Council of State Boards of Nursing. So that is why in this law, when we were going through that sunset process, I said, no, we have to be able to consider licensing examination pass rates because that is an indicator of a program that may be doing amazingly well or may be starting to have some issues pop up. And so just for that clarification, I'm not saying that I know anything that's going on with Samuel Merritt and why their NCLEX pass rates may be trending down or having a blip or anything like that. I'm just trying to correct the statement on the interpretation of that law and what that means. And it is not that if they meet 75, then they are considered for an enrollment increase. It's that you take into consideration those rates and make your determination based on that. The other one that I want to address is that the availability of clinical placements. Availability of clinical placements is much more than just saying, I have signed agreements with these clinical placements. And in fact, the ask for us in our law are in two separate areas. And in 1427, we actually approve the use of the specific clinical placement. It actually asks the program to consider the impact. And so what that states in 16 CCR 1427 D, it says in selecting a new clinical agency or facility for the student placement, the program shall take into consideration the impact that an additional group of students would have on students of other nursing programs already assigned to that agency or facility. And so that's where that comes into play. It is in the hands of that academic institution to say, okay, I want to go to hospital A. I see 3 other schools having clinicals at hospital A. I need to find out what inputting one group of students here to me that I want there affects those 3 that are already there. And that's the information that is typically brought forward to our board. And that is for any clinical approval, including those that lead to an enrollment increase. The next section is when we look at new program approvals and new campus locations. And there is a form that is referenced in that law that talks about evidence of available clinical placements for students of the proposed program. They need to include the list of clinical facilities that may be utilized for learning experiences, the descriptions of any future plans for expansion into those health care facilities, and they have to take into consideration the impact on the use of a clinical facility by existing pre-licensure RN programs and must be coordinated with any process for clinical placements, such as the Consortium for Regional Planning. And it says to include a description of your collaboration and coordination efforts with any existing registered nursing program and any regional planning consortium. And so I get meetings where they say, oh, it's not in law. It is. Theirs is on the 1427 clinical placement approval, where they have to take that into consideration. And then you guys, when doing an enrollment increase, would take that into consideration. Your new campuses and your new programs, look at this last one that I read. And that is how, when you guys look at these, the law that says this is what you can consider, that's where that comes into place, where you look at availability of clinical placement. And it's not that they have contracts, but it's that they have clinical placements that they can utilize after they've taken into consideration the impact to the currently approved programs that are using those clinical placements. So you might at this point want to ask for some clarification around that to see if there are other people using those sites, and if so, what they're doing to coordinate with that, if that is a concern that our board members might have.
Board Member Patricia Nguyen.
Thank you very much. Thanks, Lori, for that. You know, the thing about this request is that it's not coming into a vacuum, right? It's adding into a mix that we have data on that is a heavily impacted area. I would just remind the board that we turned down a campus fairly recently in this region because we said it was too full. And then to approve something like this, it's, it kind of affects my sense of fairness. So I do struggle with these so much. And they come every 3 months. We look at them. I'm not in a position to support this today. And I know, Mr. Rush, that you have a secondary proposal and this might be a good time to talk about it. But of course, I'm interested in other board members' perspective. Thank you.
Board Member Lawler?
I agree with you. And I would add to that the reason it's a challenge or it's difficult to deny is because it's not a statement against the school. I think it's commendable that they have done their part and their work and have met the qualifications and have done the paperwork they need to do to make this happen. But the sad reality is there are factors beyond their control that they cannot do anything about. And the analogy that I was thinking of while he was speaking was one visit a couple of years ago to San Francisco, standing in a Starbucks, staring across the street at another Starbucks. I've never seen that before in my life. And I thought of that wondering who's going to be approved to build another coffee shop on the same block. That's simply the reality of the situation. So my vote isn't anyway making any statement against the school. It's just the reality of the situation we're in right now up here.
Member.
This is
I'm
Vicky.
sorry. Go ahead, Vicky.
Yeah, I guess the sort of overarching problem I have, not with just this application, but with all the applications we see that are going into impacted areas that we've turned down previous applicants, most of whom have terrific programs, do great work, and yet they keep coming. And the situation hasn't changed. They're still impacted area. You still can't squeeze water from a stone. Y'all know that. And yet you keep coming. So it's kind of feels like a little bit of insanity to me. Do you think somehow that the conditions are all of a sudden going to change from one quarter to the next quarter? I mean, we know we need nurses. We get that. You're a great school. No one is denying that. And yet the math just doesn't work. And so I'm with my colleagues, but that's a question it just feels like it doesn't make sense to me.
Member Allison Cormack.
Thank you, Committee Chair Dominguez. I'm just going back and looking at the data. And so the one that was, I guess it says deferred, not denied, was deferred, was a new campus of 135, which I do think feels like a slightly different category than a smaller number expansion at one. That it just feels different to me in terms of existing placements, et cetera. I understand that numerically a new student is a new student. So I just wanted to add that to the mix here as we think about what to do.
I would just like to make one comment. I have noticed that the Sacramento area, I work in the Sacramento area as a nurse, bedside nurse, and I have noticed students coming into our hospital, my hospital, and a lot of them are worried that they're going to find a job when they get out because there's very, very few new grad programs out there. Now, I know Samuel Merritt takes ADN RNs and into their BSN program. And those nurses have employment already. But the majority of students that are coming into my hospital are stating that they are concerned whether they will have a job when they get out or not. We are becoming slowly impacted, not as much as Southern California yet, but with all these enrollment increase requests, We will get there if they are all granted. So at some point, we need to put the brakes on and really look at this and evaluate it, not just for the area, but for the students. We're doing them a great disservice to go through a program and they can't find a job when they get out. And they may have to move out of the area or even out of state to be able to work and support their families. So we need, the board here gives every enrollment increase a lot of thought. And I know a lot of you don't see that from seeing us sitting up here, but we are thinking about this away from here and how we can best serve those students who are going through your education programs in hopes of making a better life for themselves. Thank you.
So this is the part of my job that I don't like, and I have to actually contradict my board president. So I appreciate you sharing that, but I need to make sure that our board members know that they cannot take that into consideration when evaluating a school to see if they can do an enrollment increase. And so I'll read the section here that says, any other similar factors specified the board in regulations. We don't have any regulations, but then it does specifically state the board shall not consider nursing workforce issues, including those identified under 2717 as factors for purpose of this subparagraph. So yes, we hear that students may be experiencing some difficulties in finding work after graduation, but we are specifically forbidden by law to take that into consideration. I do appreciate you, Dolores, and I know that you're my boss, but I do have to clarify that the law does not allow us to do that.
Understood. Thank you, Lori.
So am I allowed to address
Yes,
the
go
board?
ahead,
again?
Stephen.
I don't want to interrupt anybody.
I'm
Yeah,
not
go
sure if
ahead,
you heard
Stephen.
it, but they said, yes,
Oh.
Stephen, you can.
Yeah, go ahead and give your
good.
other proposal, and thank you.
Okay, well, and thank you, EO Melby, for that clarification. I wish you could consider it because we have a 98% placement rate and for our new grads when they do graduate. So our pass rates have, when you do look at the pass rates, the ABSN, this is an accelerated Bachelor of Nursing program we're asking for the increase in, and BSN are not pulled apart in the reporting. We pull that apart ourselves. Our own internal team pulls those apart. And so our ABSN pass rates for last year were 94%. And our ELMS was 84% when you pull them out from the BSN. So I just want to make a point of clarification that we have some pretty respectable pass rates. And I appreciate all the kind comments about this is not anything specific to Samuel Merritt. I too, I'm not sure which one of you said this, but I kind of chuckled because I do think this kind of seems a little insane, right? That all the schools keep coming every month asking for this. And what we heard from you in the ELC last month is that Sacramento seems to be so impacted that you've deferred a previous school now that you've deferred us. So I'm wondering but we've also seen in the past where maybe you might consider a smaller increase. And so if we even ask for half of this increase, I think, and I'm also going to add this to another comment that one of you made, is that thank you for the clarification that this isn't the same. I'm not saying anything against the other school that was deferred, but we're a very different entity and we've been around a long time and we have really strong clinical placement relationships. So it's one thing to start a whole new school with a brand new cohort and try to establish those clinical partnerships versus one that's been around for 115 years. So I guess that would be my request, is that we would be able to have at least a partial approval of these numbers. Because I've seen that play out before with other schools. So that's my request.
Would you be able to give us numbers?
Sure. For the nurses in the room, we always like to do multiples of 8 because 8 are how we find our clinical placements in a cohorted model. And we had requested 24 for the ELMS. Perhaps we could do, what would be 16? That would be 2 groups of 8. And for the ABSN, we had requested 48. So maybe we would request 32 or 24, something like that. So multiples of 8 always work well.
So play that out for me, Stephen. So with the ELM, just for clarity, the ELM would be, let's say that if we would say 16 students twice a year.
It would be 16 additional students,
Total, and you do
actually,
8 and 8, or because you have them split up so many times a year, right? So like your Elm students, you have some in the fall and some in the spring. And with your was it your Elm or your BSN? Somebody you were going to, I think it was BSN, you were going to add your summer cohort. So we have to kind of look at that as far as how it plays out frequency wise, as opposed to just cutting it the number in half or whatever the case may be, because we don't want to also put you in a situation where we've cut it in half but it doesn't work in the summer, or it doesn't work twice a year, or it doesn't work 3 times a year. We have to like have a pattern.
Yeah, I hear you, and what I would request is that it be the same admission pattern and frequency. It's just those reduced numbers. So the
reduced
summer
total
cohort,
number.
Yeah, so this total cohort, summer cohort for ABSN of 48, if we did 32 or 40 or something like that, it would still be a summer cohort, because I agree with you, this is what we've based all of our clinical placements on. This is who we've gone out and spoke to the hospitals and say, hey, can you take them in the fall? Can you take them in the summer? So Elms would be, again, would be that reduced number, but in the fall.
So for clarification, the ask in front of us right now is for the entry-level master's program. They originally asked to do an increase of 24 students annually. And what the enrollment pattern was 72 students in the fall and 48 in the spring. And so can you tell us how those numbers would work for you, Stephen, so that obviously it wouldn't be 72 in the fall and 48 in the spring if you were asking for 16 instead of 24?
Yeah, I'm going to actually defer to our Associate Dean for Graduate Programs, Dr. Carmen Ward-Sullivan, who's been elevated. She can talk about those numbers.
Okay.
Because I think there was an error when you first presented, Dr. McCarthy, for the current numbers. But Carmen, if I could defer to you on that.
So, and Carmen, as you come forward to talk about this, I would like you to address the entry-level masters first. And then once we get that clear, then go to the accelerated bachelor's program so that we can consider these separately.
Okay, great. Thank you. Good.
Carmen, it's on the slide. I don't know if you can see the slide, but that might be helpful, because this is what we have as your request as it stands. And if we're going to adjust it, it would be clearest if we could adjust it based on this.
Okay, sounds good. I do see an error, because for Elms in Sacramento, we admit currently 1 cohort in the spring of 48, and then we admit 1 cohort of Elms in the fall in Oakland of 48.
Well, we took Oakland out of this. I apologize. I took everything for Oakland out because you've already been approved for that.
Correct. But when I see the number of 72.
Oh, it looks like Oakland's still there.
Yeah, yeah.
Okay, so thank you. Let's fix it then. Fantastic.
Thank you. So the 48 for spring for Sacramento, and then the 16 that Steve has referenced just now would be fall. It would be great if you all agreed to add the 2 additional clinical sites in Sacramento in spring, so that we admit a total of 64 total annually in Sacramento. So that's with the 2 additional cohort of clinical groups, for Sacramento, for Elms.
So let me clarify again. So you're saying your current enrollment for Sacramento entry-level master's program is 48 students annually in the spring.
Correct.
And you're asking to add 16 to the spring and 16 to the fall?
16 to the spring.
Just 16 to the spring. So there is no fall enrollment. It would still just be 1 annual enrollment for the spring, going from 48 to adding the additional 16 there to be 64 is what you said.
Correct.
Correct. Okay. So then that's an increase of 16 here, and that's just to the spring. So there is no fall enrollment for Samuel Merritt proposed for the entry-level masters. Now, the accelerated BSN program, it says that you currently enroll right now I just want to make sure that it's clear. It is 48 students twice a year, and
That's
you were asking to go to 48 students 3 times a year.
That's correct.
Is that's accurate? And from 48 students twice a year, you wanted to add a summer cohort. And the consideration now is to go from 48 to 24. What we have heard previously from nursing programs throughout the state is that in order to retain staff and clinical placements, that additional cohort or additional start should be the same as all of the others. And are you saying that with an addition of a summer cohort of 24, not 48, that you would be able to maintain your faculty for the summer and your current clinical placements for the summer, and that it would not have an effect? Or would it better serve you guys as adding 12 students to the spring and 12 students to the fall and not adding a summer cohort so that you can maintain your staffing and clinical placements as they currently are versus adding another rotation in there?
We would not have an impact because we do have plans, and I believe that's in our documents, and Steve can correct me if I'm speaking incorrectly, but we do have included plans for the increase in the number of hiring faculty. We currently have faculty in our BSN program where the summers are off, so we do have availability of faculty currently.
Got it. Now, what about the clinical placements? Because obviously those are clinical placements that have not been used in the summer before. And so I see where you can manage your faculty that way. How does that affect your clinical placements that way?
We do have clinical sites, and Steve, do you want to mention Carl?
Yeah,
Yes.
we do. And so, EOMLB, the ABSN program goes, as you know, and I'm sure most people know, it's a 1-year intensive program, right? It goes all year round. So whether you're a spring start or a fall start, you still have clinicals in the summer. So we have clinicals year round in the Sacramento area. So that makes it actually quite easy to rotate them through. So, and if you add to that, it's I know it's impacted in Sacramento. I'm not arguing that one bit, but it's less impacted in the summer because of the traditional BSN programs that aren't teaching in the summer. And so when we reach out to our clinical partners, they're always elated to hear we can rotate students through the summer. That's
So
the
I guess my
period.
question and kind of statement with that is you would be doing a separate enrollment in the summer. And as you said, it's an accelerated 1-year intensive. So they're going to go into the spring and fall rotations as well. So it's not like it's not like your curriculum is set up that if you enroll in the summer, these are only going to be a summer cohort. And that's going to go this summer, and then they'll skip and only go in summer. So
Exactly.
clinical impaction is still going to be the same.
Yeah.
It's just they're starting in the summer, therefore then probably ending in a summer a year later. But they're still going to go into the clinical rotations in the spring and the fall and have the same impact for our
Exactly.
board to consider. Okay.
Yeah,
Thank you.
exactly.
So your ask on the table right now is entry-level masters, increasing it by 16, but leaving it as a same annual enrollment for spring, moving it from 48 to 64. And then you currently have an enrollment in your accelerated BSN in Sacramento as 48 twice a year. And you're asking for 48 twice a year plus 24 in the summer.
Absolutely. That's amazing that it's so many numbers and shifting pieces that, yeah, you got it out on.
Thank you.
Member Cormack?
Thank you, Chair Dominguez. Okay, so so this is a 25% increase in both programs, an ELM and an ABSN. So, just to sort of calibrate it. I guess one thing that hasn't come up before is I wonder, of the ones that we've approved before, do they object when the next school comes? And this isn't a question for the applicant. I don't want to put the applicant on the spot. That's not what I'm saying. I'm just thinking that there's like another component of this that we're not really getting, which is we don't know who's objecting necessarily to what. So if as as board member Granwood said, people continue to come forward and ask for more, even when there's uncertainty or rejection, like I wonder, how people who recently got increases think about the people who are coming next, right? The programs who are coming next. There's nowhere to go with that. But I'll just say that the extended discussion has been helpful, and I very much appreciate the applicant's demeanor and approach and details. And 25% seems reasonable given the number of, clinical placements forms that have been produced. This is always a bit of a struggle, and but this seems more in line with what might be manageable than some of the things we've seen before. So that's what I'm thinking as I listen to our collective discussion.
And just for reminders, one, I did see that Vicky's got her hand up, so we will go out to Vicky before there's any kind of motion. And then I think Tricia does too. The clinical forms that are turned into us are from the clinical site and not from other academic institutions. And so I need to make sure that just everybody listening to this and hearing this means that you have engagement from a healthcare facility saying, I'm willing to give you clinicals. It does not address the impaction to the other schools that already have students in there that may be using those same facilities. So when the board is considering that impact, that is not able to be discerned from the forms that are turned in. But it does come in when you look at that data bank that is on our website that Allison, you said you kind of just went in, deep dived into it, went down rabbit holes and all that kind of stuff. It's definitely easy to do that. The other thing that I do want to make sure that although we are considering 2 degree types, that our licensing requirements are identical for both. Right? So when we look at the clinical impaction, it is clinical impaction for OB, Peds, Psych, Mental Health, Jerry, and Med Surg. It is not because I'm getting an entry-level master's, I have different clinical expectations. The expectations are still licensing expectations, and they are identical no matter what degree type you're offering. So even though them from their business plan and degree granting type have changed it out to saying 16 for their ELM and 14 for their ABSN, that is a total increase in licensure requirements, clinical expectations for that area. And so just to make sure that I know we sometimes get kind of lost in like the schematics of the various degrees, the licensing requirements are the licensing requirements. There is no degree attached to that, and every degree type has the same requirements.
Member Granowitz?
Yeah, I actually am having a reaction to this because you clearly had a pretty good idea we were going to say no. So you had a fallback position. That fallback position didn't get included in the documentation. It didn't get made clear to the public or the people in the area. So it didn't give them an opportunity to decide to maybe participate in the conversation. So I think there's a failure for the public to know what's going on if we do this. Additionally, I still think it's still squeezing water from a rock. I might have been willing to consider it if it had been included as your first ask rather than a sort of a salesperson's, well, it's a typical sales thing that you come in asking for more and you're going to settle for less. My father was a salesperson, so let me put it this way. When I dated, I never dated salespeople. So I just think that I would persuade my fellow people to seriously contend either turning this down or deferring it. But I'm not voting for it today.
And then Stephen, I'm going to come to your rescue just a little bit here. Stephen is very versed in education licensing committee as well as board meetings because he was a prior board member for the state of Wisconsin. And so I don't necessarily think that he's coming forward as a salesperson, but he does know the process in and out and has a wealth of information. He once served in your guys' roles in a different state. Thank you.
Really good. Thank you for that, EO Melby. I'm going to apologize.
Before you speak up, if I could just make a quick addition, this is Rez of the Board Council. I apologize for the interruption, but I wanted to piggyback on Vicky's comment regarding the notice to the public about what's to be discussed today. I always am appreciative of a close attention being paid to members of the public having a clear understanding of what's to be discussed so that they know whether they want to show up and take the time out to participate. In this particular case, speaking from strictly a Bagley-Keene Open Meeting Act perspective and whether there was adequate notice to take action on this today, given the possible modification to the request. I appreciate Vicky's attention to that issue, but under this particular situation, I think that the public has adequate notice that this specific school is being considered for an enrollment increase. So even if the numbers aren't quite the same ultimately as for what we're considering as what was put forward initially, I think there's still sufficient notice that they knew what was to be discussed. Now, in a hypothetical different scenario, if the school had made a small request for an enrollment increase and then the day of the meeting it had flipped to something much bigger, I think that would be an entirely different situation where members of the public might have changed their wishes on showing up. So just strictly, again, from a Bagley-Keene standpoint and the ability to take action, should the board so choose, I think you're fine there. Now, if you still want members of the public to have, further notice of this, that's your prerogative to go beyond Bagley-Keene.
Real quick, I don't want to put a chill on the play like we're calling this, but I have a couple board members that are saying they need a bio break. So before we continue this discussion and go out to public comment, would our board consider a quick bio break? My board president is dancing.
Too much information.
Yeah. We're fine. And then there's two members that want to speak. If we can do a bio break. Should we say 10 or 5 minutes?
10.
10.
Should be fine.
10.
Yeah. We'll come back at 3:10. Thank you guys for your patience.
Thank you.
And we will open it back up.
Roll call. Dominguez, present. President Trujillo,
Trujillo, present.
Vice President Patel,
Patel, present.
Member Cormac,
Cormac here.
Member Nguyen,
Present?
and Member Lawler,
Lawler present.
and Member Granowitz.
Granowitz present.
And that's it. Okay, we will continue on. I believe Tricia Nguyen had a comment.
Yeah, thanks very much. You know, I understand the concern that you have, Board Member Granowitz, but the truth of the matter is a lot of the schools don't show up for comment at these hearings. This is the second committee meeting. Of course, we'll open it up for public comment. I'd really like to align my comments with Board Member Cormac, who said, you know, this is a difficult decision every time we have to face it. I do feel like it's been amended to be a more reasonable request, and for that reason, I will be supporting a motion.
Vice President Patel.
Patel here. I just wanted to commend Mr. Rush for having a Plan B to think of quick action, because I came in here completely conflicted, especially because the last time during the last meeting, we had denied Sacramento School because of, you know, the placement situation. However, you came in with a lower number, a more reasonable option that wasn't presented to us at the last meeting by the other school. So, I mean, taking into consideration, you know, you did come to us seeking something that would be more of a compromise, I think is a lot better and easier for me to, a better pill for me to swallow at this point. So I just wanted to commend you on that.
Thank you. I do have one question, Dominguez here. The other schools that the hospital said that you can do all your rotations, will they not be affected?
I can respond to that. Thank you for the question. It's actually a site that has no students. And so we would be the only students that would be in that site. And it has approximately 350 beds on 4 locations. And so we would not be impacting another single school in those rotations. And he was, I'm sure it's in the record, he spoke to that at the ELC meeting last month, that the director of those facilities actually attended and spoke on our behalf. So it would be no other schools impacted at all.
And then just so our board members know, that is not all clinical sites, because they were not able to supply OB and pediatrics.
That's correct.
At those locations, and those are our most impacted areas. If the board is ready to make a motion, I would like to be the one that reads that motion with those changes, and then someone can just say so moved, but still let me know when that time comes.
I totally appreciate that. Any other members have questions? Then I believe we're ready for that motion. Thank you.
Okay, so the motion on the table would be to recommend acceptance of the substantive change requested by an approved program and approve the enrollment increase for Samuel Merritt entry-level master's and baccalaureate degree nursing program with an enrollment pattern of the entry-level master's program at their Sacramento campus to go from 24 students, increasing that by 16. I'm wrong. Let me back up. 48 students that are enrolled in the spring annually, increasing that by 16 in the spring to equal 64 students annually. And then for the accelerated bachelor's program at their Sacramento campus, instead of 48 students 3 times a year, they will go from their original 48 students that are twice a year in spring and fall to twice a year spring and fall, with 24 students going added into a summer cohort. And so at that point, if that's something that you guys agree with, you can do so moved.
Dominguez, do I have a second? I say yes. Do I have a second?
So moved.
Oh, so moved.
And so now we would need a second.
I'll second. Win.
Thank you, Wynn.
And then we do need to go to public comment.
BRN moderate.
I'm sorry.
Sorry.
Chair Dominguez, could we just clarify the ABSN Sacramento one, because that went by pretty quickly and I think potentially could be confusing. Could you try that just one more time?
So 48 students right now, they enroll 48 students in spring and fall. They would do 48 students spring and fall, staying the same and adding 24 to a summer cohort.
For a total then of 120.
Correct.
Thank you.
BRN moderator, would you take us to public comment, please?
We cannot hear you, Mark, if you're talking.
BRN moderator, would you please take us to public comment?
Mark, your audio is not working if you're speaking. I do see that you have the slide changed. So I know that Jennifer's on it. Mark, are you able to come off mute?
We'll be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for a comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Stephanie Landers would like to make a comment. 1 second, please. Stephanie, on your screen, probably behind, there you go.
On behalf of the faculty of Sacramento State School of Nursing, I object to the increase in enrollment for the Sacramento campus of Samuel Merritt University. Our objection is on grounds that the Greater Sacramento region, Region 1, lacks appropriate clinical sites as well as qualified faculty to support an additional 72 students or even the 40 students as has been amended as of this meeting. First, as has been discussed, we can attest that clinical sites in this region for pre-licensure programs are in short supply. While we appreciate Samuel Merritt considering non-traditional scheduling such as evenings and weekends, recent mapping of clinical use at the regional consortium meeting demonstrates that these clinical placements are already being used by other programs. Last year, California North State University was approved for 90 students annually, and University of Pacific was approved for an enrollment increase of 40 students. It is unclear where these 130 students will be placed in the Sacramento region, let alone the additional students requested by Samuel Merritt. Clinical partners are approving fewer and smaller sized groups of students than ever before, and in some cases, historical placements are being denied. Samuel Merritt has indicated close relationships with Bay Area clinical sites such as Sequoia Living. However, they do not have facilities in Sacramento. For example, the closest Sequoia Living facility is in Walnut Creek, 70 miles away. Second, although it's been stated this cannot be taken into formal consideration, Sacramento is not in a nursing shortage area. The California Department of Health and Human Services indicates we are above the target ratio of RNs in this region. Further, new graduates are finding it challenging to find employment, and in some cases moving out of state to find employment as a new grad. While Samuel Merritt cites the number of program applicants as demonstrating need for their proposed enrollment increase, it is well known that students apply to multiple programs. Therefore, the number of applicants is not necessarily directly correlated with the demand for student enrollment. Third, there's a lack of qualified faculty to support the increased enrollment. Samuel Merritt indicates they have funding to hire 30 new full-time faculty positions, but where will they find these people? According to AACN, more than 1,900 full-time faculty vacancies were identified in the 23-24 academic year. And a common topic at regional consortium meetings is the faculty shortage and the efforts to recruit qualified individuals coming up short. In summary, Sacramento is not in need of additional new graduate nurses, nor is there the infrastructure of clinical sites to support an enrollment increase from any school at this time. Thank you for considering this in your decision.
Thank you for your comment. Deborah Finn Romero would like to make a comment. 1 second, please.
Romero, also at Sacramento State. I do agree with my colleague Stephanie Landers and object to additional student enrollments for this program or other schools within our region. We are heavily impacted, losing clinical sites, having hours reduced, and it is a very, very competitive area, and additional students will only add to the impaction on our community. Thank you.
Thank you for your comment. Committee Chair Dominguez, there are no other public requests for comments on the WebEx. Do we have any public requests for comments there in person in your location?
Yes, it looks like we do.
Green light.
I got it, sorry. Thank you. My name is Dr. Nancy James, and I am the Dean of Nursing and Allied Health Sciences at Sierra College. I couldn't have said it better than my last two colleagues from Sacramento State. I urge you not to approve this. And I've heard everything that's been said. I've heard your discussions as well, and I appreciate that. I have been Dean of the Sierra College Nursing Program for over 12 years. In that time, the most crucial time has been the last 5 years in which I cannot get faculty to save my soul. They are going to the other programs that are paying more and coming in, and my historical placements are being taken. This is a problem because when you enroll a student, you're guaranteeing them that they will have clinical placements for 2 years. And I know you know this. And in the middle of the year, last year, my clinical site withdrew. They could not take my students, so I had to find space for 10 students in the med-surg at the very last minute. And this is an ongoing problem. Also, in my pediatric and OB rotations, the hospitals, because of nurse burnout, because of how many schools are in their hospitals, they are now decreasing our typical cohort from 10 down to 6, which means I have to find alternative sites. So while I appreciate the fact that it's being said that it will not affect the other schools, it will. It always does. And in the last 5 years, I have not signed any letters of support. Nothing personal for these other schools, but I can't do it. We're really struggling right now, and I want you to understand that. So that's super important that I share this. Thank you.
Good afternoon. My name is Julie Holt, and I'm the Director of Nursing at Sacramento City College. And I'm also not in support of this motion to increase enrollments, much to what my colleagues have already spoken about. Some of the other pieces that I would add is that our nurse burnout at the bedside with supporting all of our students to care for the public. That relationship that occurs at the bedside is crucial, right, to everybody here in the room as well as in California. The nurses are being asked 24/7, 7 days a week to take students in our large clinical facilities here in our region in the greater Sacramento. Our school has placements at five of the major hospitals here. Historical placements, we've been around for a very long time. And much to that note, the burnout is very high. So we're cautious of overburdening more of our nurses as well. Preceptor specifically is a very intense request that occurs in many programs, not all. If there's preceptorships being asked for, that's a one-on-one placement, and that is also very impacted in our region. The consortia that has been spoken about, we have done a mapping of a grid with all of our public-private ADN and BSM programs, and our grid is very impacted with all of our clinical partners being represented from even beyond just the major Sacramento area. So I'm not in support of this motion, and thank you very much.
Thank you. Go ahead, Ms. Twin.
Thank you very much for coming here, and I really value your input. It's just, this is the kind of information that would have been helpful earlier in the process. So this is the second time we've seen this item, and we're struggling. And of course, the kind of information you've just provided is so critical to our decision-making. And I'm just wondering if you had conversations or, I mean, this is the kind of information that would have been helpful earlier in the process than today, although I do thank you very much for coming today.
Sure. No, I appreciate that. And, we're in conversations with our NECs as well and letting them know when we are removed from a clinical site. So the data is being collected. We are more than happy to start attending these regularly if that will help with the point, because it doesn't just end a day. There's other schools that have actually reached out to me. I've had conversations with them about the impaction and how this is going to affect our programs. They feel it won't, and we agree to disagree. But I've been in this for so long that I've watched it happen, and it's concerning. And so if we need to come back, we will.
Thank you.
Thank you.
Thank you.
Just to add that, please come to the Education Licensing Committee. That is held virtually, so you wouldn't have to leave your work. You can multitask into that. That is where the majority of this discussion does happen. And then by the time it gets to board, either recommendations have already been made, or like these two schools that are still pending on this agenda today are recommendations that the Education Licensing Committee weren't comfortable or didn't feel like had all the information to make, and they defer it for a full board discussion. So please come to the Education Licensing Committee first, and if everything is done, then you won't have to come to board. But if there are deferred items to board, please then come to board as well.
Thank you.
Member Cormack?
It's like whipsaw back and forth. Glad I'm not keeping track of how many times I'm leaning a different direction. So I did notice that it was Sequoia Living listed as for most of these clinical placements. And I do know and I appreciate the public comment person mentioning that those are far from here. So I wonder if maybe the applicant could address, just head on, is the fact that it's difficult to find clinical placements in Sacramento the reason that you are utilizing placements for med surg and geriatric that are far?
Yeah, that is, thank you for the question. It is part of the reality of nursing education today, is that our students are traveling a little further for clinicals. We're not saying they're all going to be going there, but we have the capacity that if we needed for them to go there, we could. We also have students who live that far away from different campuses, right? Students will commute to campuses. So we always poll our students and ask them, here's 3 sites, which one is closest to your home, which one works best. I was surprised when I heard from our clinical coordination team that we have students who actually request nights or request weekends because it fits better for their life. So I think there's an assumption is made that students don't want to have these sites, but we've not found that to be true. As far as faculty, we've never had a problem hiring faculty. We have never had a problem bringing in faculty. We're very lucky with that. I think we have a great working environment. We have good pay. We have good benefits. We don't have a problem finding faculty. We also have a DNP program where we graduate several students every year, many of which, I guess it's a grow your own model, who want to stay and teach for us, and many do stay and teach for us. So we've been very blessed as far as finding enough faculty to handle the enrollment increases, as well as our long-standing clinical partnerships.
Okay, thank you for that. I guess it's not inconsistent with what we heard from other comments, which to the extent a program that pays more might be able to get faculty, and a program that is unable to pay as much for a variety of reasons would have difficulty ongoing.
Then to address Sequoia Living, just so that our public is aware, we don't have anything in our regulations or statute that require the clinicals to be done in an acute care setting. And so Sequoia Living is an assisted living memory care kind of facility. So it is what some schools may not find appropriate for all of their clinicals. However, if every nursing program throughout our state has a different has a different curriculum. They make it themselves and they make their own objectives. And our law in 1427 says that you can't have a clinical site that is approved by our board if it doesn't meet your clinical objectives. So if they write their clinical objectives in a matter that it can be obtained through this clinical site, then because we do not have a law that says you have to have acute care or whatever, they can utilize this. But with this being an assisted living, skilled nursing facility, memory care type location, it does not have PEDS or OB. And so if they are using that for psych, Jerry, and med-surg, it would be limited to the experience that are offered within that, including the psychiatric rotations would be adult Jerry focused and not necessarily pediatric or adolescent kind of focused as well. So it would only manage the clinical objectives that are specific to what can be obtained at this clinical site.
So we'll go ahead and take it for a vote. Jovita Dominguez votes yes. President Trujillo?
Trujillo votes no.
Patel? Vice President Patel?
Patel votes no.
Member Cormack? Okay.
I hate being at the beginning of the alphabet.
Oh.
Wow, I'm usually better at making decisions. Cormack, yes.
Member Granowitz?
Granowitz, no.
Member Nguyen?
Win, no.
And Member Lawler?
Lawler, no.
So that's one. So
So the motion on the table has failed. Would our board members like to make a new motion?
No, I just.
Your motion would be to deny. Yeah, you have to make a new motion.
I make a motion to deny the request.
I second. This is Vicky.
So
Do we have
we
to
will,
go out to public comment again with a new motion?
It's the same agenda item, so unless you want additional comment on this new motion, fair enough.
okay, then we will re-vote on the new motion. And Dominguez votes yes and President Trujillo
Yes, to deny.
and Vice President Patel,
Patel, yes.
Member Granowitz,
Granowitz, yes.
Member Cormack,
Cormack, yes.
and Member Nguyen,
Win, yes.
Member Lawler.
Lawler, yes.
Motion carries to fail.
May I make one last comment? And it's not in any way, of course, it wouldn't be procedurally even possible to change your minds on this. I just have a request, actually. Would that be possible?
Yes, go ahead, please.
Great. I think, and I appreciate all your comments. I don't take any of them personally. And appreciate the positive comments about our university. I might take one personally, that I'm a salesperson. I'm not a salesperson. I'm a dean, and I was chair of the ELC, and I was a member of the State Board of Nursing. So I know this procedure very well. But my request is, and one of you said this, and I can't agree with you more, is that this is going to keep coming up. And it appears what the board has done, especially with the vote that you just made, that a moratorium has been placed on any future growth in this particular region within the state. And I make a request on behalf of Samuel Merritt, but also more importantly, my colleagues that are all kind of lining up to make future requests, that there be some type of a memorandum or some type of a statement coming from the board, or I don't know if this would come from you, EO Melby, that there's a moratorium on any future growth until further notice. And I don't know what would need to change so that schools could grow in this area, but it is a labor-intensive process to go through all of the forms and documentation and preparation for these meetings to be told, we've already deferred and denied other schools, so we can't do yours either. So I'm interpreting that as my provost, who's on the call today, and others at Samuel Merritt, that there's been a moratorium placed. And if that's the case, I respect that. But I wonder if that could be publicly messaged.
I appreciate that, Stephen. Thank you. A couple things. There's several things to address right there. One is, please send me an email so we can discuss what next options are for your program. You were looking at using a clinical facility many miles away, right? So you could do an enrollment increase specifically requesting for that area if that area is not impacted. We have several colleges and universities that might have a base campus in one location and then grow at a separate location that is outside. One of them is, it was an Angwin campus that is using Adventist Health, and that's several miles away. Excuse me, from where they're located. And so it would still be managed through your Sacramento location, but your clinical sites would be in another area. So you could then grow in the area where it looks like maybe your clinical placements are. And so it wouldn't be deemed a Sacramento specific location. So please reach out to me and we'll kind of discuss options for that. In order for doing a moratorium to any area throughout the state on enrollment increases, we would have to agendize that on a board meeting, and we would have to follow any kind of legal proceedings that would need to happen around that, and then make a motion to follow through on that. So that would require a bit of work to do that, but that may be something that our board would consider. The third question that you kind of asked on there is what would need to change? And truly, that is law needs to change. We were very much in support, our board was in support of last year, a Senate bill that was put forward by Roth in order to collect data from our healthcare facilities. That data collection from healthcare facilities was supposed to go to HCI to allow us to accurately assess what our clinical placement landscape is in California. And that bill died in appropriations. And so in order to really make evidence-based decisions that can accurately reflect what the landscape is out there of clinical placements, we need to have data from our healthcare partners, and the Board of Registered Nursing does not have any jurisdiction over that. We get data from schools, and so when our school partners come here and provide us with data, and we do our annual survey that is on our website that talks about displacement and clinical placement stuff, that's the only data that we have to consider. And so absent of legislative change where we can get data from our healthcare partners and use that to really get a clear depiction of what our landscape is. We've also talked about a statewide RAND consortium that has regional focuses. That is where all of that stuff can play out. And that is not something that we have at our fingertips today. I can speak, I promise, just not eloquently right now.
I appreciate that, and I will certainly reach out and we'll see what next steps might be available. I appreciate that.
This is Vicky. Can I have a minute? I want to apologize. I shouldn't have made the crack. I just was not happy with you coming in with a proposal when you had one already ready to go. But I apologize. And I apologize to salespeople everywhere.
Well, I accept that. Thank you very much. That's very gracious of you. I really only made that second or plan B because I've witnessed many times the ELC offering that, right? So I knew it was something, as I think ELC chairperson Dominguez said, that's something they've done in the past. So that's the only reason I brought it up. So appreciate your apology, and it's accepted and very gracious of you. Thank you.
This is Reza, Board Counsel. Just a quick comment here. I recognize the motivation behind the suggestion of a moratorium, and I sincerely respect that. I think that the gentleman was trying to balance the or avoid the waste of effort that goes into these requests and having somebody chase what potentially might be a futile effort. So I fully understand where that was coming from, and I support the idea of some solution to that. The idea of a moratorium, though, and the board making a statement that it's not approving any requests in a particular area does concern me a little bit, and I don't want to take any position on it now, and of course the board's not, but just set expectations about whether we can do that, something that would be, need to look at closely. As it sits right now, I think the board is obligated to consider requests that come in, and they're reviewed on a case-by-case basis, even in impacted areas. And I don't think it's necessarily impossible in an impacted area to secure an enrollment increase, but the level of evidence and the comfort level that this board would need to approve an enrollment increase in an impacted area, knowing that there's clinical shortages and things like that, would probably need to bolster your case, knowing that, it's coming in an impacted area, in particular in anticipation of comments from other schools that might struggle based on the outcome. So I just wanted to touch on the moratorium idea. There is not a moratorium in Sacramento nor in Southern California. It certainly, I think it's fair to say, it's harder to secure an enrollment increase in those areas because of the impaction, but we don't have any kind of blanket denial of those. That said, I recognize the issue and the problem that for a school to put together a package seeking an increase in that area and them seeking to have all their bases covered, that's a lot of work, and I don't, the board shouldn't just roundly reject those, and I don't believe it does. But anyways, that was just to set expectations, I think, if there is a future discussion about something like either a moratorium or some other idea that someone may have to try to address this issue.
We will now go to 8.3.
Thank you. Agenda item 8.3 is the discussion and possible action regarding a feasibility study for a new pre-licensure program. This is Gurnick Medical Arts Baccalaureate Degree Nursing Program. This is a current program who's asking for a secondary site in San Jose, California. Information on this program can be found starting on page 132 of your packet. And Gurnick should be in the audience there. And so if I could ask you guys to come forward to the microphone, that would be helpful. Gurnick Medical Arts Baccalaureate Degree Nursing Program submitted a feasibility study for an approval of a secondary campus new program in San Jose. The San Jose campus is in Santa Clara County. Both Concord and San Jose campuses, so they have a campus in Concord as well, and San Jose campuses are in Region 3. The Concord campus BSN program is approved for a total enrollment of 112 students a year, with an enrollment of new students 3 times a year. The enrollment increase plan, and I'm going to refer you to page 136 because it is complicated, and I don't want to confuse anybody, but schools are getting very creative on how they're doing their enrollment increases. So on page 136, you'll see what they're requesting. I can read it to you. Gurnick is requesting to enroll 28 LVN to BSN advanced placement students and 28 generic students in June of 25, and then 28 generic BSN students in September of 25 for an enrollment pattern, annual enrollment pattern of 84 students for the year. And then you'll see their next request is for starting in 2026. They would like the request to enroll 3 times a year with 28 LVN to BSN advanced placement and 28 generic every January. And then each June and September, enroll 28 generic BSN students. In 2026 on, the total enrollment would be 112 students every year. We do have their growth pattern on page 135, which is for the region. And the program is here in front of you, should you have any questions. Thank you.
So one thing to consider in this one here is that there was other schools that came forward with this request for this region. And those were things that were voted on already and passed.
Board members, do you have any questions or should we let the school?
Let's hear what the school has to say.
Thank you.
Sam, there you are.
Thank you, Dr. McCarthy. Thank you, Ms.
Thank
Dominguez.
you.
My name is Samantha Mendoza Sanchez. I'm the program director and also Dean of Nursing. With me is Dr. Larissa Revzina, Chief Academic Officer, and our legal counsel, Ms. Diana Lucci. Thank you for hearing us out and also allowing us to come back here for the full board. We have been in the, have RN programs in the Fresno campus for years now. We've had our visit. We had no findings except for at the beginning, which was 2 years ago in 2023. But we got our 5-year continuing approval. And the last visit in Concord, we had no violations as well. That was for our BSN program, which was last year. Thank you, and I'm open for any questions.
So real quick, as board members are considering this, Samuel Merritt was one of the programs that were approved in this region. If you can go back to page 6, it does say that Samuel Merritt for their Oakland campus did have an enrollment increase of 48 students, of 72 students annually for that campus. And then the other one, I believe, was Unitech. And so Unitech, let me find it here for you guys real quick. Unitech in that area, the increase was 40 students annually. So those were the 2 schools that came forward asking for additional students, and those were the motions that were accepted today of increase to Samuel Merritt and an increase to Unitech in that same area that are existing schools that grew, and this is a new school asking to come into that area, or a existing school, but coming into that area new.
LVN to BSN, correct?
Yes, LVN to BSN and generic.
So the generic ones are not LVN to BSN. So they have 2 asks. The ones that are LVN to BSN, those are students that typically do not utilize a pediatric placement or an OB placement because they get credit for their LVN experience with that. And as you guys are very much aware, OB, peds, and psych are our most impacted areas. And the generic placement, though, does have a requirement to meet all 5 of the content areas: med-surg, OB, peds, psych, mental health, and Jerry.
And Ms. Melby, if I can just add, we have 8 hospitals, 10 OB, and 7 peds. Because we know in the San Jose area, the only BSN over there is San Jose State. The rest are associates. I understand that Unitech is from Fremont, but that's another county, though within the 50-mile region, and as well as Samuel Merritt as well. And also, I did talk to Unitech, and they are open to collaborations, as we've always done in years, with our East Bay in Concord facility that we have in our branch over there. So we do have, and if you look at our list of clinical sites, we went all the way, not just in hospitals, as Loretta Melby, our executive officer, pointed out earlier, there's no regulation that states that it has to be acute care hospitals. So we made sure, I had 2 people that, one is making sure for clinical acquisitions for hospitals. The other is going out there in underserved areas that will cater to OB patients and pediatrics. So if you look at, there are, in the list of OB and pediatric, we do have, and it's 10 OB and 7 pediatrics. Thank you.
Thank you for the information. Vice President Patel has comment.
Thank you for your presentation. I'm just curious, it looks like a pretty substantial increase. Obviously, that's why you're here. But if you can talk to us about your faculty, and it looks like a pretty big load on your faculty. Are you increasing faculty, or are they absorbing all these students all at once?
They will it will be another set of faculty in the San Jose. So we do have a large campus in San Jose campus. 20 years ago, we've had our first campus in San Mateo, which has an LVN VN program, and we moved to San Mateo in 2023. So we have our VN program over there, and it will be a separate faculty that will be allocated, knowing that it's that the driving time in East Bay. So we make sure that it's separate assistant directors, separate faculty as well. And so far, no problems with our full-time and our part-time, because we also have an MSN program. So some of our graduates from BSN many years ago came back, and I've hired them, and they're in the MSN program that we do, for scholarship grant for our previous grads of the BSN. So they're teaching in our Concord East Bay location. Thank you.
And then for clarification, I know she said that there's only one other BSN program in that area. For licensing requirements here, they're all the same. And so ADN, BSN, entry-level masters, it's all the same clinical requirements, all the same requirements for that for licensure. So it does not differentiate for degree attainment.
Member Nguyen?
Thank you very much. Thanks for sitting here all day. I know how hard it is. So in the last 6 years, we have made decisions which have allowed the growth of 577 students just in that region. So, I mean, the question, of course, that we face in every one of these decisions is, where's the ceiling? When do we hit that point where we're not serving our students well? And I guess, Dr. McCarthy, I wonder if I think we've reached it in Sacramento, and that was kind of our unease on the last agenda item. Are we approaching it in Region 3 as well? I mean, this is a huge increase in an area. If it is impacted, I don't know how we vote for this, but if you think there's room and there are clinical placements, then maybe it's a different conversation.
Well,
it's hard for us to make that decision.
Well,
it
is, and I don't have any magic information. We have the data that we provide for you for each region. But just from my personal experience sitting as the liaison for the past 5 years, I personally haven't heard a lot about the San Jose area. That's just my own personal reflection about when we talk about areas as opposed to regions. I haven't heard a lot about San Jose. I've heard about, the Bay Area. We've talked about, all different areas but the best that we have is the data that we give you of what's been done in the past. I think we're at 6 years now. We're looking back.
No, I'm right there with Dr. Mary Ann McCarthy. So what we tend to start see is we start to see growth in these areas. A lot of schools start to come in, it booms, and then we hit these caps, which is kind of what's occurring. And so we've seen that in San Diego. We've seen that in Riverside now area, Ontario. We've seen it in LA. We're now seeing it in kind of the Sacramento area. So as it stands, we're not getting a lot of pushback in the San Jose area, but I'm sure as we continue to grow, that's when we'll start getting those impact statements. And so, but as of this point, we don't have a lot coming from that area. We do, just a reminder, this was brought forward in our education licensing materials. We have a table at the very beginning that talks about faculty impaction and clinical impaction. And when we do hear from our nursing program directors, we do put that on top right there.
Mm-hmm. Yes.
So I will read the motion and then you can move. Okay. So is my understanding there's no alteration to the numbers? We're going forward with exactly what they requested? Okay. So it says, accept the feasibility study for an alternate campus in San Jose for Gurnick Medical Arts Baccalaureate Degree Nursing Program with a projected enrollment pattern of, and it says that they are requesting the start date of June 2025. Within 2025, they plan in June to enroll 56 students. That is 28 generic and 28 advanced placement. Those advanced placement are your LVN to RN. And in September, they want to enroll 28 students for a total of 84 new baccalaureate degree students in this year. For 2026 and going forward, they want to do a every January enrollment of 56 students. That is 28 generic and 28 LVN to RN step-ups. And then in May and September, just do the 28th generic students. And that would be a total annual enrollment of 112 students per year. On that side note, just for everybody to be aware, new campus location is pending completion of the requirements set forth in 16 CCR 14-121 application for approval, including board acceptance of a self-study demonstrating that it meets the requirements of section 1424 through 1432 and sections 2786.A and B of the Business Professions Code. Once you so move in second, I'll explain that a little bit more.
So moved.
Dominguez, seconds.
And so just a reminder, this is an acceptance of a feasibility study saying our board does agree that this is an area that you guys can grow into. What is pending is you guys will have to complete a self-study. That self-study typically takes about 6 months. So it is a very generous thought that you guys will enroll in June. I don't think that that will happen, honestly, because you would have to be in our April education licensing and our May board. And that would mean that that self-study would have to be completed and into our NECs now. And I don't know that that is.
Yeah,
is
that's not going to be possible.
Yeah. So, although we are voting that this is something we agree that this is done, you still have to do that self-study. An accurate estimate for the self-study would be this fall to get it approved by our board, which means you guys would probably start enrolling in the beginning of the next year. So just to set expectations for that, because it is a 6-month review for feasibility at minimum and a 6 months review for self-study at minimum. So just so you guys are fully aware of that. And we can go out to
Member
public.
Cormack has a question.
Thank you, Chair Dominguez. This is a question for the applicant. I'm a little perplexed by the variability in your NCLEX pass rates. So quite recently, the first given is 70, the next is essentially 87.8, then down to 78.6, and then apparently up to 92.8. It's very rare to see this level of variability. So would you like to just tell us a little bit about the
Thank you for the question, Ms. Cormack. Yeah, we did have change in our system in terms of what we used. It was HESI before, and then we are using ATI. We're in complete partnership, and we really noticed working with our NEC, Ms. Doherty, really extensively with the new ATI package that we are using.
I'm
The
sorry,
pass
I
rate-
don't know what ATI is.
Oh, it's a system of resources for students, like for NCLEX review, CMS, like content mastery series in different areas of med-surg, Jerry, OB, pediatric. So our, for the last one, I know you noted that it is 78.57. Our current one for our 2 quarters report is 93.33. And the last visit that happened last year, we did have our 5-year continuing approval with no violation in that particular. But right now, I'm happy to also inform you that we just got our quarter report, and between quarter 1 and quarter 2, it's a total of 93.33% at this time. Thank you for the
Nice to
question.
hear. It's sort of like an additional help to give the student an idea of where they stand. Is that correct?
Yes.
It
It's
gives
a-
them an idea where they stand every semester.
It's an NCLEX test prep.
Yeah,
And so.
okay,
like
now
practice,
you're
that's what that
speaking
is.
regular
Yeah.
language.
Yes,
Yeah,
it's like,
it's
thank
an
you,
NCLEX test prep. And
Practice
so there are
exam.
various companies that
Kaplan,
offer
yeah.
these. It's just like Kaplan, but it is
For nurses.
API.
Okay, great.
Yes.
Yeah.
And then, because I always do this, I did pull up the clinical spaces lost and students impacted in the Bay Area. I'll just say I live in the Bay Area. Bay Area is very big. I mean, we could all have these conversations. We'll just set that aside. But the number of students impacted is, half what it was in 2021. It's still a significant number, but in comparison to the prior one where we had the trajectory going up, in this instance, we have the trajectory going down. So those are the, the main pieces of data we have, which are not anecdotal, that, we can use. So thank you for the explanation about the NCLEX, and hopefully it stops being variable and just stays at that number, starting with the 9. That's where we're happy to see that.
And that 2021 impact was felt across the state because of COVID. And so
Right, yeah.
that should even out.
And I do want to say, just like Member Nguyen, I really love it when you guys are here in person. Thank you. Should we take it to, BRN moderator, would you take us to public comment, please?
We'll be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board Member Dominguez, there are no public requests for comments on the WebEx. Do we have any public requests for comments in person in your location?
I believe we do not.
Thank you. Would you like me to close this window?
Yes, please. And we will take it to a vote. Dominguez votes yes. Vice President Trujillo?
Trujillo votes yes.
And President Trujillo, Vice President Patel?
Patel, yes.
And then Member Granowitz?
Granowitz, yes.
Member Nguyen?
Nguyen, yes.
Member Lawler?
Lawler, yes.
And Member Cormack?
Cormack, yes.
It's passed. Thank you.
Jovita. So at this point, I'm going to move to 8.5 and 8.4 and kind of manage through that really quickly.
Yes.
But I want to give pause in a moment just to let everybody know that we're going to reopen 6.1 quickly just to do an amendment to the motion. So as I go over 8.4 and 8.5, we will be reopening 6.1 to talk about and just a slight addition to that motion for the regulatory update. So 8.4 and 8.5, they're both information only. I'm going to point you to them in the meeting materials, and we'll open up to public comment for one public comment for both of these because they are information only. So on a page 143, you will see the information only on the NCLEX update. There is nothing that is surprising to me. We still come in #1 in the nation. And 8.5 is our licensing update. There are also no surprises on there, but if you guys do have questions, I am here to answer any of those. And the licensing update starts on page 148 and ends on page 150. Are there any questions from our board members? Yes.
Quick one, which is on page 143. I think this may be the first time I've seen our quarterly pass rate be below 90 for California.
Yeah, so the reason that we are seeing some fluctuations in pass rates are kind of multi-layered here. And the one is the shift to the next gen NCLEX. There is fully an expectation that when you change the way that you test, that there is a kind of leading in time frame, and they do expect about a 10% decrease across the board when we see that next gen. And so next gen has now been in place for just over a year. What we're also looking at and experiencing is the effects from the COVID education, as well as the effects and changes to our decrease in direct patient care requirements and some of those changes. And so over the years here, when we went into COVID, we were requiring 864 hours for clinical and 75% of that had to be in direct patient care. There were emergency kind of procedures put into place. AB 2288 passed. And what that did for clinical preparation is decrease that to 50% in med-surg and GERI and only 25% direct patient care for OB, peds, and psych.
That was something that was adopted and that continued on for about 3 years. Then we went into our sunset that law passed 2 years ago now. And in that sunset, although it continued those provisions so that they are there for any future issue, they also address the concurrency. And so previously you had to have theory and clinical concurrent. Now you can have theory and then whatever clinical practice you can't complete in that semester and you have clinical impaction, that clinical hours are now rolled over to the next semester to be picked up. Additionally to that, because we had no standard curriculum throughout the state, we just required 18 units of clinicals to be separated and divided to those 5 nursing areas. There was a law change where we dropped it down to 500 in direct patient care. That 500 in direct patient care through feedback from the public went to 30 minimum hours in psych, 30 in geri, 30 in peds, 30 in med surg, and 30 in OB. And so if you do that 5 times 30 is 150 hours. There's still 350 hours that have to be accounted for, and that typically goes to your med surg and geri. So we are very heavily reliant upon simulation and other experiences. There is a request coming forward to the NEWAC committee. There's a letter asked that they're even asking us, and I say they as the greater academic partners are asking us to drop that requirement from 500 hours down to 250. They want half. They want a 1-to-1. They are quoting an NCSBN study that says that simulation is the same as in-person clinicals when it's given on a 1-to-1, 50% kind of basis. What that study clearly talks about is that it has a 300-hour requirement. And then what it also states is that recommendation of that 50% on a 1-to-1 comes from people that have completed the simulation study. An additional paragraph in there that they're not quoting is that the people that dropped out of the study were minorities and male. And so they seem to fail more and drop out of the study more. And so what they only considered was that simulation study based on completion of the study. And so it is not accurate. And that's why our board has in the past always opposed going to a 50% sim because of the diverse nursing population that we have in California. And because they do believe that direct patient care is really where you're learning a lot of that critical skill attainment. And so we are now seeing some of that come forward in our first-time test takers with various decreasing of our standards. Again, we're still above standard mostly throughout the state, throughout the nation. But as we make amendments to our clinical requirements and our educational requirements, we do fully expect to see some changes to our NCLEX pass rates.
So I think there's something we should keep an eye on then, because that, it's a downward trajectory and that's not great for the public. It's certainly not great for the students probably.
It's more effective with the students. So once you pass NCLEX, which could be taken repeatedly on and on, you are deemed a safe entry-level practitioner.
Okay.
So that is not affecting the general public at that
But
point
to the
because you
extent that
passed it.
people don't get into the field.
But correct. And so there was a statement made by a board member previously, which I thought was very poignant, that said, there is not another item in your life that you will pay for in advance of receiving it in high amounts of money. And so what that comes down to is if I'm going to buy a house or if I'm going to buy a car, I have something I legitimately expect at the other side. So when we're looking at consumer protection, the reason that we regulate schools is for the student. That is why we regulate schools, because they are the protector, they're the consumer that we are protecting. And that student that pays $150,000 tuition on day one expects to get a degree 2 or 4 years later. And with that degree, they expect to be able to pass NCLEX. And that is the only investment that you will make without a true guarantee that you will have a degree or able to pass NCLEX. And so when students start to have an NCLEX pass rate dip and experience that,
not only do they have a degree that is now not usable until they pass that NCLEX, but there is a monetary commitment there as well. At 6 months, your student loans start to go into repayment. You cannot retest. So they tell you to test the first time within 3 months, right? And then if you fail, you can't retest for another 3 months. And that is a requirement that they have to meet. That is the National Council of State Boards of Nursing requirement. They reapply to us. So they reapply. So on the initial one, they apply and pay for us at our board, and then they apply Pearson VUE to take the test. And then they apply back to us and pay, and then they reply back to, they pay more to Pearson VUE. So there's more out of pocket at that point, and that cycle continues until they pass their NCLEX. So at that point, if they fail first time and they take that within the first 3 months and they wait another 3 months to be able to test again, they're already at their 6-month student loan repayment and they don't have a job because they have a degree without passing NCLEX. And that's really where that consumer protection comes in, where we really focus it and why we look at these schools and why we're really narrowing in on these kind of metrics that we can wrap our hands around and figure out what's going on. We do not have authority over what they charge. We do have authority over pass rates, and that is something we do need to pursue regulations in the future to really kind of put more guardrails in of what NCSBN has found in studies that determine a safe, functioning, healthy school, to ensure that we grow in schools that can support that. Okay, so at that point, Marissa, you want to come back up and do, we need to do open to public comment, sorry. So you come up while we're opening the public comment. So we will open up board moderator public comment for agenda items 8.4 and 8.5, please.
We'll be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in "I would like to make a comment." Okay, I brain cramped. I don't know who's running this part. So, Board EO Melby, there are no public requests for comments on the WebEx. Do we have any in-person requests for comments there in your location?
We have no in-person requests for comments in my location, and thank you, Mark. I will take over and close this section out. Thank you. You can close public comment.
Okay, thank you.
And then this is part of the admin, which is Dolores and myself that manage through that. So we will reopen 5.5. Marissa, we'll have you make the amendment to the amendment to the motion.
Thank you. And apologies for bringing this back. But there was a public comment that highlighted a area in the regulations that inadvertently added a barrier that we don't wanted to have in there. And so we wanted to bring it forward rather than wait till the next meeting. So it is on, I believe, agenda item 6. Sorry, yeah.
I said 5.5. I meant 6.1. Okay. Mark, I'm right with you today.
It's agenda item 6.1, and it is page 11 of the materials. It is the proposed amendments to Title 16 CCR 1482.4C. So that's the section around the 104 MPs. The original language had talked about maintenance of an active national certification that matches the area in which they're seeking certification as a 104. And just for efforts of clarity, I originally had put in a category listed in 1481A. And so that cross-references with our existing 6 categories in the regulations, just to make it super clear and just reinforce we can only do that on a population-focused level rather than a subspecialty. However, the commenter made a good point about legacy certifications, which are now eligible. And so we don't want to accidentally not allow those. So we wanted to propose including language that would essentially say maintenance of an active national certification in the category listed in 1481A or a population-focused category that was discontinued before January 1, 2017. And that phrase lines up with statute, with a provision that was added in 1451, essentially saying that legacy and retired certifications can also be eligible. So we just wanted to include that caveat in there, that it's not just listed to the current ones, but also previous ones.
So I will help with the motion here. So the motion on 6.1 stands as is, and it was a first and a second, and we went out to public comment and everybody voted to pass that. The specific section that we are asking to add is for you guys to make a motion to add the language or a population-focused category that was discontinued before January 1, 2017 under that C, right? But what's the beginning part of that?
Yes, it is Title 16, Section, I have it up. Section 1482.4C.
Okay, so section 1482.4C, adding in there after listed in section 1481A or a population-focused category that was discontinued before January 1, 2017. And all you guys would have to do at this point is say so moved.
So moved.
So moved.
We'll get a second. Okay, so Patel is seconding. And then we will go out to an additional public comment just about the addition of this specific language real quick. Board moderator.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment."
This is Reza. While we wait, I'm just going to ensure that everyone's totally clear. So when we earlier discussed item 6.1, the board approved a motion that approved the proposed regulatory text. What's currently happening is based on the realization that Marissa just explained, item 6.1 has been reopened with some additional proposed language that Marissa or Lori just mentioned. I wrote down, quote, or a population-focused category that was discontinued before January 1, 2017, end quote, to be added to section 1482.4 subdivision C of California Code of Regulations, Title 16. The only reason I bring that I'm chiming in is for ensure that process-wise, procedurally, folks who are interested in this item have an opportunity to comment. We opened up for public comment earlier when we discussed 6.1. We're doing it again now, just in case there is anyone who dropped off this meeting in between the two discussions. Please be aware that there will be future opportunities for comment on this regulation package as it moves through the process. There will be formal public comment opportunities. In addition, at any future board meeting, even if this item is not on the agenda, you can still make a comment on it if you happen to have not gotten the opportunity to address what's currently being discussed at this moment. So just want to make it abundantly clear as far as what's going on and opportunities to comment on this piece that's proposed to be added. Thank you.
Thank you, Reza. Board moderator, do we have any public comment?
No, ma'am, we do not. Do we have any
Thank you.
requests there?
And we do not have a public comment in Sacramento as well, so you can close that public comment.
Thank you.
And then board president, if you want to do a roll call vote.
Sure. Dolores Trujillo votes yes. Vice President Nilu Patel.
Patel, yes.
Board Member Jovita Dominguez.
Dominguez, yes.
Board Member Patricia Nguyen.
Win, yes.
Board Member David Lawler.
Lawler, yes.
Board Member Vicky Granowitz.
Granowitz, yes.
And Board Member Allison Cormack.
Cormac, yes.
Thank you.
Thank you, guys. So just for everybody that is joining on the WebEx as well as any other kind of streaming platform out there, we are at the end of day one's open session. What will occur now is we will go into closed session. So we will close out of our WebEx and this will no longer be there. The kind of just some housekeeping stuff for tomorrow. Tomorrow, what we open up with is any items that were not addressed on the agenda from today. What that means is we will open up in public open session tomorrow, and then we will go back into closed session to finish any of the items that are not finished this evening prior to 5 o'clock. At that point, when we open up tomorrow, we'll have a better idea. So when we do open up at 9 o'clock in the morning, we can project that it may be 1 hour or 2 hour before we go into the next agenda item, which will be covering any legislative items as part of this year's legislative session. And then after that, we will then move into EIIC section of our board for tomorrow. So the way that it looks now is we're closing out of open session, going into closed session. Tomorrow we will open and go immediately into closed session to finish anything. And then once that closed session is completed tomorrow morning, we will do legislation followed by Enforcement Intervention Investigations Committee to our board. Thank you.